Hi everyone, I hope you're having a great day. Welcome to Business Laws and Ethics Marathon for all CMA students. What we'll be doing initially is we'll be taking care of corporate law. I'm diving directly into the subject which consists of 40% of your syllabus, okay, which has a various concepts which will be covered. So what we'll be covering here is from your chapter number, from your corporate law, we'll be covering sections 3 to section number 122, and then we have to cover section number 134, section 143, and directors chapter, a little bit of directors chapter, responsibility, appointment, remuneration, powers, etc. Right? So this is a syllabus of your corporate law which consists of 40% of your syllabus. Okay, so let's directly jump into the marathon session of CMA Business Laws and Ethics. Right? Before I begin, just a small disclaimer. This marathon that we are going to do, or that I am going to do, is solely for revision purpose. So if you have questions saying, sir, with this marathon can I score exemption, the answer is no. Unfortunately no. With the marathon you cannot score exemption. Marathon is like a revision, so you need to at least have 1 or 2 rounds of your study, the entire study, and then only you watch marathon. It will be very, very helpful. Right? This is a quick revision of what we are going in every section, what they are trying to tell, and this is a quick revision of it. Right? I hope you all know that your exam pattern is 100 marks, and this 100 marks is divided into MCQs and descriptives. Right? MCQs and descriptive. MCQs you have 30 marks, which is 15 questions of 2 marks each. And then you have descriptive of 70 marks, out of which you have technically you have to write 5 questions of 14 marks each, but 2 additional questions are given, so totally you have 7 questions to answer, but again not technically answer 7, you get 2 as optional, so you have to write 5 questions, and in these 2 questions generally one question which is of 14 marks will be your case study. This 14 is divided into 7 and 7, right? Case study. So again, case study is an optional, so direct theory question is predominantly asked in the exam. So rather than analytics as to what can be done here, directly they'll ask procedure as to for example, list out the disqualifications of a director. What is the incorporation procedure? So directly let's jump into the procedure part of it and not too much of analytical part of it. Section number 3 talks about formation of a company. What is the formation of a company? Whenever we want to form a company, minimum number of members is what we require. Correct? Therefore, if you are a public company, minimum number of members required is 7. Minimum is 7. Right? If you are a private company, minimum is 2, and if you are an OPC, obviously minimum is 1, because 1 person company, minimum is 1. Now maximum, if you are a public company, it is unlimited. If you are a private company, maximum 200, and if you are a 1 person company, maximum is 1. But in case of 1 person company, you need to appoint someone called as nominee, right, in your MOA. Generally in memorandum of association, where we have a lot of clauses like name, object, association, situation, capital, liability, but when it comes to OPC, we have something called as nominee clause. What clause will have? Nominee clause. Right? Now what is this nominee clause, sir? In this clause, you will be naming that 1 person instead of the member, instead of, in the sense, after the member's death, or if member is incapable of running the business due to unsound mind or any other disqualification, this nominee will take over and run the company. Right? So you have to mention him in the clause of, in MOA, nominee clause. You have to take his written consent. You cannot force anyone's consent. So you have to take what? Written consent. Right? At any time, if you want, you member can change the nominee. If he wants to withdraw at any point of time, he can also withdraw. No issues at all. Intimate such changes to company and ROC. Intimate in the sense, go and inform the company as well as ROC. Sir, why we have to inform the company, sir? 1 person company, boss company has a separate legal entity. We have seen that. Yes, we have known it right from our commerce childhood. Right? Company has a separate legal entity. Next, let's jump directly into section number 3A, which talks about members severally liable in certain cases. Whenever we talk about members severally liable in certain cases, not in all cases, since we know that company is a limited liability personality, in some cases members are severally liable. In what cases, sir? Generally, public company 7, private company 2. If you fall below 7 or below 2, let's say one member died, one member left, one member surrendered, right? In those cases, you fall below the statutory limit of 7 or 2. Now in that case, you are actually running the company illegally. But because of section number 3A, you get a shield for 6 months. You get what? A shield for 6 months. So for this next 6 months, even though you are running the company below the specified number, designated number of 7 or 2, law says 6 months you can run this legally. Within 6 months, come back to original number. If you still don't come back to original number within 6 months, after 6 months, whatever debts you have contracted, for that company will not be liable. For that, you alone will be liable. And that is section number 3A. Right? Now, sir, let's talk about types of company. If you are a private company, what is the definition of private company, sir? Section 2 clause 68 clearly says private company means a company which minimum paid up capital is as may be prescribed, not yet told, by which its AOA, 3 points you have to remember: restrict, limit and prohibits. What to remember? Restrict, limit and prohibit. Restrict what? Transfer rights. You cannot transfer your share to anyone. I am not saying prohibition, it is a restriction. What is the difference between restriction and prohibition? Restriction you can do after following certain conditions. Prohibition, come what may, you cannot do that. Clear? So in this case, following restrictions are generally incorporated. Meaning what, sir? Private companies like our house, sir. Will you let anyone come into your house without your permission? No. Therefore, if anyone wants to be the member of private company, generally in AOA they'll put some restrictions saying you cannot sell the shares to anyone. What if they take over the company and start taking bad decisions? Right? So for that purpose they're telling you cannot take over the company. You cannot give the shares to anyone and everyone. We will tell you. We will tell you to whom to give. You give only to them, right? So such a certain limitations they will put in the AOA. So we have the power to restrict the rights to transfer, limit the number of members to 200. Max to max, how much you can have? 200. Max to max, how much you can have? 200. Now in this 200, there are certain calculations. If you are a joint shareholding, we will consider you as a single member. Current employees are excluded. Previous employees are excluded. Right? So these are the adjustment with respect to limitation. Third one, prohibits any invitation to the public to subscribe for any securities of the company. Right? Prohibition, sir, not at all allowed, not a single rupee, whether shares, debentures, bonds, any type of instruments through which you are raising money, raise it from your members, not raise it from general public. Next is holding and subsidiary company. Holding company means what? To understand holding company, let's understand subsidiary company. What is subsidiary company? Subsidiary company, there are two ways to control a particular company. One is the controlling the composition of board of directors, and second one, controlling more than 1/2 of total voting power. 1/2 of total voting power. Do not say share capital here. Previously it was share capital or paid up capital. Now it is voting power. Be very careful in MCQs. They can test you here. Right? Sir, can a subsidiary company hold shares in holding company? The answer is no. Section 19 says you cannot hold shares in holding company, and even holding company cannot allot shares to subsidiary company. But in 3 cases we can allow. Number 1, where you are holding the shares as a legal representative of deceased member of holding company. Number 2, as a trustee. Number 3, subsidiary company is a shareholder even before it became a subsidiary company. Let's say for example 2010 A Limited was incorporated. 2011 B Limited was incorporated. B Limited held shares in A Limited 1%. Okay. Now in 2016 A Limited purchased 60% of B Limited. Sir, what about this 1%? That 1% is valid because this 1% was purchased even before it became a subsidiary. So before subsidiary relationship was established, whatever shareholding is there, that will still be valid. But voting rights will not be available. Voting rights will be available only in 2 cases. That is your legal representative and as a trustee. Clear? Legal representative and as a trustee. Next is one person company. For one person company, as usual, minimum one, maximum one, nominee one. But the main point to be noted here is only a natural person who is an Indian citizen, whether you are a resident in India or not. Whether you are a resident or not, doesn't matter. If you are a natural person, if you are an Indian citizen, we will allow you to have one person company. But still, sir, if you are a resident, what do we understand by resident? Resident means that person who stays for not less than 120 days in the immediately preceding financial year. That means minimum to minimum 120 days you have to stay. If you are staying for more than 100 days, it is still allowed, right? You shall be eligible to incorporate an OPC, as well as you shall be a nominee in the sole member of OPC. So as a nominee or as a member, in both cases, obviously this rule will be applicable. Resident rule will be applicable for you. A natural person, sir, can I become OPC in one member in one OPC, nominee in another OPC? The answer is completely yes. But the moment you become nominee in another OPC, you have to choose between old OPC and new OPC within 182 days. You can't have both. Clear? Next. No minor shall become a member or nominee in OPC, because we all know how good the minor is. In Indian Partnership Act, if you know, minor, or even in Indian Contract Act, minor is one of the beautiful things that can happen for anyone, right? So minor is not allowed, sir. Please, I do not want a beautiful thing to happen in the company. So minor, we will not be allowing you to become a member or nominee. You cannot carry out non-banking financial investment activity. You cannot have a Section 8 company as OPC. Right? You cannot convert also, you can't incorporate also, right? Sir, can I convert myself into any other company? Yes, without any limitation you can convert. But if a private company is converting into OPC, then obviously you are degrading yourself. Therefore, you need to pass something called as special resolution in general meeting, and also you need to take no objection from members and creditors since their money is involved. Clear? Since their money is involved, you need to take their permission. Right? Then, what about small company, sir? Very easy. Small company, if the paid up capital is maximum, it's not 4 lakh rupees, it is 4 crore rupees. If it is maximum 4 crore, yes, and your turnover should be maximum 40 crore. Very important MCQ. Okay? Right? 4 crore and 40 crore. Right? Provided this 4 crore 40 crore criteria is not applicable if you are a holding and subsidiary, right? Section 8 company or any special company. Sir, what is foreign company? Very easy. Again, foreign company is nothing but born outside India, incorporated outside India, but has a place of business in India. Doing business in India with physical, online, no problem, sir. Clear? Direct, indirect, no problem, through an agent, physically or through electronic mode, or conduct any business activity in any other manner. In any mode you conduct business activity, we will call you as a foreign company, provided primary condition is you should be born outside India. Right? Okay, sir. Now, what is government company? Very easy. Government company is nothing but where government is holding more than 51% of the share capital. 51% of the share capital. Don't get confused. It is not 50. It is 51% of share capital. Any company not less than 51% of paid up capital is held by the central government, state government, or state governments. Multiple state governments coming together. Partly by central, partly by one or more state, and includes a company which is a subsidiary company of a government company. All put together, if they are holding more than 51%, we call it as a government company. But 51% of what? Again, paid up share capital. But if the government company has issued shares with the differential rights, which you will see later, right? Differential voting rights, if they have given, then this paid up capital shall be read as total voting power. Total voting power. Next is dormant company. What is dormant company? Company which is formed and registered under this act for a future project. Now I want a company, but project is not being held now, it is in future. Or to hold an asset or intellectual property. I want to purchase land. I can purchase in a company's name and keep it, but for future purposes, right? I want to develop a patent in a company's name and keep it, but for future purposes. And no significant accounting transaction has happened. Such company is called as dormant company. Clear? What is significant accounting transaction? Any transaction apart from these four: payment of fees to the registrar, payment of fees to fulfill the statutory requirement, Clear? Issuing shares to fulfill the requirements of that. For example, a public company, minimum 7 members should be there. So you have to give 7 shares at least. So giving that 7 shares does not be considered a significant accounting transaction. Maintenance of office and records, rent, electricity, admin expense, whatever you are giving is not to be considered a significant accounting transaction. Such company can be called as what? Dormant company. Apart from that, if there is an inactive company, they may also make an application to ROC and get the status of dormant company. Now the question is, what is an inactive company? Any company which is not carrying on business or operation or not made any significant accounting transaction in the last 2 financial year or not filed FS and AR in the last 2 financial year, we will hold you liable. Clear? Liable in the sense what? We will call you as an inactive company, and this company can go and ask for dormant status. What is an inactive company? Business not done, operations not done, filing not done, right? In these cases, on significant accounting transaction not done for the last 2 years, if you have not done any of these, we will call you inactive company, and automatically, if you want, not automatically, sorry, if you want, you can go and apply for dormant status, right? Next, what is listed company? Listed company is nothing but any securities, if it is listed on any recognized stock exchanges, will be called as a listed company. Now in this case, there are certain things which where even though you are listed, we will call you unlisted. Which are those company? Public company whose equity shares are not listed, but non-convertible debt securities issued on private placement basis is allowed. Even though you list your non-convertible debt securities private placement in private placement mode, we will not call you listed company. Clear? Private companies who have listed their non-convertible debt securities again on private placement basis. One of the best things that have been happened for private company. If you want, you can list your non-convertible debt securities, no problem. Public companies whose listing is not done in India, outside India, foreign stock exchanges, in foreign stock exchanges your shares are listed, no problem at all, sir. If it is listed in foreign stock exchanges also, we will call you unlisted company. But if you are listed in India and foreign, then we will have to call you listed companies. Clear? Next, Section 8 company which talks about formation of charitable objects. Formation of companies for what objects? Charitable objects. Here the objective is not to make profit. Here the objective is to do society service, social service. Clear? So for them, Section 8 company is there. You can form a Section 8 company, Reliance Foundation, right? Section 8 company. You can form a Section 8 company, right? Who will give you the license? CG will give you the license. Who will take the license? CG will take the license. Clear? Now, if in case if you don't match with the object, you do something wrong, then CG will tell boss, see, I gave you license to do good, you are not doing good, so I will take that license back. Clear? You cannot alter your MOA or AOA with previous approval of central government, which is currently a regional director, right? If you want, you can convert yourself into any other kind of company, no one is stopping you, right? Now, in this case, sir, where a license is revoked, CG may, if it is essentially in the public interest, they can ask for winding up, they can ask for you to get amalgamated with another company which is registered under this section. So Section 8 company should get amalgamated with another Section 8 company only. They cannot get amalgamated with another profit making company. Clear? Okay. Now, with respect to things, I am doing a quick revision of other things, right? If you have your module, there will be some additional points in your module like conversion of Section 8 company to another company. Please go through that once, right? Section number 4, which talks about memorandum of association. Here we'll have name clause, object clause, situation clause, liability clause, capital clause. In case of OPC, we'll have nominee clause. Now, memorandum is like a charter, like a constitution of the company. This sets what the company is with outsiders. Clear? If outsiders want to know what the company is doing, they should read MOA and enter into a contract. Once MOA is filed, MOA, AOA, once it is filed, it will be called as a public document. Name clause, name should end with private or public, correct? Then we have Rule 8, 8A and 8B. I have given in the book Rule 8A, 8 and 8B. Rule 8 talks about if the name or the words in the name resembles too nearly to the existing company's name, they will not approve your name. You have to give a new, unique name which matches with your business. Clear? Then Rule 8A talks about undesirable in the opinion of ROC, and Rule 8B talks about certain phrases which if you use, you have to take central government's permission, but you have to take central government permission before you use the word, not after you use the word. Clear? There are certain words, it's there on the screen, look at it. These words if you use in the company's name, you need to take prior permission and then go for it. Reservation of name. Sir, for an existing company, name will be reserved for 60 days, and for new company, name will be reserved for primary 20 days with normal fees. If you still want extension, they will give you 20 more days with 1000 rupees fees. If you still want more extension, they will give another 20 days with the 2000 rupees fees you have to give. But if first only you want 40 days, you can pay 3000 and then go ahead. Okay, right? Then after that, sir, object clause. Here we need to understand doctrine of ultra vires, doctrine of constructive notice and indoor management, right? What is doctrine of ultra vires? Ultra vires is very simple. It means beyond the power. Ultra vires is what? Beyond the power. So we have director, we have company, we have companies act. Clear? Now, sir, if the transaction entered into by the company is within the powers of directors, we call it intra vires. If it is going beyond the directors, it's called ultra vires, which is primarily void. Therefore, company will not pay any amount under that. Director is personally liable. Clear? Whereas in case of it is beyond the power of company, but within the power of beyond the power of directors, within the power of company, we already told void. Beyond the power of company, within the powers of the act, then primarily it is void, but it can be ratified by company's members and then it will be fine. But any act is beyond the power of companies act is always void and illegal. Right? Now, this is to protect whom? People's money is there, shareholders' money is there, creditors' money is there. So we are protecting their interest rather than we are protecting anyone else. Their money is very important here. They have put so much of capital by trusting the directors. We should not allow them to go beyond the powers. Right? Okay, sir. Then, next, that is doctrine of constructive notice. So, in case of doctrine of constructive notice means what? Notice, notice thing, C. Whenever MOA and AOA is filed as with ROC, it will become a public document, and the moment it becomes public document, it is available for public to see and read. So whenever you enter into a contract with the company has a liberty to assume that you have seen their MOA and AOA. It is not that you have not seen it. If you have not seen it, it is your problem. That is what company will tell. We have the liberty to assume, because company will never ask you, do you know about me, what business I am doing? No, I have filed a document, go read and then come to me. This is what Companies Act says, right? So company has a liberty to assume that whoever is entering into a contract, they are aware about who am I, what the company is doing, etc. Right? Now, if you have not read and still enter into a contract, tomorrow if you lose, you will not get any compensation from company side. Company is not liable for that. Right? Then doctrine of indoor management is exception to doctrine of constructive notice, which means there company got the liberty to assume. Here the third party will get the liberty to assume that company, I will not ask you, have you passed a resolution, have you taken signatures, etc. Whatever your internal rules are there, I will not question you. I will assume that you have done it properly, and I will not sit and question about the internal rules and regulation. Clear? Again, it's the same logic of MOA, AO only. Right? Now, again, sir, what are the exceptions to indoor management? Meaning, in these cases, we will not be able to give you shelter under doctrine of indoor management, which is the knowledge of irregularity. When you know that something is wrong, you cannot assume everything is right. Second, negligence or suspicion circumstances, when there was a means to find out whether the truth or whether it is happening or not happening, you did not execute that. It is your negligence. Therefore, we will not be giving you any shelter. No knowledge of articles. You don't know about AOA only. What will be able to give you the shelter? See, AOA, at least you have to read and come, right? That only you do not know. The power only you do not know. How can you assume that, right? Illegal transaction and forgery will always be considered as out of context here, right? Capital clause, sir. What is capital clause? In capital clause, how many people, that is your first subscribers, how many shares they have taken, and what is the amount of shares they have taken, and authorized capital will be there. That's your capital clause. Liability clause, sir. If your company is limited by shares, what is the liability? Liability is equal to unpaid amount. In case of company limited by guarantee, liability is equal to amount promised. Clear? Section 5 talks about AOA. In AOA, what is their internal rules and regulations? How does the director have the power? Calls in advance, power is there or not? Clear? To make the calls, for varying the rights, all these things in AOA, there will be internal power given. Clear? We can alter our AOA just by passing a special resolution as per section number 14. Clear? Now there is entrenchment clause. Entrenchment clause basically to protect the minority or even for example the majority, right? Now for example, let's take an example. Let's say 100 people are there and 75% of them say yes to a loan. Now obviously the 25% of the people have a valid reason to say no. If you take a loan, we will not be able to repay, that our capability is not there to repay. So that's why they said no. Now every time they say no, 75% of them say yes, majority says so we'll go ahead, right? That is when entrenchment clause comes into the picture. Entrenchment clause says it is not those who say no or yes, it is about caring about those who say no. Every time they say no, we are not taking their no into consideration. Entrenchment clause says if this particular business, whatever you are transacting, let's say borrowing, and on that entrenchment clause is applicable, tomorrow when you go to bank for borrowing, bank will read the AOA. If entrenchment clause is there in the AOA, bank will ask, sir, please go get consent of this minority interest as well. They also should say yes, only then we will be able to execute it, right? So entrenchment clause is something where you put a stricter rule and regulation, stricter than special resolution. See, first of all, special resolution itself is stricter. Getting 75% of the votes is very difficult, right? Now they are saying even stricter than that, that is more than 75, it could be 80, 90, 95 or even 100 you put, no problem. Clear? This type of clause is called as entrenchment clause. Then section 6 is a consequential section. Act to override MOA AOA, you can't put anything beyond the act will prevail. Section 7, important, very important, incorporation of a company. What is the procedure to be followed? You have to obtain DSC, then you have to obtain DIN, right? Then you have to reserve your name by using run facility. 2 names you have to give. Clear? Now in case of 2 names which is not at all approved, both the names are ignored, then 15 days time is there, another 2 names you have to give. Clear? Then you have to file INC 32, E-form Agile INC 35 and signed MOA AOA you have to file. Then professional declaration you have to file saying all the rules and regulations we have complied with, right? Then a declaration of subscriber saying that we are not convicted, not found guilty of any professional misconduct, and all whatever documents have been filed is correct and complete. Correspondence address, meaning temporary address till your register office is found. Clear? Details of every subscriber, name, number, identity number, etc. Right? And then particulars of interest of the people involved, how much shares they are holding in what firm, in what company, are they partners in the firm, etc. All the interest you'll have to pay, you'll have to put it here. Then particulars of situation of registered office within 30 days. Situation means what? Location of your registered office. Then pay your fees. ROC will give you CIN, that is corporate identity number, and COA, certificate of incorporation. Maintain and preserve all the documents permanently, that is till the dissolution of its company. Clear? Then section 9 talks about effect of registration, where they say subscribers will become members, body corporate can hold, dispose any of the asset, right? They can sue, they can get sued also. Effect of memorandum and MOA, once it is done, it will bind the company and members, and all money payable is like a due from the member to the company. Section 10 talks about commencement of the business. Commencement of the business, sir, within 180 days, you have to file a form called INC 20A, right? Declaration should be filed by a director telling that whatever first subscribers are there, they have paid the value of the shares taken by them. This I have to tell within 180 days in form number INC 20A, because to avoid the dummy membership. Clear? Simply in the paper you will say 10 members are there, but have you given the shares? No idea. So here you have to give them the shares, right? Only then they will pay money. Okay. Then section 12, which talks about registered office of the company. Every company must have within 30 days of its incorporation, they have to have registered office. So it's not mandatory that from day 1 only you should have registered office. You can also have registered office after incorporation within the next 30 days. Okay. Now, then with that, after that you have to file with the registrar verification of registered office within a period of 30 days of incorporation in INC 22. Outside the premise you have to put the name in legible characters, right? Local language and English. On the seal, engravement, official publication, everywhere this name should be there. In case of OPC, the word should end with one person company, and in the last 2 years if you have changed your name, old name as well as new name should be incorporated, right? Then notice of every change in INC 22 should be given to ROC within the 30 days. If ROC believes that you are not carrying on any business, they can come and physically check, and if the register office is not there, what they can do is they can remove the name from the register of companies. Clear? Right. One city to another city, easy, just pass a resolution BR and move on. Okay. One jurisdiction to another jurisdiction, this is applicable for 2 states. Okay. What do you mean by 2 states? Sir, in case of Tamil Nadu, Chennai and Coimbatore has 2 ROCs. In case of Maharashtra, Mumbai and Pune has 2 ROCs. In that case, you have to pass a BR, INC 23 application you have to give, board resolution, special resolution, KMP declaration. Clear? Then, declaration not to seek jurisdiction, because imagine from Chennai you are going to Coimbatore, your case has been filed in Chennai and case is going on in Chennai. You have to request to the tribunal saying, or you have to request to the ROC saying, or regional director saying, sir, for the pending cases will come to Chennai and solve. New cases they can file in Coimbatore. Clear? Next. Sir, acknowledgement copy of intimation of chief secretary, meaning, sir, my employees will not be retrenched. I will not remove any employee. Their interest will not be harmed. We will not take any negative steps towards the employees. This you have to convince whom? The chief secretary. File e-form MGT 14 within 30 days of passing SR, and RD shall confirm within 30 days to the company. Company shall confirm the ROC within 60 days, and ROC will give certificate again within the next 30 days. Clear? Yes. Then we have state to state provisions. State to state provision is pretty big, right? INC 23 you have to give. Copy of MOA, copy of minutes, board resolution, acknowledgement, that chief secretary, same logic. Clear? Then any advertisement if you have given, yes. Notices issued, objections received, along with counter response. All these documents you have to file with them. Clear? Now, attach a list of creditors and debenture holders as well. Clear? Giving names and address of every creditor, nature and respective amounts of the debt, because so that we will get to know how many creditors are there, what is the value of the creditor, what is the value of debenture holders, etc. Clear? The list shall be accompanied by declaration signed by the CS if any, and not less than 2 directors, one of whom shall be managing director. They have made a full inquiry into the affairs that, yes sir, whatever creditors are there, we have included them in the list, and whatever the value is there, we have included, we have disclosed everything. Clear? You have to also tell, no employee shall be retrenched because of the shifting of registered office from one state to another state. Clear? Then, once you file an application, within 30 days of filing application, you have to publish advertisement in newspaper in INC 26 and serve a copy of advertisement to CG. Then you have to give individual notice in RPAD mode. MCQ they can ask you. RPAD is registered post acknowledgement due. Registered post acknowledgement due. Clear? In RPAD mode, you can give it to them. To whom? To every debenture holder, to every creditor, ROC, and in case of listed companies, you have to give it to SEBI. So 4 people you have to give: ROC, SEBI, creditors, debenture holders. If no objection is received, within the next 15 days, order will be passed. If objection is received, then we'll have to solve the objection. Once you solve the objection, NCLT will pass the order. Clear? Right, sir. Then after that, you have to file something called as e-form active, right? E-form active you have to file. If you do not file e-form active, they'll be giving you a tag called e-form active, or that is non-compliant, active non-compliant. Then pay 10,000 rupees fine, then they'll give you active compliant tag. Alteration of MOA, that is a name clause. If you have to change your name, INC 24 you have to file, BR you have to pass, SR you have to pass. CG approval in case of change of name, only with approval of CG is possible. So BR, SR and CG approval. But if you are simply changing private to public, public to private, you need not take CG approval. BR, SR is 100% required. Clear? If you have not filed your annual return, financial statements, or not paid or repaid your deposits and debentures and their interest, you won't be able to change your name. Repay, file, then they will allow you to change your name. Clear? Once everything is done, INC 25 will be given, that is certificate of incorporation in INC 25 will be given. Object to change if I am doing, see, whatever company has incorporated for a specific object, if you are changing, you should ask your shareholders, because they have given your money, they have given the money to be run in the company. Therefore, if you have raised money from public, then you should not change the objects unless a special resolution through postal ballot is passed by the company. Details in respect of such Details in respect of such has to be published in newspaper. Whenever newspaper comes, two languages, English and regional. Clear? On the website of the company also you have to place. If there's people who say no, they are called dissenting shareholders. People who say no, they are called what? Dissenting shareholders. They should be given an opportunity to exit. Meaning what? Sir, I don't like this, therefore please give me my money. Yes, opportunity to exit at such price as may be prescribed. Clear? Then section 14, which talks about alteration of AOA. Alteration of AOA says, sir, first of all you have to take a board resolution as to when do we hold general meeting, and in the general meeting you have to pass SR, file an application with central government which is given to RD now. Okay. Then whatever NCLT passes, please take the order copy, go and file it with ROC. He will give you a fresh COI. Conversion shall not affect your any obligation or liability. Sir, you took 1 crore loan as a public company, you are converting into private company. Nothing will happen. Clear? Nothing will happen. That will still continue under the new identity. Okay? Right. Then every alteration under this section and a copy of order of central government shall be filed with ROC. Okay? Together with printed copy of altered AOA, proposed alteration, whatever you have done, print one copy and file it with ROC. Okay, right. Section number 16, which talks about rectification of name. Rectification of name are of two types. One, by accident. By accident, sir, unintentionally, inadvertence, unintentionally, the name resembles an existing company. Government will pass an order within 3 months. You are supposed to change your name. Now, it doesn't resemble the name, it resembles trademark. Trademark means what? For example, now Surf Excel, or now let's say for example Domino's, right? Now I will incorporate a company called Domino's. Now Domino's is a particular trademark, right? It's a brand. Now I incorporate a company called Domino's, and if I do pizza business there, now Domino's company name is Jubilant Foodworks, right? Company name is different, brand is different. Therefore, tomorrow I start the company name with a brand of another company. That proprietor, that is a brand's proprietor, can file an application within 3 years with ROC, that is government. Government will pass an order within the next 3 months. You are supposed to change your name. If you don't change your name, government it on its own will give you a name, and that name you will not like it. Then you are forced to change your name. Okay. Right. Section 19 we have already covered. Section 20, which talks about service of documents. You can, how do I serve the documents, sir? To whom do I serve the documents? Clear? Now, from ROC to company, what type of document I have to give and how I have to give, not what type of document, in what mode I have to give. Section number 20 talks about it. Clear? On the other end, ROC should give the documentation to the company. In what mode they have to give? That section number 20 says. Clear? In what mode? Registered post, speed post, courier, electronic mode, leaving at the register office, etc. Clear? This is section number 20, which talks about service of documentation. Clear? 21 talks about authentication of documents, proceedings and contracts. Now in your CMA module, there is one unit in corporate law which says key managerial personnel. I have covered that here itself as a definition format. So authentication of documents, contract and proceedings. Who should authenticate it, sir? As per section number 21 of the Companies Act, document or proceeding requiring authentication shall be signed by any key managerial personnel or officer or employee of the company, but he should be authorized by the board. Now, who is this key managerial personnel, sir? Who is this key managerial personnel? CEO, MD, manager, company secretary, WTD, CFO, any other officer not more than one level below the directors who is in whole-time employment designated as KMP and such other officer. Right? Who is KMP? CEO, MD, manager, CS, WTD, CFO, anyone next to the board and any other officer. Clear? Execution of bill of exchange. Who should execute bill of exchange, sir? Sir, any authorized person, board should authorize someone so that that person can enter into bill of exchange transaction and can sign it. And the moment he signs it, he can bind the company as well. Right? Now, there are two types of authorization. It could be a general authorization or it could be a specific authorization, depending on what authorization you are giving according to that he should function. Clear? Now, if the company has a common seal, you put the common seal on the authorization. If the company does not have common seal, no problem. The above authorization shall be made by whom? At least 2 directors or director and CS wherever the company has appointed a CS. A deed signed by such an attorney on behalf of the company shall bind the company. Only authorized person. Unauthorized person. Unauthorized person signing. Unauthorized person signing cannot bind. Cannot bind the company. Clear? Only authorized person can bind the company. Right? Now in this chapter, that is in the first chapter, actually section number 3 to 22 will be covered. Clear? Then 23 to 42. Then 43 to 72. Then 73 to 76A. 77 to 87. 88 to 122. So this is a division of the chapters. So technically we have 6 chapters to deal with from till section number 122. Clear? In your module they have given line by line, line by line, line by line. That is section wise they have kept on putting the content. So you won't be able to find out which chapter is what. That's why here chapter wise you can take it forward. Clear? So section 3 to 22 is how this is there. Right? Now corporate law, you can see this as a part 1. Right? Then you can see the next part, then you can see the next part, like that. Part by part, if you are able to do it, it would be better for your revision purpose as well. Right? So section 3 we saw formation of company, 3A we saw members are liable, 4 we saw memorandum, 5 we saw article, Act 2 override, incorporation, your charitable objects, effect of registration, effect of MOA, commencement of business, registered office, alteration of MOA, alteration of AOA, 15 alteration to be noted in every copy, rectification of name. Clear? 17 copies to be given. Any member requests for the copy, you have to give him. 18 conversion of companies already registered. Proper conversion will give you proper effect in ROC's books also, as well as your certificate also. Subsidiary company not to hold shares in holding company, service of documents, authentication and execution of bill of exchange. Right? So this is your from chapter number 1, section 3 to section number 22. Okay, so the next topic is concept of corporate wheel. Now, what do you mean by corporate wheel? Corporate wheel is nothing but a corporate personality. As we know, a company has a separate legal entity and it has a corporate personality, correct? So, concept of corporate wheel says company is different, members are different. So, this is a general rule. Company is different, members are different. Now, what is lifting of corporate wheel is we don't consider company and members are two different people. We consider them as one. Why, sir? Company cannot talk on its own. Company cannot do things on its own. Since company is an artificial person, we do not want people taking advantage of this artificial personality. Therefore, people who run the company may use this company for bad things, or they may use it in a manner which is not so advantageous for the company itself. In those cases, what we do, we lift the corporate wheel and we say members and company both are same. This is not usual. This is only in case of exceptional situations. What are those exceptional situations? For protection of revenue. For example, to protect the revenue of the government, what people will do is, what people usually think of doing is, they float a company, transfer the funds there, and from there they spend it, right? Which means you are avoiding income tax, correct? So in the Dinshaw Manekji Petit, there was a case where he diverted his funds to various companies, and from there he escape the income tax. Now in that case, you can't call it as a corporate wheel. Company did, sir, I did not do. So they lift the corporate wheel and say company and members both are same. Determination of enemy character of the company. Although company is incorporated in India, and imagine the members are from enemy country, right? The directors are from enemy country. The subscribers are from enemy country. It is as good as enemy is dealing with us, right? Company is not dealing with us. Therefore, they say in this case, boss will take the company's corporate personality, and who is behind the company, who is running the company, members from enemy country, right? Prevention of fraud. To prevent fraud, what we can do is we can lift the corporate wheel and see who is the person behind a company who puts the company's name in front and does fraud and ultimately blames whom? The company. Therefore, liability will be on the company. This should not be allowed. Protection of public policy. Company is a mere sham. Mere sham means what? Dummy. Clear? Simply like a puppet, you have created a particular company where a company acts as an agent of its shareholders. Now in this case what happened? A company which was supposed to get some license, the department rejected the application. Now the company floated one more company and all the assets were transferred to that company. That company went and applied to the license again, and obviously the department said, see, we cannot give because this company is run by you only, right? Therefore corporate wheel is lifted, therefore company and members both are same, right? Next, avoidance of welfare registration for payment of bonus. You float a company and you still we don't have enough profits, we have given loan to that company. Based on the profits only you have to give bonus, right? So you are telling, right now you are telling, we don't have any bonus, sir, therefore we will lift the corporate wheel. To punish for contempt of court. Contempt of court means not following the orders of the court, in disobeying the orders of the court. This can be asked in the examination. This can be asked in the examination. Clear? So please be careful with respect to corporate wheel and the situations of corporate wheel, right? Now, next chapter we'll be talking about is chapter number 3, that is prospectus and allotment of securities. In this chapter we'll be covering from section number 23 to section number 42. In your module section number 41 they have given in a different chapter, but I'll be covering under the same chapter. What I have done is in the particular portion I have covered section wise as per the act only. What is the section that only we have been covering, okay? Section number 23 talks about actually types of issue, right? Types of issue means what are the different types of issue a company can have, right? A public company can have 4 types of issue, that is public offer, private placement, rights issue and bonus issue. In this chapter we'll be talking about public offer little, yes, private placement, that is section number 42, rights issue will not be talking here, that's your next chapter, section number 62, and bonus issue section number 63. And in public offer we have 3 types, IPO, FPO and OFS, okay? Private company we have 3 things, private placement, rights issue and bonus issue. Okay, so this entire chart if you study, that's good enough for section number 23. So again, for public company, what are the different types of issue? Public offer, private placement, rights issue, bonus issue. Public offer, IPO, FPO and OFS. Okay, now what is the definition of prospectus? Prospectus means any document, right, either described as a prospectus or issued as a prospectus. It includes red herring prospectus, also shelf prospectus, or any notice, circular, advertisement or any other document inviting offers from the public. Okay, for what? For purchase of any securities. Clear? So any document either defined as a prospectus, described as a prospectus, issued as a prospectus, or any document, basic condition you have to see is, are you inviting offers from public? If the answer is yes, then you're welcome. You have called that particular document as a prospectus. What are the different types of prospectus? Section number 31, 32, 33. Also, we will be talking about section number 25. Section number 31 talks about shelf prospectus, which means what is shelf life? We relate that with the shelf life, which means there is some expiry. So this prospectus has 1 year of time within which any company, if they want to go for multiple issues, what they do is they initially issue shelf prospectus and then they can give multiple issues, because the reason is for every issue, if we keep doing prospectus, if we keep on making one prospectus, will go up to so many details we have to put, around 400 to 600 pages it will be. Clear? And it is not so easy to make. So what they are telling is during your first offer you give the shelf prospectus, and for the upcoming offer you don't have to give further prospectus. 1 year time is there. Within 1 year n number of issues you want to give, you give, no problem, no further prospectus is required. The changes between the first offer and succeeding offer will be given in the form of information memorandum. Okay, and in case of anyone who has already given you money, advance payment they have given you, now when they have given you advance payment, it is your duty that any changes if it is there, you have to tell them, right? So if because of advance payment, that's the only logic. Right now you have given me 1 lakh rupees, I want only 10,000. Now you have trusted this issue with the terms and conditions of the issue, and you have given me 1 lakh. Now the question when you give me 1 lakh is, when I change the terms, it becomes my obligation, it becomes my duty to tell you what are those changes. Now coming to your point of view, if you like the changes, you can keep the money with me. If you don't like the changes, don't you think you will express your desire to withdraw? The answer is yes. So when you withdraw your money, it is my duty again to refund that to you. But you have to give me some time to refund, and that time is nothing but 15 days. Can be asked in form of your MCQ. Within 15 days, I am supposed to return your money, sir. Now, this information memorandum, obviously ROC will not be knowing about it. He will be knowing only about the first shelf prospectus. So, what should I do about information memorandum? Information memorandum shall be prepared and filed with the ROC within 1 month prior to the issue of subsequent offer of securities. Clear? Right? Now coming back to red herring prospectus. What do you mean by red herring prospectus? Red herring prospectus means a prospectus which does not include complete particulars of quantum or price. Either quantum or price. In some cases both will not be there in the prospectus. Right? Why? Because see, red herring is a concept basically to divert the attention of the public. Now imagine Toyota company is coming up with a car with every feature ready, prices also ready, they know that they are going to launch. Let's say they are telling we are going to launch in the month of June. Now let's say Maruti Suzuki company also, it's in the competition. Now Toyota has already launched the car. General public who wants to buy that particular car, they'll be thinking only about Toyota. Now, how do I make them think about me? So, what Maruti Suzuki will do? They will launch one more product. That is one more car. They do not know what features they are going to get. They do not know at what price they are going to sell. So, what they will do? They will announce the arrival of the car by saying, we are also coming up with the car coming soon. Right? More details they will not give. Now what will happen? The public will be having some sort of worm in their mind when they purchase a car. Should I go for Toyota or should I go for Maruti Suzuki? If I am going for Toyota, should I wait for Maruti Suzuki to release their car? Now that diversion is created because of me announcing, the Maruti Suzuki company announcing the car, and that diversion is called as red herring. Right? That's a concept of red herring. So in red herring prospectus, company will come out with an issue saying X number of shares, we don't know how many, at X price, we don't know what price. Now, what people will do, they will read the prospectus and apply to the company saying, I would like to buy this many shares at this price. Now what will happen at the end of the offer? They will get to know the range, how many shares people want and at what price generally people are accepting. So I get to know the price range of it. Therefore, it will help me in understanding the market better. Right? So this particular red herring prospectus company may issue, right? You have to file it with the ROC at least 3 days before the opening of the subscription of offer. Any variation shall be highlighted as variation, and upon closing of the offer, this variation plus red herring prospectus put together will be called as, once it is complete, will be called as a normal prospectus. Clear? Then, now how do I understand, sir? Let me just show you. If I go to SEBI website, here if you go to filings, public issue, can you see red herring documents filed? Yes. Now if I open red herring documents filed, I'll just open Aether Energy, right? Okay. Right. Now if you see fresh issue, do we have number of shares? No, it is dot, right? Do we have amount? No, it is dot, right? So either quantity will be missing or price will be missing. In this case, quantity in case of fresh issue is missing, price in case of OFS is missing. That means everything they will give you. See, 586 pages prospectus it is. Clear? (586) prospectus. Now if I go to our main content, filings, public issue, final offer. Okay. Now final offer, Aether company has not yet given the final offer because it is still open. Right. Now I'll go for some other product or some other prospectus. If you see here, right? Now if you see here, fresh issue, I think you can't see properly, so let me just download it. Right, quantity also there, price also there, OFS quantity also there, price also there, right? So this is how the final prospectus looks like. Okay, right, sir. Next is deemed prospectus. Sir, what do you mean by deemed prospectus? Deemed prospectus is nothing but, see, if you try to through a document you try to get the public's money by bypassing the prospectus route. See, you take public's money, but you follow this chapter section. Without following this chapter section, if you try to take public's money through some other means, then the document issued by them is what we call as deemed prospectus. For example, there is a company, there is an issue house, then there is public. Okay, the company allots the shares to issue house, the intermediary, and tells the issue house, you sell the share and you collect the money and give it to me. Now if company wants to directly give it to public, if the company wants to give directly to the public, if this is a company, this is the issue house and this is public, okay, company wants to directly give it to the public, it has to go through the prospectus route. Now we don't want to go. So we will go through issue house will give it to public will give money to issue house will further give it to company. This methodology they will not allow. Now issue house, they have to give some document to public if they are giving the offer. This document will be called as a deemed prospectus of the company. Clear? That is your section number 25 concept. Okay, where company allots the shares to issue house and further to public, right? If the person making the offer, that is the issue house, is a company or a firm, then the document should be signed by 2 directors or not less than 1/2 of the partners in the firm. Okay, the document shall be signed. Okay, sir. Then matters to be stated in the prospectus. What matters to be stated? Very easy, sir. As long as SEBI is there, whatever SEBI says will be following it. So every prospectus of a public company shall state such information and reports on financial information as may be specified by SEBI in consultation with CG. So till SEBI says, SEBI's old law only will be applicable. This prospectus shall make a declaration about what? Compliance of the provision, statement that we have not contravened this provision, nothing is going against the provision, nothing is going against SCRA, nothing is going against SEBI Act. This section shall not apply to whom? Existing members and debenture holders or shares where the terms and conditions, everything is same, uniform in all respects. This particular section is not applicable. Okay. Copy of prospectus shall be signed by the director or a proposed director, shall be delivered to ROC on or before the date of publication of its filing. Okay. Now expert's statement shall be included, but which expert statement shall be included, sir? Only those expert statement who is not engaged, was not engaged, interested in formation, promotion or management of the company, given his written consent, not withdrawn his consent before delivering of a copy to ROC. Okay, ROC shall not register a prospectus unless all the requirements of this section are met and accompanied by consent in writing of all the persons named in the prospectus. No prospectus shall be valid if it is issued after 90 days after the date of filing. So this can be asked as an MCQ. Clear? This can be asked as an MCQ. 90 days is the maximum limit. Section number 27 talks about variations, sir. Now, what is variation? Any term. It could be original purpose, clear, right? It could be utilization of amount, clear. Any of that sort if you are changing, clear. Any of that sort if you are changing, you have to take their permission. So, a company shall not vary the terms until and unless you take what resolution? Special resolution. In what meeting? General meeting, clear. And once that is done, you have to give a notice in newspapers. Whenever we talk about newspaper, we are talking about two newspaper, one in English and one in vernacular language. Clear? Such company shall not use any amount for buying, trading or otherwise dealing in equity shares of any other listed company. Very, very, very important. Clear? Then in case of dissenting shareholders, they may given an exit offer, meaning people if who want to leave, they can leave at such price as may be specified by SEBI. Meaning people, sir, I take 1 crore loan from, not loan, 1 crore money from you as a public offer, and I tell I am investing 1 crore in real estate business. Now, after getting that 1 crore, if I am using that 1 crore in automobile business, I need to take permission and then invest. That is called variation of objects in the offer. Section number 28, which talks about OFS, right? Now, OFS is nothing but offer for sale. Offer for sale by certain members of the company. Now, certain members means who? It could be promoters. It could be big shareholders. Clear? Now, promoters, big shareholders and all, for them, let's say for example, they want to dilute huge number of shares. If they want to dilute huge number of shares, if they only sell on their own, the public might feel, why are promoters selling their shares? But if it is done through the company, the confidence level will be different. So certain members in consultation with the board can propose to offer whole or part of their holding of shares to the public. Any document by which offer for sale to public is made shall be deemed to be a prospectus issued by the company. All liability will be applicable, but what is not applicable, very, very important, minimum subscription. Minimum subscription is not applicable. Clear? Then minimum application money, application value. Clear? Not needed, right? Any expert statement or director statement not necessary. Not necessary, right? So why? Because it is not a company's offer, it is people offer, right? Public issue is happening here not because company wants, because promoters want to sell off their shares. So rather than individually doing it, you can collectively authorize a company to do it. Section number 29 talks about demat format. So every public company and every other unlisted company, if they want to give shares, they have to convert their shares into dematerialized form. Any company other than the company mentioned above, that is private company, etc., if they want to give physical shares, you can give physical shares, absolutely no issue for that. Clear? Yes, you can give it in physical form also, you can give it in demat form also. But every company going for public offer and unlisted company, such a class of unlisted company, obviously they have to give it in demat form only. Clear? Right. Now, section number 31, 32 is done. 33 is something but abridged prospectus. With every application you are supposed to give something called as abridged prospectus. Abridged means what? Nothing but a short form of prospectus. Clear? So just nothing but only important features will be there. So with every application you are supposed to give abridged prospectus. Clear? Now section number 30 talks about nothing advertisement of the prospectus. Wherever you have given these documents, you have to advertise. Clear? It says when an advertisement is published of advertisement of what? Prospectus. You should also specify MOA, objects content, liability content, etc. Basically MOA content. So they should know what the company is doing. Clear? Then 34, criminal liability, very, very important. Sir, criminal liability means what? Imprisonment, jail time, etc. If a prospectus issued, circulated or distributed includes any statement which is untrue or misleading, or which is included or where there is any inclusion is likely to mislead, either it is misleading or there has a potential to mislead, every person who authorizes issue shall be liable under section 447, which is nothing but fraud. Clear? 447 talks about what? Fraud. right? But if this particular thing is not applicable, you can escape the liability on if you have to prove that the omission was immaterial, but you believed that whatever information you are told up to the time of issue is true, or inclusion or omission was necessary. So if you are able to prove that, boss, I really believe this information is true, then you'll be escaping this particular liability. Okay. Section number 35, which talks about civil liability. Section 35, civil liability. In civil liability, we have three subsections. One talks about the offense, second talks about exception, okay, and third one talks about intention to defraud. Alright, so first subsection number 1, which says if a person has subscribed, mark my words, whatever I am marking, please mark, you also mark the same words. Person has subscribed for securities acting on any statement which is included in the prospectus and has sustained any loss or damage. So you should have subscribed to the shares by acting on the prospectus and sustained any loss or damage. In that case, every person who is a director or has authorized himself to be named as director or has agreed to become such director, promoter, or anyone who's authorized the issue of prospectus or is an expert, these people will be liable to pay compensation to every person who has sustained such loss or damage. Clear? So in this case, you should have acted on the prospectus and then suffered the loss. Now, who are these exceptions? What is the exception, sir? No liability if you prove that you had withdrew your consent before the issue of prospectus. Any director, if you had withdrawn your consent, you won't be able to pay liability. You will definitely not pay liability. Sir, if you prove that the prospectus was issued without your knowledge or consent and you have given your forthwith, that is immediately, you have given public notice. Clear? Then, sir, with respect to expert, if any statement made by an expert and you had a reasonable ground to believe that the person making the statement was competent enough, he has given the consent to issue the prospectus and the expert has not yet withdrawn. Till when? Till, sir, before filing the copy of prospectus or before allotment, if he has not withdrawn his consent, then we will be telling that, boss, expert, you are liable. Subsection number 3, if there is intention to defraud, if there is intention to defraud, then he shall be personally responsible or personally liable. Clear? Without any limitation, meaning completely liable, sir. Clear? No limitation. Now, clearly they have said, instead of telling it, there's a case law where they said only allottee can claim damages. So Peak versus Gurney, which says only allottee can claim damages. Who is an allottee? The one who purchases the share directly from the company. Application, you have to apply for the shares and then get the shares from the company. You purchasing from a stock exchange is not called, you are not an allottee, you are a purchaser, right? Allottee is where company allots you the share. Section number 36 talks about punishment for fraudulently inducing persons. If you influence people to invest money in the company, then you are liable for fraud under section 447, right? Section 37 talks about action by affected person, and this is what we call as class action suit. What is it? Class action suit. Now, if one company has cheated thousands of shareholders, rather than you filing 1,000 cases, you just file one case. All of you become the petitioners for that, and one case you file, that should be good enough, is what law says. Rather than you filing multiple cases, you just file one case, right? Section number 38. 38 is not there here. 38 is talking about personation. If you apply to the company multiple names and different combinations using fake names and all, obviously you will be liable. Whatever benefit you got from that, you will have to give up that particular benefit, and that giving up of benefit is what we call as disgorgement, right? And that money will go and sit in section number 125, which is not there in the syllabus, IEPF, Investor Education and Protection Fund. Okay, now section number 39, 40, 41, 42. Here, very important for us to understand. Section number 39 talks about allotment of securities by company, right? Allotment of securities by company. Whenever company gives any securities, we need to have something called as minimum subscription. We need to obtain something called as what? Minimum subscription, and currently minimum subscription is 90% of the issue size. we need to obtain what? 90% of issue size. So if we get 90% of issue size, minimum subscription, minimum 90 we should receive. Then the object is fulfilled, sir. MCQ can be asked on this. Okay. Right. Sir, any person who is applying for the shares, minimum application money should be 5% of nominal value or such other percentage. Currently it is 25% of the issue price. Okay. Sir, what if I don't receive minimum subscription, sir? No problem. If you don't receive minimum subscription, whatever is there, you are supposed to refund it back. Clear? What you should do? You should refund it back. When, sir, technically you are supposed to receive within 30 days of the issue. Okay, within 30 days of the issue. But if you are not able to get within 15 days from closure of issue, you are supposed to refund. If you are not able to refund, then you have to pay interest at the rate of 15% per annum. How much you should pay? 15% per annum. Okay, and whatever money you have received, you have to credit to the same account from where you got the money. Then you have to file a return of allotment in form number PAS3 by giving certain details, the name, the list of the allottee, all these things you are supposed to put, which securities you have given, if it is given for cash, if it is not given for cash, then for what you have given, all the details should be there in this. Clear? That is section number 39. Next is section number 40, which talks about securities to be dealt with in stock exchanges. So therefore here, very easy, sir, every company that goes for public offer shall take permission of the stock exchanges before they go for public offer. That means they have to list their securities in stock exchanges, one of the stock exchanges or both. We have NSE or BSE in our country. So this is called recognized stock exchanges. So here you can get yourself permission, you can take the permission and get your securities listed here. Right now, whatever money you receive, you have to keep in a separate bank account in a scheduled bank. Okay, and you cannot use it anywhere except adjustment against allotment or repayment of money within the time specified by SEBI. Now, sir, very important point is underwriting commission here. What is underwriting commission? Commission paid to underwriters. What is underwriting commission? Commission paid to underwriters. Now, in this commission paid to underwriters, why do we pay? Who are these underwriters? Underwriters are those people who take huge amount of risk for your benefit. Clear? If you are a company going for a public offer, obviously what they will do? 90% minimum subscription we have to receive. What if 85% is received? That 5% balance underwriters will tell, I will take it, and for that as a consideration you pay something called as underwriting commission. Now the first point for underwriting commission is it has to be authorized by company's AOA. From where do we pay? We pay either from the proceeds or from the profit or both. Mix and match you can do. Should underwriting commission be paid in cash? Not necessarily. You can also pay it in kind. Clear? You can also pay it in kind. What is the rate should be paid, sir? Shares shall be paid at 5%. Debentures shall be paid at 2.5%. So share SHARE 555, SHARE 555, debenture 2.5%. Clear? Or AOA, whichever is lower. Therefore, maximum we can pay is what? 5% here. Maximum we can pay is 2.5%. Or rate authorized by AOA, whichever is lower. Clear? And you have to enter into an underwriting agreement where they'll give all the details, right? Commission will not be paid if you are giving it to existing shareholders, or if you are not giving it to the public, then commission need not be paid because there is no risk involved here, right? Private placement, very important. Private placement means what? Section number 42, extremely important from your exam perspective. Clear? It is nothing but giving securities to a selected group of people other than public offer. Here prospectus is not given, sir. Here what we give private placement offer letter, and which satisfies following condition. Now directly I'll jump to subsection number 2, which says maximum number of members to whom we can give is 50 or such higher number. Currently it is prescribed as 200, but while counting the number of 200, we will exclude QIB and employees who are offered under ESOP. Right now, this 200 is per financial year and per security. Per financial year and per security. You have to give something called as PP offer letter and application in form number PAS4. There is no right of renunciation. Either you accept, either you reject. There is no right of renunciation. Clear? Sir, in what mode I can pay? Any mode apart from cash, right? sir, two offers cannot be simultaneously existing. One offer should be over and then the next offer will come. Sir, within 60 days you're supposed to allot. If you're not able to allot within 60 days, within the next 15 days you're supposed to repay. And if you do not repay, interest at the rate of 12%. From where? From 60th day. From where? From 60th day. From where? From 60th day. Clear? Maintain it in a separate bank account, and utilization will happen only in two cases: adjustment against allotment, repayment of money. Clear? Like I said, since it is between us, you and me, public should not get to know what is happening. Therefore, public advertisement should not be given or should not be made. Right? File return of allotment in PAS 3, full list, name, address and security should be there. Right? In case of default, obviously the following penalties will be applicable. Right? Now, rule number 14, which says wherever you are passing private placement, you are supposed to take special resolution. But the same rule says if you are giving the private placement offer and the amount raised is not exceeding the limit of section 181C, then board resolution would be good enough. MCQ below 181C limit, BR, above 181C limit, SR. Clear? But if you are having multiple offer in a year, in the beginning of the year, you take one SR is good enough. That's specifically for what? Non-convertible debentures. If you are raising money from non-convertible debentures and the amount is more than 181C, then it is better you take one SR for the entire year. Similarly, if you are giving a securities to any qualified institutional buyers, one SR for the entire year should be good enough. And if you are giving to private placement, if you are having or if you are raising money through any person who shares land border with India, then you cannot directly give. You have to take government's approval before you go ahead with the proposal. Clear? Right, sir. Now, this is with respect to your prospectus and allotment of securities. Although I told global depository receipts is taken care in your module under section 76, for us it is here only. So, I'll just explain it in a crisp manner. Imagine we are in India, right? Indian company will allot the shares to whom? Domestic custodian. Clear? Now, India has a depository agreement with Overseas Depository Bank. So, technically, this is the main party. Clear? India and who? Overseas Depository Bank. Now, here they will have depository agreement. Okay. Now, I can't give shares directly to him. So, his agent called domestic custodian will be there in India. So, Indian company will allot shares to domestic custodian. Now, custodian and depository bank will have something called as custodian agreement. Okay. So, domestic custodian will tell Overseas Depositories Bank, telling, I have received the goods, sir. Right? I have received as per your instruction. Now, what the Overseas Depository Bank will do, they will issue depository receipts to foreign investors, and investors will give the money and that money will flow back to India. Clear? Now the main part here is procedure. Procedure is in your module they have given after section number 76A. Please go and read, very important. Clear? Where they have told you it's just a procedure, there is nothing big in it. One procedure which I want to explain here is who will vote, sir. Shares are allotted in their name. In company's ROM, whose name will be there? Overseas Depositories Bank name will be there. Therefore, who will vote? Overseas Depository Bank only will vote. Clear? And foreign investors will not vote because they have receipts. The moment they convert these receipts into shares, then they can directly vote in the company's meeting. Until then, they will not be able to vote. Right? This is your concept of depository receipts, and this is global depository receipts. If you are doing this in the country in any country apart from America, we call it GDR. If you are doing it in USA, we call it American Depository Receipts. And if a foreign company is doing it in India, we call it Indian Depository Receipts. Yeah? So, this is your prospectus and allotment of securities chapter. Sorry? Which bread you order? That honey. No, honey something, oatmeal. Okay. Right, chapter number 4, share capital and debentures. We have section number 43 to section number 72 in this particular chapter. That is section 43 to 70. We talk about share capital. and then 71 and 72 we talk about debentures. In that only important sections will be done, not small sections, but again we will be just quickly going through the concepts there. Now first section is section number 43, which talks about types of or kinds of share capital. We have equity and we have preference. Under equity, always two types of there. One is with voting rights, which is also called as plain vanilla. Then we have differential rights. Differential right with respect to dividend, voting, or any other rights if it is different. Then we have preference share capital, which always carries preference rights. Preference rights means whenever dividend is declared, preference shareholders will be paid first. Number one. Number two, whenever repayment of capital is done, they will be paid first. Number three, in case of winding up or any specific winding up when it happens, their money, they will be paid first. Now, with equity shares with differential rights is a very important question, which can be asked in the exam for 7 marks, so a descriptive part. You cannot issue differential right shares until and unless AOA authorization is there. In this chapter, always there is a thumb rule that AOA authorization must be there. There is a thumb rule, but not necessarily in every section it will be mentioned. Some sections AOA on the negative side will be mentioned. Now, should be authorized by ordinary resolution, even though it is a special business, we are passing OR. Reason because Act has specifically asked us to pass OR. And where we have to pass general meeting, meaning postal ballot not approved. Postal ballot is approved only for listed entities. If it is a listed company, then it can be through postal ballot. Voting power, total voting power should not be more than 74% of total voting power, including voting power with differential rights. So that is a maximum allowed limit is 74%. You should not be committing default in filing your FS and AR. Both documents regularly it should be filed for 3 financial years. And 3 financial year, which 3 financial year? Immediately preceding. You cannot choose any 3. It's not any 3, it is immediately 3. Right? Then, company should not have made default in 3D. That is your dividend, deposit and debentures, their interest. Then, preference shares and their dividend. Right? Then, term loan and their interest. Dues towards statutory payments like EPF, ESI, bonus, gratuity, any statutory payment if you have made default not allowed, and any amount, any default in creating the amount to IEPF. IEPF is Investor Education Protection Fund. Under section 125, this fund will be created. In this fund, you are supposed to transfer certain amounts, not there in your syllabus, but there is a rule. Within X number of years, X number of days, you are supposed to transfer it. If you don't transfer it, then yes, liability. Now, company has not been penalized by court under these Act, RBI Act, SEBI Act, SCRA, FEMA or any other special act being your sectoral regulator. Basically, example, for insurance we have IRDA. Yes, so under IRDA you are not supposed to get any penalty. If you get any penalty, you cannot be able to give shares with differential rights. Then, since it is a special business, we should always give explanatory statement. If you remember, I think we had written a thumb rule in the class saying every special business shall be followed by a explanatory statement. Right? Now, for that, certain details you have to fill in. Out of this, if you are able to write 4 or 5 points in the exams also should be good enough. Right? You cannot convert your existing equity share into differential right and differential right into existing. Basically, no conversion allowed, only fresh issue. Only fresh issue. Then, section number 46 talks about share certificate. There are 2 types of share certificate generally discussed here, original and duplicate. Clear? Share certificate will be given to you only on surrender of allotment letter. Whenever company allots you the share, they'll send you a letter. That letter when you surrender, only then they'll give you share certificate. You will not have both. You will not have allotment letter and share certificate both. But for listed companies, this section is no more valid for your perspective, from your point of view, because you are beneficial owner for listed companies. Share certificate is given to the depositories. Clear? Now, who shall sign this share certificate? 2 directors shall sign, or 2 directors and CS if CS is there. In case of OPC, if 1 director and CS if he signs, if CS is not there, only that person, that 1 director if he signs, it should be good enough. Right? Now, duplicate share certificate, when can you get? You can get if it is lost, destroyed, defaced, mutilated or torn. If it is lost and destroyed, you cannot return. But if it is torn, mutilated and all, you have to surrender it back to the company and they will cancel that. Okay. What is the time limit? For unlisted company, it is within 3 months. For listed company, it is 45. I think I told 15 days, no? Yes. Yeah. All right. Now, sir, what is the time limit for other certificates, sir? In case of subscribers to the memorandum, that is your first subscribers, what is the time limit? 2 months from date of incorporation. Allotment wise, again 2 months from the date of allotment. Transfer transmission, 1 month. Debentures, 6 months. Then voting rights. Voting rights is for equity shareholders. All resolutions they can vote. Preference shareholders only 3, which affects their rights, repayment of capital and winding up. But if the dividend is not paid for 2 years or more, all resolutions. Because I told you, there is no difference between them and equity shareholders now. The only preference was dividend will be paid first. But if that only is not getting paid, it's as good as equity holders. 48, variation of shareholders' rights. In case of your varying shareholders' rights, you cannot vary without a permission. Whose permission you take? First of all, you have to check whether MOA AOA allows you. If MOA AOA does not allow you, forget this section here only. But if MOA AOA doesn't allow you, now you can actually check one more document called terms of issue. If the terms of issue allows, then go ahead. If the terms of issue does not allow, you cannot go ahead. And second step is you have to take consent. Consent in how you have to take? Writing you have to take. How many people? 3/4 of issued shares, or pass a separate special resolution. Here we call it class meeting. Call a separate class meeting and pass on special resolution. Right now, those who say no, we have dissenting shareholders. If they want, they can go for an appeal, but not everyone can go for an appeal. What is the criteria? 10% at least you have to hold of such shares. Go to NCLT within how many days? 21 days of variation. NCLT's decision will be final. 49, calls on same class should be made on uniform basis, meaning you can't call 2 rupee from one person, 3 rupee from another person in the same class. Everyone should pay same amount. Different class, different call money, okay. Same class, different call money, not okay. Then calls in advance means what? Company has not made a call, but still we want the money. Now in that case, company says, you give money, no problem, I will never ask you, but you cannot ask it back. It's a non-refundable money. You don't get additional voting rights as well. Company should have specific power in AOA, and liability of future call has been reduced to that extent. Imagine I have given 1 lakh rupees, 1,50,000 supposed to be paid. 1 lakh is I have given, balance is 50,000. Out of that 50, 20 I will pay now. In future, you can't ask 50 from me, you have to ask only 30 from me, because 20 I have already paid. So with respect to the 20,000, balance has been reduced. Clear? If company goes into winding up before that, then it shall be repaid before any other shareholder. Company is liable to pay interest on CIA, whether or not profits are available. So interest is non-negotiable. Maximum you can pay interest is 12%, not minimum. Right? But if your AOA says anything lesser, you pay on AOA basis. Right? 51, payment of dividend to be paid in proportion of paid up capital. Generally, dividend is paid on face value, but as per section 51, you can pay on paid up value to ensure that we are paying as per what we have received. Otherwise, partly paid up shareholders will get better dividend. Section 52, issue of shares at a premium. What is premium? If the issue price is more than face value, we say we have reached the premium, right? Now, in this case, we have to transfer to a special account called securities premium account, and securities premium account can be utilized only for 5 purposes as per the act. But I told you in the current generation, it's only 3, or in the current time, it's only 3. Reason being, all companies follow accounting standards, right? Therefore, right now, only 3. What is that? B square and E. Bonus, buyback, expenses of or commission paid or discount allowed on issue of shares of the company. Then, shares issued at discount, generally void, specific circumstances allowed. Which are the specific circumstances? Number 1, sweaty equity shares allowed. Number 2, if you are giving shares to the creditors, when their debt is converted into shares as per SRP, that is statutory resolution plan, or debt restructuring scheme. Under this scheme and this plan, you can give shares to them at a discounted price to save the company. Okay. Generally, you cannot give. Only under these 2 plans you are supposed to give. Section 54 talks about equity shares. Which equity shares? Sweat equity shares. We are giving this to whom? To employees at a discount or for consideration which is other than cash. Why are we giving them? So that they are providing us value, know-how in different ways. Could be skill, could be talent, could be any intellectual property. One person has a software in his name, one person has patent in his name. We can give them because they are providing us a particular IPR. Then it should be of a shares already issued, meaning no fresh issue. You can't make fresh issue out of a fresh class. Already issued class, from that you have to pay, or you have to give sweaty equity. SR should be passed, special resolution. In that you have to specify number of shares, market price, consideration, directors or employee to whom such shares are issued. If it is compliance matter, listed company is SEBI, unlisted company always CG. Now, who is employee? Any employee who has worked with us or with the company for at least 1 year, we call them permanent employee. Director of the company, whether whole time or not, meaning full time director, part time director, doesn't matter, both will get sweat equity because both are adding value to the company. Third, employee or a director of subsidiary or holding, right? Then Allotment shall be done within 12 months of SR. That is a very important time limit. Lock-in period, sir. Maximum how much? No, minimum 3 years. Clear? Lock-in period means three years for which you cannot sell, you cannot deal, you cannot pledge, you cannot do anything with that. Clear? Now, how much we can pay? 15% of paid up capital or 5 crore in value, whichever is higher. But at all times, it should not exceed 25%. If it is, yes, 25% you cannot exceed. That means 1/4 they are giving it to employees. Okay. If you are a startup company, 50% up to 10 years. Exemption is given for you. Then, section number 54, redeemable preference shares. No company can issue shares which are irredeemable. What is irredeemable means? We will never get our money back. That type of logic and all we have removed now under Companies Act 2013. You have to pass an SR. Then, what is the maximum period? 20 years. But if it is infrastructure, 30 years. But from 21st year, 10% redemption or minimum 10%. This is very important. This 10% is minimum. It's not maximum. Every year you have to pay. Now, you can pay 1 year 20 also, another year 10 also, no problem. But you can't pay any year less than 10. Minimum 10 you have to pay. Redemption can be out of profits or fresh issue also, no issues. Clear? Redeemed only if it is fully paid. Right? If you redeem out of the profits, you have to create a new reserve called capital redemption reserve, which can be used only for bonus shares. Clear? Now, sir, we have spoken about this premium payable from where we can pay, sir. Premium payable, if you remember, section number 52. Nowadays, all company comply with AS. Therefore, it's only profits allowed. You cannot use SPA. But if preference shares are issued under 1956 Act and still valid, like 20 years into 2010 you are given, now it is still valid, then you can use SPA for that. But for new issue under 2013, you cannot use SPA, it was only profits. If you are not able to redeem the preference shares or dividend, you have to issue, further issue can be done. But for the two permission you have to take, one is NCLT's permission, one is holders permission. Which holders permission? Your the preference shares holders permission. Minimum 3/4 in value. This is very important. 3/4 in value. MCQ, they can give you numbers also. They can give you number of members. You have to take 3/4 in value. Right? That is section number 55 for you. Section 56 talks about transfer. Transfer and transmission, what is the difference? Transfer is always voluntary. Transmission is not voluntary. It is by operation of law. Like insolvency, death, court's order. Any of these things happen, then we'll have to undergo transmission. Transfer can be made voluntary in form number SH4. Stamp duty shall be paid. It shall be signed. It shall be submitted to the company within 60 days. Time limit within 60 days. Who can transfer? Either transferor or transferee. But if the transferor has lost the deed, sir, I cannot submit, no problem. Give indemnity bond to the board. Draft an indemnity bond, execute that, sign that, and give it to the board, saying in case if any loss, I will compensate you. You in the sense who? Board. Next. Deed, the company is required to give notice to the transferee only if the shares are partly paid and submitted by the transferor. This is to avoid future liability. That is uncertainty about future liability. The transferee, what if he doesn't know it's a partly paid up share? Notice shall be given in form number SH5, right? And he has the right to object within 2 weeks. 14 days time is given. If you fail to object, then we will assume that you don't have any objection. We will register the transfer. In case of deceased person, legal representative should execute. We will assume that legal representative is equal to the holder of the shares. Clear? It's an assumption given in the law itself, and we have to take that. Right. Then, section 57, punishment for personation, not that important. 58, refusal. If public company or private company, if they refuse for valid reasons, that is, you're transferring it to minor, some other illegal way of doing things, if they refuse your transfer of shares, then you can go for an appeal with NCLT. If you go for an appeal with NCLT, NCLT will hear you. Now the question is, within how many days I can go? If you are a private company, notice, they should give you the notice. Who company should give you the notice of refusal? If they don't give you that love letter, notice of refusal, then first 30 days if they give the notice. If they don't give the notice, then 60 days from the date of lodging the documents, meaning from the date of submitting the document, 60 days. Whereas private company, 30 days from the receipt of notice. And fun part is they have to send the notice within 30 days of intimation of transfer. So technically you are not getting 60 days, you are getting extra 30 days only. If you are a public company, notice is received 60 days, not received 90 days. What can tribunal do? They can either dismiss, or they can direct, or ask for you to rectify. Right? Section number 59, rectification of ROM. Very easy. Indian members, if there is any error in the ROM, go to the tribunal, apply. tribunal will give an order to the company. Company has to rectify within 10 days. If you're a foreign shareholder, in your competent court, whatever government decides, that court you have to go, you have to appeal. Again, NCLT will give an order. Within 10 days, the company has to rectify. Clear? That is section number 59. Now, 61 talks about alteration of share capital. Not there, but still, we are doing it. Alteration of share capital, nothing but number 1, increasing the authorized share capital. Number 2, consolidate and divide. We had given an example, 1 500 rupees note dividing into 10 100 rupees note, or 500 rupees note converting into 1 500 rupees. So consolidation and subdivision will be taken care of, right? Converting shares into stock and stocks into shares, and cancelling that part which is not taken by any person, meaning I have issued but not subscribed. So this is unsubscribed part.
Cancellation of unsubscribed.
Yes, cancellation of unsubscribed part. Section 62 talks about further issue of capital, that is section 62 1A, 1B and 1C. 1A talks about right, 1B talks about ESOP, and 1C talks about preferential allotment. 1A, right says if you are giving, you can give to only existing shareholder. You have to give them minimum 15 days time, not more than 30 days time. So 15 to 30, anywhere you can shift, no problem. Clear? If not accepted, we will assume it is rejected, right? In case of private company, very important, 90% of the members should give their consent. If yes, then you can give them even 1 week time, no problem. Reason being, private company has only limited number of members. We don't have to talk to public. Maximum 200 only. Out of that, 180 said no problem. You give us only 7 days. We are okay with it. Give only 7 days, no problem, right? But right shares has the right of renouncement. Renouncements mean all, I don't want the share, give it to someone on my behalf, allowed, no problem. But if AOA provides otherwise, option shall not be available. If you want to prohibit renunciation, you have to put it in AOA. Then, sir, if they decline to accept, nothing, board will dispose of as per the manner board decides. Okay. Now, ESOP is given again to whom? All the employees, that is permanent employees, and directors who are only full-time directors, and in part-time directors we are excluding independent one. Independent director will never get what? ID will never get ESOP from us, from the company. Clear? Not allowed. Then, if you are supposed to give ESOP, pass SR. Whenever SR is passed, you have to give explanatory statement citing the details. Out of this, don't worry, you need not write all 11. At least 4 5 you write, no problem. Okay. Now, if you are granting the option, then company will have the freedom to determine exercise price. Exercise price means at what price the members want to apply or the employees want to apply for. Right now, you can give it to your employees of holding company also, employees of subsidiary also, no problem. But you have to pass separate special resolution. That means 2 resolution has to be passed. One is for your employees, one is for holding company's employees. Then between grant of option and vesting of option, minimum 1 year period should be there. Sir, company shall have the freedom to lock in, specify after lock-in period, after shares are issued. Once I give ESOP, it is at the company's discretion that how many years lock-in period it will be. Clear? Option granted to employees is not transferable to any person except in case of death. ESOP is given to employees. Now, employee can't tell, I don't want the share, you give it to my father. That is not allowed. That is only in right shares. In ESOP, renunciation right is not there except in case of death. Right? Director report should be talking about ESOP, and company shall maintain a register of ESOP. Employee who is an employee, same as our sweat equity shares, permanent employee, director excluding independent director, and who is not included for ESOP, promoter or anyone belonging to the promoter group, number 1. Number 2, any director who is holding aggregate more than 10% of the shares. But even if it is in the startup, promoter can get ESOP, and even a particular director who has more than 10% can get ESOP. It's only for startup company. Clear? Not for normal company. Normal company excluded. Yes, startup company only. Right? That too only for first 10 years. After 10 years, even if you are a startup, promoter will not get ESOP. Yes. Then preferential allotment, you can give it to anyone provided you have to pass a special resolution, and the valuation of that share should be done by who? Registered valuer. Okay. Now, for them also you have to give notice within at least 3 days notice you have to give. Then comes the most important part is our conversion of loans or debentures into shares. This is, imagine a company has taken loan from a government. and government in public interest, they can issue order to the company saying this loan will be converted into share. Now, even though the loan does not have a convertible feature, since government ordered in public interest, I am forced to convert that into number of shares. Even though I don't have the shares, I have to increase my authorized capital and automatically I have to give them the shares. Now, if it is not acceptable for me, I can go to the tribunal. So, it will be government versus me, where in tribunal only, right? Now, tribunal will look at both the parties, see what were the terms and conditions, see the financial condition, then order whether shares should be, your security should be converted, loan should be converted or not, right? And once everything is done, once I agree that yes, I will give you shares, that my memorandum MOA shall stand altered and authorized capital shall stand increase. Even though I don't have that much authorized share capital, now I have to create that. Okay. 63, issue of bonus shares. We generally prefer to use capital redemption reserve here because it's a very rigid reserve. We can't use anywhere else. So we have three sources: free reserve, SPA, CRR. We generally prefer number 1 CRR, number 2 SPA, number 3 free reserve, because free reserve we can use in multiple areas. That's why we will not bother too much about it. Revaluation reserve we cannot use it because it's a notional reserve. There is no money in this. Clear? If AOA authorizes only, we can give number 1. Number 2, board will recommend authorization general meeting. Number 3, deposit and secure debt securities. If you have not paid, you cannot give bonus shares. Clear? Then statutory dues of employees. If you don't pay, no bonus shares. It should be fully paid up. And once you declare a bonus, you have to give bonus only. But once you declare a dividend, you have to give dividend only. You can't say bonus and then give dividend. You can't declare a dividend and then give bonus. Right? Once you announce the decision, you cannot withdraw. Now, section number 66, reduction of share capital. Whenever we say reduction of share capital, there are three ways to reduce the share capital. Number 1, unpaid amount we will reduce. Whatever is the unpaid amount on the share, we will not even ask them. We will cancel it in the balance sheet. Therefore, reduction of share capital happens. Cancel that part which is lost, meaning you have invested money, but you have a big loss. We can cancel that against the share capital. Clear? If you are returning the money which is in excess of your wants. Now I want only 10 lakhs, right? You have given me 20 lakhs. I don't want 20 lakhs. The remaining 10 lakh I will give it to you. That is called reduction of share capital. What is the procedure for this? Very important. Procedure is very important from exam point of view. Number 1, SR shall be passed. Whenever SR is passed, we will file MGT 14, right? Alter your MOA by reducing the amount of shares. Reduction shall be made only if there is no due in deposit or interest of deposits. Go and apply to NCLT. What NCLT will do? They will give notice to 4 people: CG, ROC, SEBI, creditors. They have to represent how many days they have. 3 months they have. If they don't respond within 3 months, we'll assume that they have no objection. Clear? Then tribunal will pass the order if it is satisfied that the claim of every creditor has been discharged. Either you have given their money or consent has been taken. If they say yes, also it's fine for me. If they say no, I should be able to pay their debt and then get the freedom. Right? Now, if creditor's name is also not included by mistake, right? And after the NCLT will pass the order. Once NCLT passes the order, I should pay their money even though that creditor's name is not there in the list. But if I take advantage of it and I don't pay creditor's money, then NCLT has a power to decide who will pay them. It could be us, it could be anyone else. Even though if I am not a member, NCLT can pass an order for me. You are an ex-member. Whenever I had passed the order, you are there. Therefore, we will be able to charge you. You are supposed to contribute. Clear? Now, section number 67, if you see, I told you in the class, 67 technically is not there. Clear? But for the understanding purpose, basic concept of understanding of buyback, it is there. Right? So, 67 simply I just explain, since other people, when they see this marathon, they should not be like, what sir is teaching. Clear? In the textbook only 68 is there, 67 is not there. From where this did come? Right? To understand 68, we need to understand 67, 68, 69 and 70. If you remember buyback, we did it in a group manner. First we did 70, then we came to 67, then we went to 68 and 69. 70 says you are not supposed to do 4 things. You cannot buy back shares through your subsidiary or any subsidiary. Through investment company you cannot do. Right? 3 years after committing the default, then you have to go for buyback. And last one, 4 sections if you miss: 92, 123, 127, 129. These 4 sections if you don't follow, then you cannot go for buyback. 67 says you cannot give financial assistance to anyone to buy your own shares. Here See, you cannot be member in your own company. That's the logic. You buy back, no problem, but give consequent reduction effect. Reduction effect means what? Use and reduce in the balance sheet. Clear? You give a consequent reduction, then buy your shares, no problem. But you cannot be your own member and you cannot vote in your own company. That's the entire logic of buyback. Clear? Then, section 68, what is the procedure, sir? From where do we have to pay money? FR, SPA and fresh issue. What is the condition? AOA authorization. If it is less than 10%, BR should be passed. 10 to 25% SR should be passed. If it is only equity shares, maximum 25%. Debt equity ratio should not be more than 2. Maximum to when? After buyback. In the class, I think we have done before buyback, during buyback and after buyback chart. Correct? Huh? Yes. All the shares have to be fully paid up. Gap between two buybacks should be minimum 1 year. If you are listed, then SEBI guidelines. Unlisted, follow CG rules. Procedure before buyback, you have to give explanatory statement. Clear? Also, you have to file declaration of solvency. If you remember, declaration of solvency means what? I am capable of meeting the liabilities even after paying for the buyback. Right? Time limit for completion, maximum 12 months. That is 1 year. From whom should I buy back, sir? Existing shareholders, open market, or from my employees I can purchase. Clear? That is your sweat equity and ESOS employee. Right? Extinguishment. After buyback, you have to physically destroy the share certificate. Could be shredding, could be burning, could be tearing. Basically, physically destroy the share certificate. Cooling period. For the next 6 months, you cannot issue the same kind of shares, but however, following is allowed. Bonus issue you can give because it is free. Rights issue you cannot give. Number 1. Number 2, obligation, that is conversion of warrants, you can give, no problem. Stock option scheme, sweat equity, no problem. Conversion of preference shares or debentures into, basically all these are promises. These are not fresh issue. These are all promises made before. So if that falls on this date, I can't say don't do it because we just did buyback. These are obligations. You have to do it. It's not your choice. It's your duty. Company shall maintain the register and you have to file buyback return within 30 days. Section 69, if you are touching, there are 3 sources, FR, SPA and fresh issue. If you are touching FR and SPA, you have to create a special account called Capital Redemption Reserve and nominal value of shares redeemed or nominal value of shares bought back. Right? Section 70, we have already spoken about. Debentures. There are various types of debentures. Main point is, can I give with debentures with voting rights? No, you cannot give debentures with voting rights. That's solely equity shareholders' rights. Wherever you are creating debentures, you have to create a new reserve called Debenture Redemption Reserve. We have studied a table in that, if you remember. Yes, only unlisted company other than NBFC and HFC has to create 10% Debenture Redemption Reserve, 15% Debenture Redemption Fund. 10% of what? Debenture Redemption Reserve of amount outstanding or falling due for the next 1 year. Clear? Right. Now, in this, debenture trustee feels that something is wrong. He has certain duties and rules and regulations to take care. That can be asked in the exam. Very big answer, but possibility is there. Okay. Then DRR. DRR we already done. Okay. 15% DRF we have to maintain. 50% of what? Sir, any debentures maturing during the ending 31st March of next year. 1 year in advance only we create Debenture Redemption Fund. And DRR is how much? 10% of value outstanding. Whatever is the outstanding value is there into 10% you do. If it is a partly paid up shares, create DRR only for the debenture part, not for the conversion part. Pari passu clause. What does pari passu clause means? In case of incapacity or insufficiency of the funds, generally we have to pay proportionate. But here, if pari passu clause is there, only then proportionate. Otherwise, we'll have to pay as per the chronological order of the issue. Okay, that's your section number 71. Now, can a minor become member? No. But it's not directly no. Minor can become a member only through transfer and transmission. Cannot be through application and allotment because he cannot sign a contract. Okay. What are the different modes of getting membership? Subscribing to the memorandum. Our name being there in ROM. Demat account if we have, will automatically become the member. Right? Yes. Transferee will become the shareholder there. And then finally, we have estoppel. Member by estoppel. Okay. Now, forfeiture of the shares, meaning cancellation of rights. How can we cancel the rights, sir? There are 2 ways to cancel. If somebody is not paying call money, I have 2 options. One is file a case on him, one is forfeiture, which is reasonable. Forfeiture is reasonable. Clear? Sir, I have to give notice, but directly I can't forfeit. I have to give notice. 14 days notice I'm supposed to give to them. Only then I can forfeit and I have to clearly mention the amount, how much he owes us. Clear? And I have to tell that if he doesn't owe, I'll have to forfeit the shares. Otherwise, notice is invalid. Therefore, forfeiture will become invalid. Clear? One catch. Can a fully paid shares be forfeited? The answer is yes. But it should be in the agreement. Only if it is there as arrangement or contract, fully paid shares can be forfeited. Clear? Right. With this, our chapter number 4, that is share capital and debentures, quick revision is done. Clear? Right. Next chapter, chapter number 5, acceptance of deposits of companies. Now here we are going to discuss about 73, 74, 75 and 76. So 4 sections we are going to study. One more section is the 76A. That's with respect to penalty. Clear? Now deposits is not applicable for such companies, which is banking, housing, NBFC and any other company, because for these people RBI is there and respective act is there, and we can't ask them, we cannot expect them to follow all the rules and regulations before accepting one single rupee, because that's their ordinary course of business. Acceptance of deposits is bank's ordinary course of business. Definition: 2 parts are there, includes and excludes. Includes receipt of money by way of deposit, loan or any other form, but excludes certain list. Now in your module it is incomplete. The list is incomplete, okay, but I have given you the entire list. Go through it once. Amount received by CG, SG, LA, SA, that is Indian government. Second one, foreign government, foreign bank, foreign citizen, PROI, anyone from foreign you can accept, it will not be considered as deposits. Banking company, you can take any money, form of loan, not to be considered as deposits. Public financial institution, you can take money, not to be considered as deposits. Commercial paper, what is commercial paper? Short term way of raising money, it's an unsecured way of raising money. Ultra short term, if you want, you can go through commercial paper, but here if you raise finances through commercial paper, it will not be considered as deposits. Intercorporate loan, company to company loan, not to be considered as deposit. Share application money, but you are not given allotment. Allotment is pending. Now if you remember section number 39 in the prospectus, what they have mentioned is you are supposed to refund the money if minimum subscription has not reached. If not, you have to pay interest. Now here they are telling same logic. If you have to refund within 15 days. If you don't refund within 15 days, we'll call it as deposits. Clear? Share application money received, but not allotment is not done. Now there is a difference. In section 39, minimum subscription it was, not application money. Minimum subscription, if it is not received, you have to refund. Here we assume that minimum subscription is there. They have paid application money, but you have not made allotment. Clear? If allotment is not made, that means there is no intention of giving shares. Whatever money you have received, you give it back. Now within how many days you have to give it back? Within 15 days you have to give it back. If not, we'll consider that as deposits. Then sir, whether you are a public company or a private company, you can take loan from directors and relatives. Yes.
Within next 15 days, that is the second day. Which is
No, don't compare this with 39, 15 days. Section 39, that 15 days is for minimum subscription. This is for application money. Next 15 days, in the sense, allotment is not there within 60 days of application money receipt. Now, whenever you receive application money, let's say for example, you gave me 5 rupee application money. From the day you give me, within the next 60 days, I'm supposed to give you shares. If I don't give you shares, within the next 15 days, I should give you money. If I don't give you that money, from 76th day onwards, it will be considered as deposits. Okay, right? Now, in case of public company or private company, you can take loan from whom? Directors or even relatives for that matter. If it is a public company, you can take loan from directors. If it is a private company, directors or relatives. But only one thing, very important, they have to give a declaration saying whatever money I have given you, it is not from borrowed money or accepted money, it is my own money. Here, one small adjustment you have to remember. What if the director received a gift from his mother or from the grandfather, grandmother, anyone? Can he give that gift money to the company as a loan? The answer is yes, because it is his own money. It is not borrowed money. It is not deposited money. Then, sir, company has to declare this in the form of notes. Amounts raised by issue of bonds and debentures, which has first charge. Charge means what? Interest, right? So, first charge on what assets? Any assets excluding intangible assets. That means on tangible assets, you should have first charge, subject to market value of such assets. Listed non-convertible debentures, if you raise money through listed NCD, very important, not unlisted, listed NCD, then only allowed. Excluded. Sir, from employee we can receive security deposit, but it should be non-interest bearing, right? Up to their annual salary. Please don't divide this here. Let's say for example, an employee's annual salary is 3 lakh. You received 4 lakh rupees as a deposit. You don't decide 3 lakh is not a deposit, 1 lakh is deposit. Entire amount is deposit. Clear? Any amount received in ordinary course of business, advance for supply of goods, it's a revenue for us. Number 2, immovable property advance, it's again income for us. Clear? Performance of contract secured deposit. Example, Zoom cars. Let's say you give 5,000 rupees deposit, take the Zoom car. After that, you have to give the car back and take the deposit. Clear? Then, capital goods supply. Capital goods is what? Nothing but specifically produced for my purpose. If I have any customized goods for that, if I'm paying any or receiving any advance for that, then obviously it is not considered as deposit. Yana, at the end of the day, it's a revenue part only. Clear? Then, unsecured loan, sir. Who should give? Promoter should give. Why, sir? Because bank or financial institution, they are forcing the promoters to give unsecured loan so that they'll have confidence in their project. It is basically because of a bank or financial institution, the promoter is trying to give the loan. Clear? Now, this is not to be considered as deposits. Technically, if I have to go in depth here, this will not be considered as deposit only up to the tenure of the loan. If the loan is for 10 years, it's only for 10 years. 11th year, he should take that money back. If he doesn't take the money back, for company it is a deposit and they have to pay interest. Clear? Then amount accepted by Nidhi companies. Nidhi companies, again small companies, let them accept money, no problem. Then startup companies should receive 25 lakhs minimum, but that too one shot. Installment if they receive, it is a deposit. But one shot if they receive, not a deposit. Correct? Any amount received by company from AIF, alternate investment from collective investment scheme, mutual fund, etc. Clear? So a company receiving money from mutual fund also is included in this particular clause, and mutual fund receiving money from people is also included in this particular clause. Okay? Right. Then section number 73 talks about we can accept deposit from members. But if you are accepting deposit from members, there are certain rules and regulation. What is that rules and regulation? No company shall invite, accept, renew from public except under this chapter. Now, who may accept deposit from its members, sir? Pass an ordinary resolution. Any company can accept deposit from its members. But what they have to do? Number 1, pass OR. Sir, specifically it's a special business, but still we are passing OR because companies have to specifically ask us to pass ordinary resolution. Then you have to issue a circular in form number DPT1. In that 4 information we have to put position, credit rating, deposit amount and any other particulars. This you have to file with registrar within 30 days before the issue. Be very careful here, before the issue of circular, not after. Okay. Then you have to create something called as DRR. What is DRR? Deposit repayment reserve. How much you have to create? 20% minimum. By when? By today. 30th April. On or before 30th April, 20% or more you have to deposit in a separate bank, scheduled bank. Now 20% of what? Deposits maturing in the next financial year. Now where are we in the which financial year we are in? 25, 26. So this year by today what we have to do? 20% of deposit maturing in 26, 27. That deposit whatever is matured amount is maturing amount is there into 20%. Today we have to go and deposit. Basically 1 year in advance we have to keep a security. And this where will be used? Repayment of deposits. Then one certification we have to give. Here. What is the certification? Company has not committed any default with respect to repayment of deposits. Sir, we have not done any mistake. In case if we have done, 5 years has expired. After 5 years only, you should be able to raise the money through deposit. Okay. Then you have to create security. There are 3 ways to create security. Be very careful here. This is where students get confused. There are 3 ways. First is insurance. Second is charge. Third is mortgage. If there are in 3 ways you can raise it. I mean, you can have security created. Clear? Now, all 3 ways put together, your deposit should be 100% secured. Even a single rupee if it is not secured, we'll call it unsecured. Clear? Now, once you accept the deposit, it shall be repaid with interest. And if you within a particular time, if you are not getting your money back, where can you go? Go to the tribunal. Tribunal will order to either pay the sum, pay any damages, such other orders. Clear? Now, these rules are, if you remember, I have told you these are extra bonus content for understanding the concepts better. Correct? Now, directly come to section number 74. If we have accepted the deposits, any deposit accepted before 2013 Act, that is under 1956 Act, if we have considered any deposit, what we should do? Law says repay it back. Repay it to the people, and if you still want the money, take it under 2013. Yeah, because under 1956 Act, we know that rules were different. So whatever you have accepted could be under old law. We don't want that to happen. You repay it now and accept under new law. Clear? And what is the time limit? Two things you have to do. One, file a detail, all the deposit detail within 3 months. Second, repay within 3 years. Clear? 3 years or due date, whichever is later. Okay? Right. Oh, sorry, whichever is earlier. Now, if you want more time, you can go to the tribunal. Now, within that time also, if you have not paid, tribunal will put very good amount of penalty. What is that? For company, 1 to 10 crore. Whereas for people, that the officer in default, free massage or only fine or paid. Understood? Now, section 76, very, very important. Very, very important. You can accept deposit from members under 73 and under 76 from, no, from whom we are accepting.
From public.
73 is from members, 76 is from public. 73 members, 76 public. 73 always members, 76 is always public. Remember this very carefully. MCQ very important. Under 73 we take it from members, under 76 we take it from public. In what is the difference? In 76, same procedure of 73 also will be followed. One additional is there, that is credit rating every year we have to take. If you remember, credit rating we had seen, CRISIL agency. On their website we had gone here. Now, if you, I had taken the report directly, correct? Now, rather than taking the report, no, see here, this is CRISIL's website only. There we had directly gone to their website. That is your company's website. This is CRISIL's website. For example, we'll take Tata only, for example. When we want internet to work, it will not work. Right, see, this is one more rating. Commercial paper, if you remember, just now we saw, right? Commercial paper, previous rated amount is 22,500, current also 20,500, rating action A1 reaffirm. So like this, every year we have to take it. Clear? Only when we take every year, people will have that confidence in our company that, okay, if we give money, it will be stable, clear, and we will not lose our money. Like that, every year you have to take credit rating, okay? Then you have to take SR. Yes, because it is public, you have to take members resolution, whereas in case of 73 it was OR. Okay, but here there is one more. If eligible companies accept deposit within the limits of 181C, then OR is enough. If it is more than the limit, SR. Less than the limit, OR. More than the limit, SR. Clear? Now, which companies can accept deposit from public? Number one, always and always and always public company. But public company, which company? All public company? No. Either net worth should be 100 crore or more, or turnover should be 500 crore or more. One of them. Yeah. But public company, no compromise. Private company cannot accept from members. Public. Now, section 76 here talks about punishment. Clear? Now, what is the punishment, sir? If you do not follow section 73 or section 76. 73 is from whom? Members. 76? Public. Which company can accept from public?
76.
Which company? Public company having either net worth of or turnover of 500 crores or more. Always remember, turnover will be the highest. Here we know one is 100, one is 500. Turnover will be the highest. Now, if you do not follow section 73 or 76, penalty will be given under section 76A. Okay. Now, sir, 75 is not mentioned. In your module, 75 is mentioned, but nothing great. 75 is fraud. Clear? If you do fraud, personally liable without any limitation. This is there in the entire act only. Okay. Now, 76A says, if you don't follow 73 or 76, what is the penalty given, sir? Very good penalty, same like 74 only. Exactly same like 74. That is, for a company 1 crore to 10 crore, but one extra addition is what? Twice the amount of deposit accepted, whichever is lower. That is one. Number two, for officers in default, it is imprisonment and fine. So it is never only imprisonment or only fine. It is both way. It is a paid massage. There is no free here. Clear? If the intention was to deceive, more punishment for you. Up to 10 years you can go for long vacation. Clear? Clear in that only. Right. Next. Chapter number 6. Registration of charges. Clear? Today our target is to finish corporate law. We are once we are done with corporate law, our main portion will be, biggest portion will be done. Clear? Look at how he is convincing himself. 40% is done, sir. Next chapter, chapter number 6, registration of charges, section number 77 to section number 87. 77 to 87. So totally we have 11 sections to talk about. Clear? Section, and before that, now see in your module directly they have jumped to sections without telling what is what. Okay. So I am just going to give an introduction as to what is charge. Charge is nothing but an interest or lien created on the property, assets or undertaking. Undertaking means what? Business. Clear? Right? And includes a mortgage. It is as a security we are creating, includes mortgage too. Therefore, charge is what? Lien created on property, assets, undertaking as security and includes mortgage. Two types of charges are there, fixed and fluctuating. Fixed usually is on assets of permanent nature like building, land, etc. Generally, not specifically, generally, but there could be an exception. Now, in case of fixed charge, can I sell my assets? No. Can I use my assets? Yes. Clear? But again, the borrowing company is not permitted to sell, although they may use them. If you want to sell, you have to take consent and sell. Clear? Okay. Sir, floating charge. In case of floating charge, we put the charge on generally current assets. Clear? Right? Now, in this case, can I sell? Yes. Can sell means what? Trading? Yes. Clear? But at the end of the day, it's on group. It's not on particular asset. For example, debtors, not on one debtor. The entire debtor. Right? Whenever I go and execute, whenever I put my enforcement into picture, and on that day, whatever is the debtor amount will belong to me. Debtor keeps changing. Inventory keeps changing. Clear? Yes. Sir, whoever purchases from me will get a free title. I mean, good title. Clear? Okay. Crystallization of floating charge. What is this? When the fixed charge, when the floating becomes fixed. Clear? Now, when the floating becomes fixed, can I sell my assets? No. I have to ask whose consent? Charge holder's consent. Okay. Section 77 is the most important section in this particular chapter, that is duty to register charges. Duty to register charges. Charge holder, the one who gave me money, because he has the asset now he has the power. Section 77 talks about what? Duty to register charges. Whose duty it is? Always company's duty. Within how many days? 30 days. Now, extension is where you have to focus on. Extension before 2/11/2018 and after 2/11/2018. Before 2/11/2018, if it is there, meaning you will get extension of 300 days, but not 300 days extension you will get. 270 days you get. Additional 270 days you get, because 300 days from creation date only. Clear? Then after 2/11, if you are doing 60 days of such creation on payment of additional fees. Clear? Further extension will be given if it is before 2/11. 6 months, after 2/11, 60 days. But here 60 days from payment of ad valorem fees. Here after payment of ad valorem, that is proportionate fees, you get 60 days to register it. Clear? Now, with that you have to actually file an evidence. What evidence? Loan agreement or whatever evidence, whatever instrument which evidences charge creation. See, this chapter doesn't talk about creation of charges. This chapter talks about only registration of charges, not creation of charges. Okay. Now, sir, once you are going and filing delayed application, you have to also file a declaration as to why are you filing delayed application. Clear? Now, after that, ROC will issue certificate of registration of charge in form number CHG2. Clear? And liquidator will never touch those assets on which charge is created but not registered. If he wants to take care, you have to create the, whatever assets you have given as a charge, as a security, it has to be registered with the ROC. Until and unless you get it registered, liquidator will never consider that during winding up. Okay. Now those things only you have to take care. Right. Next is 87 here. I told you why 87 is included here. Right. In case you want more time, where do you have to go? Central government. In what cases you have to go? Sir, omission to give intimation to ROC, omission of or misstatement of any particulars. This should be accidental. Inadvertence, meaning unintentional, or any other sufficient cause where creditors and shareholders are not getting affected. In such reasons, government can give you more time than the section, and registrar has to follow that particular government's order. Clear? 78, who can file? Charge holder can file. 77, whose duty? Company's duty. But if company does not do their duty, charge holder can request the ROC. And now charge holder, if he goes to ROC and says, sir, this is a charge created, company has not filed, please file it. ROC will not directly file it. ROC will send 14 days notice to company, and company has to tell what happened, what is the issue. If the company doesn't respond within 14 days, ROC will proceed with registering the charge, and whatever fees the charge holder had paid the ROC can take as a reimbursement from company. Okay, that is 78. Right? 79 is very easy section, lazy section. Says what? Follow 77. Whatever change you do, no problem. Come to me, I will give you the solution. What is the solution? Follow 77. Same 30 days, 60 days, and 60 days is applicable for them. Clear? Right. Now, date of notice is very similar to, remember doctrine of constructive notice?
Yes, sir.
Yes, very similar to doctrine of constructive notice. Yes, in regular classes, we had gone to MCA website, if you remember. We had seen index of charges and we had read the every column there, and then we came here, if you remember. Clear? Section number 82 talks about company to report satisfaction of charge. What does satisfaction of charge mean? Very good. Repayment of loan. And whenever you repay, now imagine company will go to ROC and tell, sir, I have repaid the loan, please register it as satisfied. Now ROC will register? No. He will give a 14 days notice to charge holder saying, company has told he has repaid your loan, correct or ilya? Come and tell me. Now charge holder has to communicate within how many days? 14 days. If he is silent for 14 days, ROC will register that satisfaction of charges is there. Then they will give another certificate called certificate of registration of satisfaction of charge. What is the certificate? Certificate of registration of satisfaction of charge. Clear? Right? Okay. And he will give in CHG 5. Okay. Then section number 83 talks about what? Power of ROC to make entries of satisfaction in absence of intimation of company. Basically, sir, company should give the intimation of repayment, but company did not give. Some third party gave, sir, no problem. As long as evidence is submitted, ROC will go and register in their register saying company has repaid the loan.
The third party is the charge holder.
Need not be charge holder, because the law uses a language where no intimation is received from the company. They can make entries on evidence being given. Now, whoever gives evidence could be charge holder, could be a third party, could be anyone buying it. Clear? Anyone, as long as you provide evidence. Clear? Now, hey, section 77, I forgot to tell you one extra thing. In section 77, it's not just that, 79, it is not just change. What if the company is actually acquiring a property which already has a charge? That time also 79 will be applicable. Now imagine A Limited is buying a land, but on that land already a loan is there. Now A Limited says, no problem, you give me, I will repay the loan. Now their loan will be repaid by A, but ROC doesn't know that A has taken a land. Let's say A Limited is taking from B, right? Now it is B, it's in B's name, no. Therefore in ROC's register, it will be in B's name. Now when A Limited takes that particular land, A Limited should go to ROC and tell, now this land belongs to me. Now you register in your book saying it is not B's anymore, it is A Limited's. Clear? For that also 79 will be applicable. This one thing can be asked as a case. 84, intimation of Appointment of receiver or manager. Sir, whenever court orders, instead of you managing the business, they can appoint a receiver or manager. I told you this one nonsense section it is. Clear? When he is appointed, he should come and tell two people, company and ROC. When he is leaving, he should tell two people, company and. Section 85 talks about register to be maintained by company itself. Clear? Putty section, nothing great in that. Clear? Company will maintain their own register. I think I have told you two differences between this and ROC, a register of charges kept by registrar of companies. Clear? The only difference is ROC will keep register of everyone. Company will keep only their register. Okay? Right. Then, section number 86 talks about what? Punishment for contravention. Company will be paying fine 1 lakh to 10 lakh, officer in default, imprisonment up to 6 months, right? Now, if you see here, contravention means not following the law, clear? Making default. Now, in 84, they have also told form number CHG 1, 4, 8 and 9 shall be signed by insolvency resolution professional or liquidator for companies under resolution and then filed with ROC. Because we are coming in as what? Liquidators. So, management will vacate. They are not in charge. Who is in charge now? Liquidator. So he will sign. He should sign. This is important. Clear? These four forms, who will sign? He will sign. Clear? This is our chapter number 6, registration of charges. See, in all these cases, no, case-based questions is very little. But I have given certain case-based question for conceptual understanding. I hope you have solved it. Yeah, if not, at least you would have seen 1 or 2 questions from every chapter. Alright? Okay. Section number 96. Started. That I'll record later. Section number 96 talks about annual general meeting. Clear? AGM is applicable for whom? Every company except OPC. I told you, OPC, only one person is there. Clear? He can talk to himself and get the meeting done. Okay? Notice shall be sent, and in that notice specifically you have to mention it as AGM. Notice shall comply with requirements of section 101. Due date of AGM, first AGM, 9 months from where? Closure of financial year, that is 30th September. Correct, no? 30th September, no? Yes, no? Then what is it? Yes, sir. 9 months from financial year, 31st December. Then, financial year closure when? March. 9 months, 9 plus 3, 12, December. Then, no extension given. What did he say? Subsequent AGM, 3 dates are there. One is, meeting must be held in each calendar year. Then, gap between 2 AGMs shall not be more than 15 months. 6 months from the closure of financial year, whichever is earlier. And extension I can give maximum 3 months. Clear? Where should I hold AGM? When should I hold? Business hours. Clear? Then, where should I hold? At registered office or some other place where RO is situated. Which day? National holiday. Hey, Sunday. Very good. Not on a national holiday. Hey, Sunday can I hold?
No.
We can. Is Sunday a national holiday? No. It is Gandhi Jayanti. Right now, for us, national holidays only 3.
Okay,
Independence Day, Republic Day, Gandhi Jayanti. Clear? But in future, if they say any other holiday is a national holiday, we'll have to consider that. Okay. Now, this is very important. AGM of an unlisted company may be held at a place in India, but listed company AGM, RO or place where RO is situated. Clear? Financial year. What is financial year? Very important. 1st April to 31st March. But exception, if the company is incorporated on or after 1st day of January, then 31st March of following financial year, following year. Clear? Then exceptions are there. You can follow different financial year provided. In case of consolidation, you can apply to the tribunal holding subsidiaries outside India, and for the purpose of consolidation only, you are allowed to follow different financial year. What is financial statement? Balance sheet, P&L, CFS, SOCI and notes to account. CFS is not applicable for small company, dormant company and OPC. Clear? 97, 98 is very easy. Tribunal will call AGM or EGM respectively. 99 punishment. Clear? Section number 100 talks about what? EGM, extraordinary general meeting. Who can call EGM? NCLT, BOD and shareholders or requisitionists, right? Yes. Now, BOD can call So EGM of a company other than wholly owned subsidiary shall be held at a place within India. We have seen this particular provision in depth. Now there is a holding company which is outside India, 100% subsidiary in India. For that subsidiary company's EGM you can hold outside India. UE Limited, HSL Limited, remember? Shareholders, minimum how many people? 1/10 of voting power or 1/10 of paid up capital. Correct? Then requisition shall specify the matters where EGM is to be called, meaning why are you calling EGM, you have to specifically tell. 21 days clear days notice as usual, right? Sir, when should board call? Within 45 days, but within 21 days they should start calling for the meeting. Meeting date should not be more than 45 days. If they don't call, you have a time, 3 months. Within 3 months, shareholders can call for meeting. Clear? Now, then next, sir, 101 talks about notice of meeting. 21 clear days notice you have to give. Yes. What is 21 clear days means? 21 plus 1 plus 2 plus, sorry, plus 1 plus 1 plus 2. Correct? Huh? Yes. Notice shall be in writing or electronic mode. General meeting may be called after giving shorter notice than specified if the consent is in writing or electronic mode. Very important, shorter notice. How many people should say yes? If it is AGM notice, 95% of the members entitled to vote, and any other meeting depends. Do you have share capital? If yes, majority representing 95%, dual condition, remember? Yes. And if it is not having share capital, 95% of voting power. Okay? Right, sir. Next. Who should call for the meeting? Proper summoning authority is always BOD or CS with the permission of BOD. Next. Sir, email once in a year at least you have to give some time limit for us to change our email. Clear? Next. Section 102 talks about business, ordinary and special business. Ordinary ADDA, ADDA, annual accounts, dividend declaration, directors appointment and auditors appointment. For ordinary business, what resolution? Always and always ordinary resolution. For special business, always and always special resolution. For every business of special or special nature, we have to give explanatory statement giving certain facts, right? Then 103 talks about what? Quorum, right? What does quorum say? For a private company, minimum? Correct, no? Correct, no? Yes or no? I'll hit you. I asked for private company, what is the quorum? 2 members personally present. If it is a public company, depends. Number of members 7 to 1000? 5. Then 1001 to 5000? 15. 5001 and more? Now, sir, very important point. If you are representing a company, governor, president, representative can come and he will be counted for the purpose of quorum. One person can represent maximum 50 people, right? And 10% of share capital or voting power. Correct? Now, if one person is representing a member who is already holding 10%, his limit is exhausted. He cannot represent any more persons. Clear? Right, sir? Sir, if quorum is not present, sir, quorum should be there only in the beginning or throughout? Throughout. Clear? Now, if quorum is not present within half an hour, meeting shall be adjourned to next week, same time, same day, same place. Clear? But if they want to hold it in some other day, some other place, some other time, that also can be done. But if the meeting is called by shareholders, adjournment is not allowed, cancelled only. Clear? Right. Now, even in case of adjournment, should you give notice? The answer is yes, you have to give notice. Clear? Right. Then, sir, as per Secretarial Standard 2, now, this is one question which I wanted to ask. What if I am representing, I can represent a body corporate? No. What if I am representing 5 body corporates? Is quorum present? The answer is no, because members personally present. With me, there should be another individual who is a member personally present. Now quorum is present. Clear? Chairman of the meeting, I told you already what is the hierarchy. Usually chairman of the company will be the chairman of the meeting. If not, authorized director. If not, select a director. If not, from members, you guys can select and go ahead. How? Show of hands. If that is also not satisfied, you have to demand for poll. Clear? And when you take up the poll, whoever becomes the chairman there, he will continue to become the chairman for the rest of the meeting. Clear? Section 105, best friends. Who's that? Proxy. Clear? Sir, who can we appoint? Anyone we can appoint as a proxy except in case of Section 8 company. In Section 8 company, even proxy should be a member. Clear? Right. So you have to give a letter in form number MGT 11. Clear? Those who want to inspect the proxy form within 48 hours before the meeting, they can inspect. Clear? Sorry, 24 hours. And before 48 hours, you are supposed to Deposit. Clear? Okay. Right, sir. Sir, what if proxy and member both attend the meeting? Both are valid. What if both vote? Only members' vote will be considered. Clear? Next. Voting. Sir, how do you can vote only on all resolutions, but you cannot vote only in 3 situations. What is that? Number 1, non-payment of call money. Number 2, any other due not paid. Number 3, right of lien exercised, not having. I told you, having lien is different, exercising lien is different. Okay. Then 101, voting by show of hands. What is show of hands? Raising your hand and voting. Clear? Then voting through electronic means. I showed you practically, no? Yes. How e-voting is done? Yes. Yes. You have to go to respective website of your depository, log in, and then we did all those things. Yes. Through electronic means you can. Every listed company or company with 1,000 or more shareholders shall provide facility to vote at general meetings. Clear? Right. Next. Procedure. Now, if you see, previous day at 5 p.m., they have to close the voting lines. Now, here, one small question is, when previous day 5 o'clock, if the voting lines is closed, my question to you, that means resolution is passed before the meeting only, no? Yes? Technically, yes, no?
Yes, sir.
Because at 5 o'clock, voting lines are closed, no? Then, resolution is already passed there. But we assume that resolution is passed on the day of meeting. Clear? It's a deeming provision. Resolution shall be deemed to be passed on the date of meeting. Clear? Now, demand for poll. Sir, who can demand for the poll? That is very important. Clear? You need to have Aukat, Tagdi. Yes, what is that? Minimum 1/10 of voting power or 5 lakh in paid up capital. Clear? The demand for poll can be withdrawn at any point of time by the same person who made the demand. Right? Now, the duties of a scrutinizer is what? Giving same thing, proper conduct of the business. I think scrutinizer login also I showed you. Yes, report also I showed you. Yes, so these things we have to do it. Clear? Now, in case of adjournment, when should we take the poll? Within 48 hours. I told you this also one question is wrong in one of the attempts. Remember? Yes. Poll demanded for adjournment of the meeting should be taken immediately. Any other poll within 48 hours. Clear? Right. Postal ballot. Postal ballot means what? Sit at home, Netflix and chill and vote. Correct? Ballot will come to your house. Now email. Click on whatever is your opinion. Submit. Done. Once vote cast, it is final. You cannot do anything. But what we have to understand is you cannot use postal ballot for certain meetings. Clear? Right? For whom? Ordinary business, you cannot use postal ballot. Wherever directors or auditors have a right to be heard at the meeting, you cannot use postal ballot. Clear? Send notice to all shareholders and assented by majority, sir. You have to give advertisement in 2 newspapers, regional and English. Clear? Following businesses shall be transacted only by means of postal ballot. Which is that? Alteration of object clause, conversion of company, changing the RO, right? Changes in the object of the offer, differential rights, right? Variation of rights, buyback, director's election, selling your company, giving loan or extending guarantee. In all these cases, you have to transact through postal ballot. But it doesn't make sense, sir. What if my company's meeting is upcoming in the coming week or next week? Should I still follow postal ballot only? The answer is no. You can still transact through convening EGM. But in the meeting, you have to give facility to vote by electronic means. Because people who can't come, they can vote through electronic means. People who can come and vote, let them come and vote. Clear? Yes. Right, sir. Next 111. Circulation of members' resolution. If anybody wants to pass a resolution in the upcoming AGM, they have to use section number 111. Clear? They are entitled to propose any resolution at the ensuing AGM, and company should give notice to all the other members. But when should you give first? There is a time limit. If you want to pass a resolution, 6 weeks before the date of meeting you have to submit. Any other resolution you want to pass or any other discussion you want to make before 2 weeks before the date of meeting you have to give. Sir, what if after giving notice also? They are not able to hold the meeting on that day? They hold it earlier. No problem. Your requisition is still valid. Clear? Right. Now, 112, 113 is about president, governor and corporation. We have already spoken about this. If they appoint a representative, it is as good as member only is coming and attending. OR and SR. How do we pass OR? Simple majority. Clear? SR. For every no, minimum 3 yes should be there. And that's when we say OR is passed, SR is passed. Now, resolutions requiring special notice. What is special notice? If a company is giving notice to member, normal notice. Member is giving notice to company is called special notice. Clear? Now, how many people can give special notice, sir? 1% of total voting power or shares not less than. And when we say 5 lakh, we mean face value. Clear? Now, you have to still give 14 clear days meeting. Yes. You have to send notice to members within 7 clear days. If you are unable to send, give advertisement in English and regional newspaper at least 7 days before the meeting and post it on your website. Clear? Following 4 resolutions, always and always, what notice we need? Special notice. Which is those? Which are that? Removal of director before expiry. Number 2. One is removal, one is appointment. Same for auditor. We are not removing. Here, not to reappoint and to appoint a person other than retiring auditor. Clear? Yes, 144 if you remember. Sorry, you don't remember. 144 is removal of auditors. Clear? Then, AOA may provide additional situations where special notice is required. Now, sir, we can, if you remember, if quorum is not present within half an hour, we have to adjourn the meeting. Now, my question to you, in the adjourned meeting, if the resolution is passed, what date we will put?
On the date which is cancelled.
Actual date of meeting. Clear? Old resolution passed there, that date will put. New resolutions passed today, today's date will put. Clear? Let's say 10 businesses are there. 6 business resolutions already passed last week. 4 businesses today we are passing. Which date we have to put? For 4 today, for 6 that day. I told you the logic. What is the logic? Logic is when 6 resolutions were passed, people are different. When 4 resolutions are passed, people are different. Clear? You cannot say decisions are already taken for the decisions which you are taking now. Number 1. Number 2, how can you go back and tell the 4 resolutions which is passed today, we are passed on previous week? Not possible. So actual date of meeting only have to write. Clear? Deemed to be passed on the date which is actually passed and not on an earlier date. Clear? Next, resolutions and agreement to be filed. Section 117 talks clearly about what? Any resolution, any agreement that you have passed, that is OR, SR, whatever it is, you have to file with whom? ROC. Remember, for a special resolution, we said MGT 14 within 30 days. Yeah, section 117 only. Then we have minutes. What is minutes? Minutes is nothing but we are talking about reference notes of whatever has happened in the meetings. Clear? For different meetings, you have to maintain different book, right? For general meeting separate, board meeting separate, creator meeting separate, then class meeting separate. Clear? Right. Shall be prepared within how many days? 30 days of conclusion of meeting. It shall be consecutively numbered. Sir, along with the date of such entry you have to prepare, right? All appointments made shall be included in the minutes of the meeting. Every page shall be signed or initialed, and last page full sign you have to. I think I've shown you also, right? Remember I signed and showed you. Yes. Who is supposed to sign? General meeting, chairman of said meeting or director authorized by board. Board meeting, chairman of said or succeeding meeting, because you can't appoint member as chairman here, only directors. For resolution passed by postal ballot, chairman of board within 30 days of. Okay. Sir, in this everything will be there? No. Defamatory, irrelevant, nonsense matters will be left out. Clear? Preservation and maintenance, sir. Who should maintain it? If it is a general meeting, keep it at registered office, preserved permanently. Who is a custody? CS or director authorized by the board. If it is board meeting or committee meeting, same. Exactly same. Clear? Yes. Inspection. Who can inspect? Anyone other than director or creditor. Clear? Minimum 2 hours I have to give. If people want to take a copy, take. If you ask for a soft copy, free of cost. If you ask for a hard copy, obviously you'll have to pay something. Within 7 working days, I'm supposed to give you your minutes. Section 120, maintenance and inspection. Right? Now, every listed company or company having 1000 shareholders, debenture holders or security holders shall maintain in what form? Electronic form. What is that? Sir, whatever register you are maintaining, record, register, minutes, everything should be maintained in what form? Electronic form. Who is the responsible person? MD, CS or any other director? Clear? If you want to reproduce. How much? 10 rupee per page. Yes. What?
Section 119. What do you mean by OAD?
Sorry? Officer in default. Officer in default. Whoever is the officer in default, he will be paying. 121, report on AGM. Who should file report on AGM, sir? Listed public company should file report on AGM in form number MGT 15 within 30 days of your AGM. Clear? Now, applicability of chapter 2 OPC. For OPC, majority of the chapter is not applicable. Clear? But ordinary business is still applicable for him. Right? He has to adopt financial statements. He has to appoint director. He has to appoint auditor. Clear? All those things are as usual applicable for him. Right? Now, sir, in the minutes, who should sign? One director is there? No. If that fellow signs only, board resolution is passed. Clear? Because minimum one director we have. Yes. So, in the resolutions, if he signs in the minutes book, it is as good as the resolution has been passed. Right? This is your section number 122. With this, the management part of meetings is done. Clear? Yes. Right. Now, we are left with what only? Directors and administration part. Clear? The section number 88 to 95. No.
No, until 91 yet.
No, we are not done. 88 to 95, we are not done. No, it's not done. Not done, no.
Oh, tomorrow night you're
No, I think day after tomorrow early morning.
but you said that you will be reaching the whole day
Yeah, because other things I have to finish the marathon.
for the night.
So tomorrow probably till 2 o'clock if I take up the classes. Then I thought of finishing negotiable instruments by uh, 2.5 units are pending.
Yes, but tomorrow so but it is not that much.
Third is done. I think unit number 2 is pending, 4 and 5 is pending. 2, 4 and 5 is pending. Nothing. Tomorrow night flight is at around 7:50. That means I have to be there by 5 o'clock. If I have to be there by 5 o'clock, by 3:34 I should leave here. 3:30 I have to leave here. Right. So 3:30 I have to leave now. I have to finish my class by 2 max and go finish off everything, have lunch and then go. Rush. So what if my class goes till 2?
Then
Class goes till 2:30. Clear? Then what if I have marathon pending? So if I keep that in mind, probably next day morning 6 o'clock is the flight. So I'll go at around 2:30 to airport night. There only I'll sit. 6 o'clock, 6:10
you
morning.
have to be there by 2:30.
No, 2:30. If I sleep here, gone. I'll not get up. So if I go there and sleep, there only I can get up and finish.
So we are dealing with administration.
Right. Section number 88 to 95, which talks about now chapter number 7, management and administration. Right. Section number 88 to 95. 88 talks about register of members ROM. Now again, it's a quick revision for us. Clear? Right. No problem at all. As long as we are getting marks out of it. Clear? Yes. Now, where do we keep ROM? First of all, question: should every company maintain ROM? Yes, mandatorily you have to maintain ROM. Where you have to keep, sir? A register office. Sir, can I keep in some other place? Yes, provided 2 conditions. SR should be passed and minimum 10% of the people, total members, should stay in that particular city. Correct? Yes. Sir, if the company is limited by guarantee, obviously they don't have share capital. So these are the following information that they have to keep. Then, maintenance of index, is it mandatory? Only for people, companies where 50 or more persons are there. 50, less than 50 need not have index. Beneficial owners will keep their own register. It is as good as register kept by the company itself. Clear? You have to maintain a foreign register. Clear? As long as you are maintaining a foreign register also is a part of our own company's register. Clear? But periodically you have to keep sending us the information about it so that we'll update it in our principal register, right? Then section number 89 talks about declaration of beneficial interest. Now, what does beneficial interest means? Somebody's name is there in ROM as a registered owner, but he is not enjoying the benefits of it. What are the benefits of a share? Dividend, bonus, rights, etc. This someone else is enjoying. So 89 says both have to come and give me a declaration. Clear? Then MGT4, MGT5, if you remember. Registered shareholder, MGT4, beneficial, MGT5. If changes are made within 30 days, company has to make the changes. Clear? ROC has to make the changes in his register. Right, sir. Then section number 90 talks about what? Register of SPO. This is very important when it comes to reference of section 216. Right? Investigation into the affairs of the company. There if you have to investigate as to who is the person who's controlling. Here, if you remember, we had spoken about Louis Vuitton company. Remember? Louis Vuitton and Bernard. Yes, how they end up taking money or taking shares and control. Yes, similarly, indirectly, if you're taking shares from other people of the company only, you give money and ask them to buy, you control the company. So, to avoid hostile takeover, to avoid bringing down of the business unethically, we have to follow this particular section where you have to maintain the register. In future investigation, it will be helpful. Clear? How many, what is the percentage? 10% or more if you hold indirectly. Indirectly 10% or more, or with direct interest, if it is 10% or more, then you have to file a particular form called PEN 1. Clear? Yes. Now, this particular register, any member can come and inspect, no issues at all. Company will give notice to whom? Significant beneficial owner who they believe. Number one. Number two, knowledge, who they believe that this person has knowledge of identity of SBO. Then, sir, in the last 3 years, if this fellow has a significant beneficial ownership. Clear? The above information should be given within 30 days. Number one. Number two, if they don't give within the next 15 days, I can go to the tribunal and do what? Ask for suspension of rights, permission to suspend the rights. Clear? Yes, sir. Next. Sir, agreed party, if you want, you go for relaxation or lifting within 1 year from the date of order. Very important. Clear? 1 year is very important. If no application has been done, I will transfer the shares to IEPF. Okay. Section number 91, closure of ROM. I can close the ROM for how many years? How many days maximum?
30 days.
Minimum?
Nothing.
Nah. Minimum, no number of minimum mentioned. Even 1 day also you can close, 2 days also you can close, but maximum 30 in one stretch. And aggregate 45 in a year. But you have to provide advertisement in newspaper. If you don't give, no problem. Private company are exempted, provided you have to give notice to all the members. Clear? 92 annual return. In what form normal companies will file? MGT 7. Clear? Yes, annual return for a reason. Right? OPC, small and dormant company, MGT 7A. Chotu Tala. Okay? Right. Correct. What are the particulars? Business details. Directors details changes, shareholders changes, remuneration, penalty, right, and meetings details should be given to them. Then signing, who should sign? If director of the company and company secretary, but company secretary is not there. CS in practice, where OPC, director and CS, if not only director. Clear? Certification, who should do? CS in practice. Form number MGT 8. Who should do the certification? Which company? Listed company or any other public company having paid up capital of 10 CR or more, turnover of 50 CR or more. Yes, sir. Then due date within how many days? 60 days. If AGM held, AGM did not be, cannot be held. No problem. Even if AGM was not held 60 days from the due date of AGM, if AGM is held 60 days from actual date of AGM. Right. 94. Sir, other registers can I keep in any other place? Yes. Where? Generally registered at office. If not, any other place, provided SR has to be passed, 1/10 of members should reside there. Clear? If you want, you can go and inspect. If you want to take a copy, take a copy. No problem at all. 50 rupee for inspection, 10 rupee for taking the copy. Minimum 2 hours in a working day should be allowed. Clear? Working day, not on non-working day. But following information will not be given. Very important. What is that? Address or registered address, email ID, identification number, PAN will not be given. Maintenance. When should I, how many years should I maintain? ROM, foreign ROM, permanent. Debenture holder, foreign debenture holder, 8 years. Then Other registers, other returns, 80. Clear? Right, sir. Okay. This is your section number 88 to 95, and this completes our chapter number 7, which talks about management and administration. Right. Next chapter is about, last chapter is about directors, and last chapter for your corporate law paper, section, that is your 40 marks of it. Right. Director, here what we'll talk about is role, responsibility, qualification, disqualification, appointment, retirement, resignation, removal, remuneration, powers and DIN. Clear? Now, who is a director, sir? I like the definition of the director. Director mean a director appointed to the board of a company. Clear? Who is that? God alone knows. Clear? Directors, apart from being trustees for the assets and proprietary for the company, are also the agents of the company, as it is a directors collectively as a board act on behalf of the company on all matters except those specifically reserved for company to act. Who appoints them? Shareholders. Therefore, they are agents. Clear? They talk on behalf of company. They have to work on behalf of company. They have to work for the company as well as the shareholders. Clear? In case of association or other bodies registered under companies under section 8, the members of executive committee are directors for the purpose of the act, though they may not be called by that name. Clear? In section 8 company, they will not tell board and all. If they say members of executive committee, it is as good as board of directors only. Clear? Definition of an officer includes what? Director as well as any person under whose directions or instructions board or any one or more directors are accustomed to act. These are called officer. Clear? Now, section 149 clearly says only an individual can be appointed. Therefore, body corporate, AOP, association of persons, or firm cannot be appointed. No, you read the entire sentence. No body corporate can be appointed. Basically, these people cannot be appointed. Clear? What are their responsibilities, sir? Very easy. Act as per AOA. What AOA has given you the power, go as per that. Number 1. Number 2, in good faith, you have to promote the objects of the company. Meaning what? What is good faith means? Honestly, having no dishonest. Clear? Having no dishonest objective, with honesty, promote the objects of the company for the benefits of the company as a whole and in the best interest of the stakeholders. Director of the company shall exercise his duties with due and reasonable care, skill and diligence, and shall exercise independent judgment. So whatever you are doing, you should be independent, is what they say. Very biased habit should not be there. Biased mindset should not be there. Director of a company shall not involve in situation which he may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. For this reason only, in section number 7 incorporation, we give particulars of interest. We give a declaration, right, that we hold so many shares in this company, we are a partner in this particular firm, right? So under section 7, when we give that, it is more useful, because whether we have a conflict of interest or not, we will get to know through that. Clear? Now comes the incorporation of company. In that, one of the point of documents to be filed, in that I think point number G in our material, where we have spoken where interest of the director should be given during incorporation. After incorporation, under special resolution, that is explanatory statement, there we have to give. In case if you are holding any interest, there we have to give in that particular meeting. Okay. Now, director of the company shall not achieve any undue gain or advantage. Meaning what? What is undue gain or advantage? What is undue gain or advantage? Not gaining in legal means. Clear? To unlawful or illegal means. Cheating, dishonest, fraud, these things should not be there. To whom? To either himself or his relatives, partners or associates. Clear? He shall be liable to pay an amount equal to the gain of that company. So in case if you get the gain, you have to refund it to the company. Clear? You shall not assign your office or any assignment, and anything if you made such things are void. What do you mean by assign? You can't give your office to someone else. Your office is your office, none of their office. Here, you can give to you only. You cannot give it to others. Assignment was, don't ask someone else to come and work instead of you. Then director identification number. In case of every company, whoever has to be appointed as a director, they must have director identification number. Clear? Now, in that section 153 talks about CG may prescribe any number which shall be treated as DIN. Currently we have DIN only. Yes. Tomorrow, if they say no, this is not DIN, this number will be DIN. Any other number, whatever they mention, that will be called as DIN. Yes. Now, in this I told you one exceptional extra out of syllabus bouncer question was asked. Surrender of DIN. Remember, in the book we had written the answer. One 5-line where he doesn't want to become a director, where is unsound mind, disqualified to be a director. Clear? In the book we had written the answer. I think it's a December 24 question paper. Written, no? Should be there in the book only. Dictated. 7 marks question. I remember telling you, only short, 4-5 lines were there. Notebook. I think it's in the notes only I've written. DIN. I showed you the question. Surrender of DIN, I think 5 points I had given, 5-6 points I had given. Remember, I clearly remember, it's there in the notes. Exactly, yes. DIN was obtained in wrongful manner. He surrendered the DIN. Death. Ratan Tata's example we had taken, if you remember. Next, disqualification. No problem. Come to disqualification. Hidden question. 7 marks. In case of disqualification, section number 164 subsection 1. Which director will be disqualified, sir? Number 1. Unsound mind person. Clear? Declared by court. You can't say, hey, mad fellow. Court should tell, hey, mad fellow. Clear? Undischarged insolvent. What does undischarged insolvent mean? Insolvency means what? Unable to repay the debt. Undischarged means what? Declared, but payment is not yet done. Applied as insolvent, but application is pending. Convicted by a court of any offense, whether involving moral turpitude. What is moral turpitude? Cheating, honesty. I'm sorry, dishonesty. Honesty is not moral turpitude. Clear? Cheating, dishonesty, all these are moral turpitude. Embezzlement, stealing. Yes? Then, sir, and sentenced for imprisonment for not less than 6 months and a period of 5 years has not lapsed. Meaning, if you go for 6 months to 7 years, then 5 years imprisonment. More than 7 years if there is 6 months to 7 years temporary disqualification, 5 years disqualification, whereas 7 years or more permanent disqualification. Clear? Yes, right, sir. Then if he has been disqualified by courts or tribunals order, he has not paid call money, clear, for the shares held by him, whether alone or jointly with others, and 6 months have elapsed from the last day fixed for the payment of the call, convicted of an offence dealing with RPET under section 188 during the last 5 years. Clear? Then he has not complied with section 152 subsection 3, that is, he doesn't have a DIN. Now, same thing only they have given in the exam. Clear? Not complied with provisions of 165 subsection 1. Clear? Now, in that case, no person who is or has been a director of a company which has not filed a financial statements or annual return for any continuous period of 3 financial year, continuously 3 financial year, if you have not filed financial statements or annual return, which means both has to be filed. If you don't file both or if you don't file any one for the last 3 financial year, you are disqualified. Clear? He has failed to repay the deposits, redeem any debenture or pay any dividend declared. Be very careful, declare dividend. Clear? Such a failure to pay or redeem continues for 1 year or more. So minimum 1 year, if you have not paid this, you are disqualified from becoming the director. Now in that case, all of you should vacate. Clear? And some other person will be taken care of as a director. Now the question is, shall be eligible to be reappointed as and when you correct the default. But when, sir? As a director of that company or appointed in other company for a period of 5 years from the date on which said company fails to do so. Meaning what? Eligible to be reappointed When for in another company for a period of 5 years from the date on which the said company fails to do so, provided that where a person is appointed as a director of a company which in default clause A or B, he shall not incur the disqualification for 6 months. Meaning, now here you have not filed for 3 years, here you have not repaid, which means you are disqualified. Someone should come in that place. For him, 6 months time is given. 6 months time, within that 6 months, you are supposed to file it and finish the repayment. Then you are, or else you will also be disqualified. 6 months gap is given to you. Shield, clear, immunity. Right. Private companies, if they want, they can have some other disqualifications within their AOA. Appointment. We have already discussed this in regular class in section 3. If you remember, initially we have discussed it. Clear? For a public company, minimum 3, private 2, OPC 1, maximum. If you want to appoint more than 15, pass SR. Clear? Retirement and rotation. If you remember this, good concept. We have solved it also. Yeah, in class we had solved. Now. Huh?
In class.
Correct. One test also was given on this. Retirement and rotation of directors. First you have to retire. Clear? But retirement by rotation. Okay. Now, if AOA provides for retirement of all directors, then all directors are liable to retire. Clear? It's not liable to directors. Liable to retire. Then, how much is the liability, or how many people are liable to retire? 2/3 of total number of directors are liable to retire by rotation. That means other 1/3 are safe. Yes. Out of 2/3, how many will retire actually? 1/3 will retire. Understood? Out of 2/3, 1/3 will retire. That means out of, let's say, 15, first 2/3, that is 10. 10 are liable, 5 are safe. Out of 10, 1/3, that is nothing but 4. 4 people should retire. Which 4 will retire? Oldest one will retire first. In that order only will go. Sir, what if all are appointed on the same day? Mutual consultation. Okay, mutual agreement. Sir, that was, there is also no consensus there. Then lots. Remember, first is 1/3 oldest. If that doesn't work out, mutual. That doesn't work, lots. Clear? Okay, sir. Now, sir, if 2 or more appointed on the same day, as usual, mutual understanding. If that also is not done, draw by lots. Right? Unless the articles provide otherwise, for retirement of all directors at every AGM, not less than 2/3 of the total number of members shall be persons whose period of office is liable by retirement by rotation be appointed by the company in the general meeting. Meaning, there only we can retire them, there only we can reappoint them. Clear? Okay. The remaining directors shall be appointed as per the provisions of AOA, meaning direct appointment. For retirement of directors, in the AGM only they retire, in the AGM only they get reappointed. Where a director retires by rotation at the AGM of a company at the same meeting may appoint, that is the retiring director only, or some other persons in the vacancy. Now imagine these 4. In these 4, A, B, C, D. Okay. Members will tell, we don't want A, but B, C, D we want. So B, C, D are reappointed. Instead of A, what you will do? You will appoint someone else. Clear? Then, resignation, sir. Can the director give resignation? Yes, sir. He can easily give resignation. By how, sir? By giving a notice in writing. On receipt of such notice, what should board do? Take note of the same, and company shall intimate the ROC. Clear? Now, if the director also wants, he can go and tell the ROC. Clear? In such a manner, within such time as may be prescribed, and shall also place the fact of such resignation in the director's report in the immediately following general meeting. It could be AGM or it could be EGM. The next meeting only have to disclose in the meeting that we have left. I mean, the director has resigned. Clear? Next. The director may also forward a copy to ROC. Why? If you have a doubt that the company will not send it to them, you can send it to them. Understood? Clear? Then, a resignation shall take effect from the date on which the notice is received by the company or a date mentioned in the notice, whichever is later. Clear? Logic. Sir, in the notice, imagine 1st May is there. Company received on 10th May. Resignation is effective from 10th May. Clear? Sir, on the date of company received the date notice on 1st May, but in the notice he is saying from 10th May I will resign. So which is the date? Again 10th May. Clear? Whichever is later we have to check. Okay? Right. However, under section 168(2), the director who resigned shall be liable even after his resignation for the offences which occurred during his tenure. When he was there, whatever mistake he had made, for that he will still be liable. Clear? Right. Removal, sir. Who can remove? Shareholders or tribunal. Under 169, shareholders have been given the power to remove. It is not necessary that there should be a proof of mismanagement. If they want to remove, they can remove directly. Clear? Next. Where the shareholders feel the policies pursued by the directors or any one of them not to their liking, they have the option to remove the directors by passing OR. In the same way, they have the right to appoint the directors by passing an OR. Removal also OR, appointment also OR. Understood? Clear? Next. Company by ordinary resolution remove a director except director appointed by tribunal under section 242. Clear? There we cannot remove them. That is operation and mismanagement section. There, if the tribunal has appointed you, except the director, all other directors can be removed by shareholders. Clear? Or even tribunal for that matter. Now, the vacancy is created after removal. Now, in that case, then in the same meeting of the removal, another director is being appointed for the time being. Special notice is provided. Clear? So, if you want to appoint, remember 169, we did there. Section number 1115, special notice. Yes. The newly appointed director has to hold the post until the duration of new formal appointment of the director is made. Clear? Okay, sir. Sir, it was held that director notice must disclose the grounds on which director is proposed to be removed. You can't simply say we are removing you. At least tell why you are removing us. Clear? Right. Next. Remuneration. Sir, how much we should pay? Who should pay is a question. Sir, remuneration payable shall be determined by whom? AOA or resolution. Which resolution? General OR only, but SR if the article requires. General OR. But if AOA says SR, where we have to pass general meeting. Okay. Now, the remuneration payable to such director determined as per the said provision shall be inclusive of remuneration payable in any other capacity. Remuneration includes everything. Clear? All inclusive should be how much? Maximum 11%. Clear? But sometimes company may make no or inadequate profits. There also you have to give minimum to minimum remuneration as may be authorized. Maximum how much? 11%. Minimum as may be prescribed or as may be decided. Okay. Now, a MD or WTD maximum 5%. More than one such director 10%. Yes. Now, if a director is paid remuneration for special services apart from director services, then such amount also must be included for that 11%. But only one case. One case. If you have given professional services apart from director. Clear? Professional services apart from director services. For that, you cannot include that in the 11%. Two conditions you have to satisfy. One, whatever services you have given should be in what nature? Professional nature. Number two, you have the requisite qualification for that. Who should say this? Opinion of nomination and remuneration committee. They should say. Understood? Clear? Okay. Sorry? For this also we have taken a test. Correct. Right. Sir, what if such committee is not there? Then board can form this opinion. Clear? Yes. Powers, very important. This also we have taken a test. Powers. No? Correct. No, powers was asked in the exam. Correct. Previous question I told. What is the power, sir? Very simple. You can make call. Number one. Number two, buyback. Number three, issue. Number 4, borrow, invest, grant loans or give guarantee, approve financial statement, diversify business, approve amalgamation, take over, any other matter. For these powers, what resolution we will pass? Board resolution. What resolution? Board resolution is good enough. Clear? Now, provided the board by resolution passed at a meeting, delegate to any committee of directors, the MD, the manager, or any principal officer of the company, or in case of a branch office of the company, principal officer of the branch, the power specified in clauses D to F, such condition as it may specify. Meaning what? Simply, you can delegate if you want. Clear? Delegate means what? Ask someone else to do your job. Okay? Right. Next. Powers and duties of auditors and auditing standards. Clear? Now here I told you very easy to understand certain things. Only keywords you have to remember. What is the power of auditor, sir? Right to access. Clear? Inquire from the officers any information and explanation. Right to access of subsidiaries books only for consolidation purpose. What are the duties? Inquiry matters. Clear? Whether loans and advances are properly secured. Whether merely by book entries, whatever transaction you have included, are they prejudicial to the company? Clear? Are they affecting negatively to the company? Then, in case if you have sold any assets, did you sell for less than cash? If yes, we have to mention it. Clear? Then, whether loans and advances shown as deposits, personal expenses charged to revenue. In case if you have given shares for cash, whether cash has actually been received, and if it is not given for cash, then whatever money or whatever kind you have received, have you disclosed it properly in the balance sheet? Right? Reporting over accounts, nothing. Accounts examined by him, laid before the every financial statements you have to check, which is laid before the general meeting. Nothing great here. Other elements or audit report. I think I had asked you to read audit report for this.
Yes.
Yes? Correct. Main thing is fraud reporting. Remember fraud reporting? One chart we had made in the class. Check. No, fraud we had prepared. 143 subsection 12. Later on, I think you didn't write, huh? What? Oh no. Now, in fraud, if you remember, do you remember? Yes. Yeah, section number 143 read with rule 13. Yeah, if the fraud is less than 1 crore, if the fraud is more than or equal to 1 crore. If it is less than 1 crore, what is the first step?
Report to BOD.
Report to BOD within 2 days of knowledge. Then BOD to disclose in their report nature, amount and parties involved. If the fraud is more than 1 CR, report to BOD within same step. Seek reply within 45 days from BOD. If they respond, forward 3 things: report, reply and comments. If they do not respond, forward the report and statement saying we have told them they have not yet responded to us. Clear? Here within 15 days, here right after expiry of 45 days. Step 3, forward to CG in ADT 4, RPAD, letterhead of auditor. To whom? Secretary of MCA. Then BOD to disclose in their report nature, amount and parties and actions taken. Clear? This is the chart for fraud reporting which we had done. I hope you remember now. Okay. Yes. Then we have provisions with respect to audit committee. In this case, The BOD of every listed public company and such other class of company shall constitute what? Audit committee. Minimum how many members? 3 directors. Who should be majority? Independent director. Now, majority of members of audit committee, very good. They should have ability to read and understand the financial statements. This I told you the logic also why. Initially, although we joked here, but I told you why. Not everyone are from commerce background. Clear? What if some people are from science background or any other background which they don't know what is financial statement? Clear? Now, sir, audit committee of a company existing before commencement of this act within 1 year shall be reconstituted. There were audit committee before also, but under 2013 the composition is different. Therefore, they're telling you should reconstitute it, meaning dissolve your previous committee. Clear? Reconstitute under new one. Okay. What is their particular role? Recommendation of appointment, reviewing and monitoring, examining FS, approval of modification with RPT, etc. Clear? Omnibus approval. Remember? Yeah. Here is where recommendations to make in RPT, all those things. Scrutiny of intercorporate loan, valuation of undertaking, IFC evaluation, internal financial control, risk management system, end use of funds raised, public offer, that is initial public offer, FPO, OFS. If you receive the money, what are you doing with that money? Audit committee can go and refer to it. Clear? Comments about internal control system, authority to investigate. They have auditors of a company and KMP shall have a right to be heard in the meetings of audit committee, but cannot vote. Clear? Then board of directors should disclose the composition of audit committee in their report. Clear? Every listed company shall establish vigil mechanism. What is vigil mechanism? Vigilance, meaning what? Being alert. Anything wrong happens, they should be alert and they should inform. Clear? To report genuine concerns. Now, victimization, sir. Whoever comes and tells, we have to protect them. Clear? Otherwise, they could be victimized in the entity. Okay? Right. Then we have rights of shareholders. What are the rights of shareholders? First of all, this we have done in chapter number 4 as to how can you become the member of a company. Remember? Miscellaneous concept. Holding the demat, applying for the share, estoppel. Clear? Same thing. Same thing. Point number 1, 2 and 3 talks about. 4. Apart from signing memorandum, 2 prerequisites are there. Agreement in writing to take up the share of the company, registration in ROM. This also we have seen in chapter number 4 only. Okay. Now, sir, a person can agree to take shares of the company either as a subscriber or in the following manner. Next time, whenever they give new shares, you can buy it. Then you'll become a member. Number 2, transfer from an existing member. Number 3, purchase of share. Number 4, acquisition by devolution. What does devolution means? What is devolution? See, let's say one company demerged or one company merged. Now, let's say 2 companies got merged together. Now, the new company share also will be given to me because I'm holding shares in old company automatically. Clear? Then, now see, for example,
We have taken as, this example is as like another bird. The powers will be given to you automatically.
transmission. That's called transmission. Transmission of shares from father to son is nothing but devolution.
If I'm there, நான் இப்போ இன்னொரு இடத்துக்கு போறேன். அந்த பவர்ஸ் எனக்கு அங்க தான் இருக்கணும்னு அவசியம் சார். ஆல்ரெடி
You're talking about ex officio. That comes in labor law. On conversion of convertible debentures or loans, you can get the shares. Convertible loans, convertible debentures, if you have, you can get the shares. Clear? Fundamental difference between subscribers and people who take shares later is one is during incorporation, one is later on. Okay? Now, what are the rights? Important. Point number 7. Important rights. Right to vote on all meetings. Requisition and extraordinary EGM, section 100 if you remember. 101, right to receive the notice. 105, appoint proxy. 113, body corporate can appoint one person and he will have the same rights as body corporate. 111 circulation of members resolution, you have a right. Section 56 getting share certificate after transfer within 2 months. Clear? We have seen this in share certificate. In section 46 we have seen about this. Clear? Then section 44, that is transfer of shares. 44 is nothing but nature. I told you, hey, do you remember in Sale of Goods Act definition? Goods means every type of movable property includes stocks and shares. So share is nothing but goods, movable goods. Clear? Then section 94, inspecting the register of members. 119, you can inspect the minutes book. 48, going and applying to the tribunal in case of variation. Remember, 10%, yes, you have to hold. Then to participate in removal of directors by passing OR. Certain other rights, what do we have? Elect, this is as per Supreme Court. Elect the directors, therefore participating in management through them, enjoying the profits in the shape of dividend, applying to the court, which is now tribunal, in case of operation, mismanagement, winding up, and sharing the surplus in winding up. More focus on this part. Clear? Under the Act, what are the rights? Not as per Supreme Court. That's an additional thing. Clear? Under the Act, what are the rights? You have to understand. Clear? Yes. Right, sir. Sorry? This is one repeated topic, if you remember. Operational and financial control. Clear? Now, what is financial controller? What is an operational control? Very simple. Operation means business. On this, we had an in-depth discussion of ArivuPro. Clear? Who is handling operation? Who is handling finance? How, an example, situation we had taken. Correct? So, a person who is in charge of operation is different. A person who is in charge of finance is different. Operational control is job title specifies responsibilities of a particular part of a company. So, those duties vary from business to business depending on its operation. Not every business's operation will be same. But most of the businesses, finance department will be same. Payment, receipt, accounts, financial statements, clear? But operations from person to entity to entity, business to business will be different. While there are some similarities between operations and business controller versus financial controller, there are definitely two distinct roles within an organization. One handles only money, doesn't know what is happening in the business. One handles only operation, doesn't know what is the budget, what is the percentage, what is the buffer, nothing he will know. Clear? Both involves budgeting, forecasting, financial reporting. The financial control deals with organizations' daily accounting operation. It includes overseeing accounting, payroll, payable, receivable departments, etc. Which one? Financial. Clear? Then, managing the organizational budget, preparation and publishing of regulatory and monthly financial reporting, and gauging fiscal efficacy, that is efficiency. Okay. Unlike financial controller, role of operation includes reporting and budgeting, including fiscal reporting within larger company of a particular unit. This is important. You do for the money, I do it for my department. Clear? Because I am in charge only of that department. Okay? Like how in Singham Hilton, you may have so many police stations, but this is only, I am the only one in charge here. So it's my duty to report budget, forecast, financial statements, everything under my control in this particular unit. Clear? In this I find very less chance of asking questions. Clear? But you never know MCQ can be asked, or like we have seen, on 5 pointers can be asked for 7 marks. Clear? But nevertheless, just go through it when it's a general topic, nothing specific. I hope you know the difference between operations and finance. Operation is where business is taken care, face of the company or face of the organization. People will see operations. You will never come to ArivuPro and you will not take an admission here because you are doing profit or loss. You are joining here for what? Class, whether facility is good, class are doing on time or not. This is called operations. Clear? Whether the team is working fine or not. Yes, that is the main part, and that is operational controller. Clear? Financial control is one your admission fees, right? Where to invest. Now one more branch if you are opening, where to invest that. Clear? How much remuneration to give. Those are financial controlling, budget, forecasting, everything. Understood? Clear? Yes. This is your director's portion. With this, corporate law entirety is done. 40% of your portion is revised in a rapid manner. Clear? Yes. Right. Let's start with labor laws. We have EPF, ESI, gratuity, code on wages. Okay. So let's start with the EPF first. EPF and ESI, very small acts, easy act. Then we'll go to Factories Act after that. Okay. Now, EPF and Miscellaneous Provisions Act, 3 schemes are there here. One is PF scheme, Provident Fund scheme. Second is pension scheme, and third one is insurance scheme. So for all schemes, you will have to contribute. Okay. But for all schemes, employer contribution will be there. Employee contribution not for all schemes which we are going to learn. Okay. Now, sir, why did we get this PF Act? Our objective is to give social security and timely monetary assistance, because not all employees will have that habit of savings. So when they don't have the habit of savings, what they tend to do is they tend to, whatever salary they get, they might start spending it. Now that means for your future generation, nothing will be there. So to provide that security, EPF is there. All right. So please remember, EPF objective, if they ask, social security and timely monetary assistance. Basically for what? Industrial employees and their families when they are in distress. Distress means what? Problem. Clear? Applicability, very important. Applicable for every establishment. Here it is not company, firm, everything. Any establishment which is a factory where 20 or more persons are employed. So minimum 20 employees if are there in a factory, applicable. Then to any other establishment employing 20 or more, which the central government may by notification specify. Basically any employment where, any establishment where 20 or more people are there. Then in case of 20 or less are there, then CG might specify. That means according to government, they feel that you need to have EPF. That even though you are less than 20, if CG says for you EPF is applicable, you have to register for EPF, then they will have to register for EPF. And in case of voluntary registration, some employer will tell, even though for us it is not applicable, we want EPF so that our employees can have pension after their retirement. So for them also voluntary possible. But one thing you have to remember, employer and majority of the employees, not all. Clear? Not all. Not all. Majority of the employees, if they have agreed, then from the date of such agreement, any subsequent or from any subsequent date specified in such agreement, EPF is applicable. Either date of agreement or in the agreement they have mentioned a particular date, from that date. Clear? From any subsequent date. We always remember that once applicable, always applicable. It's not that once applicable and then you come back to 19, then no sir, PF is not applicable. Once applicable, always applicable. EPF, ESI. Clear? Bonus, gratuity. All these are once applicable, always applicable. Non-applicability for cooperative societies where you have less than 50% not applicable, provided it is without the aid of power. Now here, what is the meaning of with aid of power and without the aid of power? Without using the power for manufacturing. Clear? That doesn't mean light fan and all they'll not use. They'll use it. But for manufacturing process, they will not use power. Like for example, handicrafts. Clear? Potteries. Right? Now handmade coffee mugs and other things. Now in these cases, they don't use power. Clear? So in those cases, if it is less than 50, then EPF is not applicable. Then central government or state government, if they have already their own scheme, EPF is not applicable. For new establishment, up to initial 5 years, EPF is not applicable. After that, it starts becoming applicable if it is 20. Okay. Then now definitions: appropriate government for railway, port, mine, and any controlled industry having departments or branches in more than one state. Also for you it is central government. Any other establishment, state government. Railway, port, mine, or controlled industry, or any establishment having multiple branches across the state, or sorry, across the country, more than one state. Like if you are having many branches, that means we will be, for you, who is a government? Central government. In any other case, it is state government. Okay. You can use it as that way. Prime. Clear? Use it, no problem. Next one, authorized officer. Sir, who is this authorized officer? We have seen this. Topmost comes as central PF commissioner. Then we have additional central PF commissioner. deputy PF commissioner, regional PF commissioner. Not a big deal. Basic wages very important. What do you mean by basic wages here? For EPF, basic wages definition is all payments which are earned, not given, earned while on duty or on leave or on holidays with wages as per the terms of contract of employment. So whatever you earn during your employment, that paid or payable in cash, but excludes all payments excluding what? Cash value of any consideration, number one. Number two, any dearness allowance. Sir, what is cash value of consideration? Now, if your employer has given free lunch, that is 2000 rupees per month, we will exclude that. Because they have given not cash value they have given. Okay, free accommodation 8000 per month. This is a rent in the market. No problem, we will exclude that. We will not include in the basic wages definition. Dearness allowance, if it is there, we will exclude that. Dearness allowance is nothing but to meet the cost of living. Clear? Then any presents made by the employer, any gift given, any extra money given, we will not consider all those things. Basic idea is this thing here, it is not recurring in nature. Presents or gift is not recurring in nature. So what is the definition? Basic wages is equal to all payments earned minus cash value 1, number 2 DA, number 3 gifts. Clear? These things are excluded. 3 things are excluded. What is that? Cash value, gift, DA. Cash value, gift, DA. Okay. Now, contribution. What is contribution? Nothing what the employee pays. The employee pays to the department is what we call as contribution. Fund, EPF is nothing but employees provident fund. Who is an employer? If owner or occupier, if it is a factory, factory is owner, factory is occupier. Any other establishment, anyone who has ultimate control over the affairs of the establishment. Sir, in case of factory owner, if he is dead, then we will consider his legal representative. Clear? Okay. Now, sir, also in this case, we can consider it as a manager, MD, managing agent, such manager, MD or any managing agent, provided what is the crux here? He should be in the ultimate control over the affairs of the establishment. He should have ultimate control over the affairs of the establishment. Okay. Now, who is an employee, sir? A person who is employed for wages for any kind of work, manual, automated, in connection with the work of an establishment and who gets his wages directly or indirectly from whom? Employer, and includes any person, contractor or even apprentice, but apprentice not under Apprentice Act. So if I have to give it in a short form, who is an employee? Any person for wages. Clear? But includes contractors, not contractors, contractors who will give me the employees. Clear? Then apprentice minus apprentice under Apprentice Act. Clear? Apprentice under minus Apprentice Act. That means under Apprentice Act, whoever is defined as apprentice will not include them. Clear? We will not include them here. So we will exclude them. Okay. So employees, who are employees? All the people in my establishment employed for wages by me, or through contractor I have employed, or apprentice also will be. But which apprentice is excluded? Under Apprentice Act. Okay. Factory means what? Now just factory means it's not the premise where manufacturing also happens. Please be careful here. It includes presence. Presence means what? Surrounding area also. Clear? Now imagine this is a land. This is a land. Okay. Now here manufacturing happens. Here manufacturing happens. For definition of factory, this also is there. This also is there. Sir, here just parking, sir. Considered. Clear? Considered. Sir, here it's just garden, sir. Considered. Understood? Presence of the factory as well will be considered as a definition under factory. Clear? Presence, but also, now you tell me, I told you garden is there, parking is there. Should I consider that as a factory? Huh? Now listen to the definition. That's why definition is very important. any premise including the presence in any part of which manufacturing process is being carried on or is ordinarily so carried on, whether with the aid of power or without the aid of power. Now in the garden, what manufacturing happens? Nothing. Factory, ah? No. Parking, what manufacturing happens? Nothing. Factory? No. Even in presence, manufacturing activity should go on. Sir, in the same land here, manufacturing happens, whereas here, packing happens. Now it is factory because some manufacturing activity is going on. Sir, here labeling happens. Factory only. Manufacturing one unit, packing one unit, labeling one unit, all put together is called factory. Understood? Clear? Parking, garden, park, not a factory. Because manufacturing is not happening. Understood? Clear? Right. Occupier. Who is the occupier? Whoever has ultimate control over the factory. Central board will have how many people? Chairman, vice chairman, central PF commissioner is ex officio. What is ex officio? He is appointed as a central PF commissioner. Automatically he will be appointed here. Clear? Okay, sir. Then appointment of executive committee by the central government to assist the central board. So hierarchy, if you see, central board is here. Clear? Then EC, executive committee, is here. These people will help whom? Central board. Right. Then we have state board, not that very important. Contribution. Now, how much contribution who should give? Both, whenever it comes for EPF, both will come. Who is that? Employer, and MP, employee also should contribute. Now, how much they should contribute? Your act says 10, but we know that it has been increased to 12. So, employer will give 12%, employee will give 12%. Clear? This is for what? EPF scheme. What scheme? EPF scheme. Employee will give 12, employer will give 12. 12 of what? Basic, then DA and RA. So 12% of basic plus DA plus RA. Clear? Equal contribution who should give? Employee should give. Sorry, employer should give. If they desire, they may make contribution exceeding the prescribed rate, minimum 12%. If you want to give 15, give 15, no issues, because it is good for savings only. Okay. Condition that employer shall not be under any obligation to contribute over and above the contribution payable. Meaning, sir, if employees want, they let them give 15%. Just because they give 15, I will give only 12. If an employee wants to give 20, I will give only. If employee wants to give 8, they can't give 8. They have to give 12. I will also give 12%. Understood? If an employee wants to give more, he is okay to give. Employer is no obligation. If employer wants, he can give, but you can't force him to give. Clear? Next, the government has rate we have already seen. Okay, sir. If it is, how do we consider rounding off? Nearest to rupee 50 paisa or more. If it is less than 50 paisa, lower. Round down. Okay. Right. Sir, is payment of contribution optional? The answer is no. Payment of contribution is mandatory. Everyone has to make the payment. No exception under any clause. Okay. Wage limit. Which employee, sir, EPF is applicable? Maximum of 15,000. If your salary is more than 15, we'll fix it to 15. Clear? For international worker, 15,000 is not applicable. Clear? Withdrawal, very important. Why do we withdraw? For what purpose we can withdraw? Number one, you can withdraw for purchasing your house. Clear? Number two, repayment of loan. Number three, withdrawal 1 year before the 1 year before the retirement. You're not retired yet. 1 year before the retirement, you can withdraw. Next, 75% of the balance, if not employed from 1 month or more, subject to approval of PF commissioner. That means you have not been employed. You have left the job. No one is employing you. It's been 1 month. You can withdraw 75% provided commissioner has given you the permission. Clear? Last one, what? Sir, such withdrawals are not required to be. These withdrawals, 4 withdrawals, not to be repaid. Meaning not like loan. Clear? It's not like loan where repayment is not necessary. Repayment is necessary. Here repayment is not necessary. Advances from the fund. So from where can we take loan? From the fund only we can take loan. For what purpose? Illness, marriage and abnormal conditions such as calamity of exceptional nature. Here, this is non-refundable. Here, you can take loan. See, what is the difference? Here we are withdrawing. Here we are taking loan. Repayable. Repayable. Not repayable. Next. Granted to members affected by cut in the supply of electricity, I can give loan, again non-refundable. Grant of advance to members who are physically handicapped, not refundable. Clear? These things please mark it as very important if you have not marked it. Okay, extremely important to understand why we can take loan, where we can take loan, in which amount refunding is there, in which amount refund concept is not there. Okay, all right. Can you tell me without looking at it? For what we can withdraw? Number 1, residential house. Number 2, repayment of loan. Number 3, 1 year before the retirement. Number 4, not employed. 75% they can withdraw. Clear? So residential house, loans in special cases, retirement and unemployed. Clear? Yes. Right. You can remember it as URL. Remember URL? Website's address. Yeah, go to their website and withdraw. That's how you think. Okay, that is U is unemployed. Clear? Then R is retirement, R is repayment, and L. Hey, sorry. L is loan, R is residence. Clear? Okay. Advances 5 cases. What is that? Illness, marriage, abnormal condition, electricity, and handicapped. Clear? Yes. Right, sir. Next, employees pension scheme. This is called as pension scheme. Where do we deposit the money? In pension fund. Now, when do we give pension? On what type of pension we give? Superannuation, retiring, widow or widower. What is the difference between widower and widower? A person who doesn't have husband, widow. Person who doesn't have wife, widower. Okay. Wife and husband will come out of marriage only. I don't know how you work, but we all have seen wife and husband relationship will come after marriage only. Okay, I know now. Children pension or orphan pension. Clear? Then pension scheme may provide for all or any of the provisions. How much you have to contribute, sir? No contribution from employee. Only contribution is from how much? 8.33 of what? Same. Understood? Clear? Then, contribution is not payable when the employee crosses 58 years. What pension to give you? You are almost retiring. Clear? So, for you, 58 years or more, not applicable. Then we have IDLI. Employee Deposit Insurance Scheme. Clear? Now, who should pay here? Which employees? Sir, applies to all factories and all other establishment except tea factories in the state of Assam. Okay, what is the wage limit here? 15,000. Again, same. Okay. Now, the insurance benefit will be somewhere between 2.5 lakhs to 6 lakhs. MCQ. Deposited to a fund called Deposit Linked Insurance Fund, whereas employee should pay how much? How much? If it is less than 15,000, actual amount. More than 15,000, we will fix a limit to 15,000. Maximum is how much? 15. What if it's 10? 10 or 15? 10. 8 or 15? 20 or 15? 2 or 15? Huh? 2 or 15? 2,000. That's what I'm thinking. What are you talking about? Contribution. How much you should pay? 1% of basic DA plus RA. 1% of what? Basic DA plus RA. Who should pay this? Employer shall pay amount not being more than 1% of aggregate of basic DA plus RA. Employer shall pay into the fund such further amount not exceeding 1/4 of contribution. Why? To meet all expenses in connection with the administration. And this is what we call as admin expense. And how much you have to pay? 1/4 of contribution. Be very careful. 1/4 of what? Contribution. Where monthly where the monthly pay of an employee exceeds 15,000, we will calculate only 15,000. We have already seen that now, right? Now, determination of money due from employer. Number one, whenever dispute arises, the authority may conduct such inquiry. These are all adjudication. Main concept is contribution. Clear? I'll do it. Tell me contribution, PF contribution, employer. I think I should let you go under the metro construction only. How much contribution does employer pay for EPF? 12%. Pension 8.33. Idli 1%. Admin 0.5. No, 1/4 of 1%. That is 0.25%. Understood? Employee 12%. Pension 0. Admin 0. Idli 0. Understood? Clear? So, employee, employer 1. EPF, how much will employee pay? How much will employer pay? Pension scheme, how much will employee pay? Employer will pay. Third, EDLI, employee will pay. Employee will pay. Sorry, employer will pay 1%. Clear? Fourth one, admin charge. Here, 1. Employee will pay 0%. No, this fellow will pay 1/4 of contribution. Okay. Then, determination of money due from employers. Where a dispute arises, conduct such inquiry. Okay. Reasonable opportunity of being heard will be given, and such power can be exercised. They can call you in the court of law. Clear? You have to produce the documents, affidavit, and issuing commission. Clear? If employer or other person fails to attend such inquiry, they can decide ex parte. What does ex parte mean? What does ex parte mean? Passing the order without the opposite party. Clear? And now you will tell, yeah. I have written there. Passing the order without the opposite party. It's actually wrong. Clear? But again, you are not coming only. I am giving you dates back to back. You are simply not coming. I will consider it as ex parte and pass the order. Okay. Within 3 months from the date of communication, you may apply to the authority to set aside ex parte order and obviously tell them why what is the reason of not coming to the court, what happened, etc. Tell the judge everything, and in case then request the judge, please give us one more date for this hearing. If judge feels to he has to give you, he will give it to you. If judge feels no, I am not supposed to give it, then you need not give. Understood? Okay. Now review. If you want, you can apply for review. Which review? 7A order. Clear? Discovered new and important matters of evidence could not be produced at the time of order. So in all these cases, they can appeal and ask, sir, please review the previous order, sir. In the last order, this evidence was not there. Now this evidence is there. Please go through it is what you have to tell. Okay. Determination of escaped amount. An officer can reopen the case within 5 years from the date of order passed if he has a reason to believe that omission or failure has happened to disclose fully and truly any amount which has escaped the income. If any amount has escaped the income, what is the time limit? Reopening the case 5 years from order passed. Whenever now you go to the tribunal court and they say, okay, reopen the book from that order date, next 5 years I have the right to reopen the book. Because what if you do all the golmaal in this year, adjust in the next year? So I have the right to inspect the next year also. So up to 5 years I can inspect it. Clear? Now if you don't like, you can go to EPF 80. Remember yesterday we saw NCLT. Remember? Here we saw EPF 80. That is Employee Provident Fund Appellate Tribunal. They will hear the appeal against the central government. Clear? And if possible, if they find any substance in that, they can confirm, modify, cancel, or even go against, may refer back to the authority saying what order you have passed. So that means EPF 80 has a power to modify the orders as well. Clear? Then, sir, they can rectify any mistake apparent from the record. What does apparent means? The moment we see, apparent means what? It is seen on the document right there. Apparent means now I'll tell you in simple language. Some people will come and tell, no, sir, so and so things happened. So I'll ask you, is it? You'll be like, no sir, apparently it seems it happened. Meaning somebody told us, we are just telling you, which means we're not sure about it. Right? So this also apparent from the record means when we see the document only, we get to know that there is a mistake. Such mistakes can be rectified within 5 years from the date of appeal order. When the order is passed, from there we have how many years? 5 years time. Clear? But no appeal shall be entertained until and unless you deposit how much? 75% of the amount due from him. How much you have to deposit? 75% of the deposit. Only then they will consider your trial. Now you tell me, Chumma, can you go inside NCLT and fight? No. Why? Understood? Some limit should be there. Clear? Like for example, if you want to sit in the classroom, some test should be done first. Clear? Which school does? Colleges does for admission purpose. Do you know? Entrance test? Yes. Why do they do? So that it's not that random people can come here and have fun. Only if you are serious, you will clear that exam, and only then from there they will select it. Now, protection against attachment, you can simply understand EPF amount is free from any charge. Is free from any charge. You cannot give EPF amount as security and buy a house, start a business, buy a vehicle. Nothing you can do. Clear? Only for the security of employees the EPF is created, not for your purpose. Now, just because you have to pay EPF, it doesn't mean you have to reduce his liability. Because, okay sir, if I pay less liability, obviously ESI is not applicable, EPF is not applicable. Remember, once applicable. But what if when I apply only I don't apply? Sinabhaya sir, now he has moustache. Proper moustache, beard is there, and I'm telling he is 12 years old. 14 years old. 15 years old. Not possible to believe. So as long as you believe that that particular person belongs to that particular group, then you take it, no issues. Clear? Then transfer of accounts now from one employer to another employer. Imagine from old employer you are going to new employer. Clear? Transfer of accounts are possible. Clear? Now because you generate something called as UAN, universal account number, this is same. This is what? Same for any employer. For employee only one UAN you get. For employee you get only one UAN. Any employment you go, you can apply that. Clear? It's like your roll number in ArivuPro. Anywhere you go, in old building, new classroom, old classroom, anywhere you go, whatever number, only one number. Clear? Income tax, only one number, PAN. Clear? Bank account, customer ID. Account number could be different. Customer ID will always be same. Clear? Right. This is your EPF. In this, most important thing you have to understand is one is transfer of accounts. Clear? I'll just mark it as important. Transfer of accounts. Clear? Then this 75% of the deposit. Review of order. IDLIs. This is important. IDLI, pension scheme and provident fund is important. Understood? Clear? Yes. This is your Employee Provident Fund Act. Next, ESI. Again a small act. Employee State Insurance Act. Contribution is less. Now what is the objective of this particular act? The objective of this act is to provide certain benefits to employees in case of sickness, maternity and employment injury. Clear? Three things: sickness, maternity and employment injury. Okay. Now, not only that, to also provide social protection to employees in case of contingencies due to sickness and illness because of employment, medical facilities to legal dependents, meaning your family, anyone who is dependent on you and you are the only earning member in the family, something happens to your family should be taken care. Clear? Then benefit in case of maternity and employment injury. Clear? Clear? Because obviously I think I showed you the other day the report of government. Yes, how many people push for cesarean operation? So who will take care of the expenses? Right? Obviously that time government will tell we will take care of it. Clear? Applicability for which one? All factories other than seasonal factories, provided how many people are there? Greater than or 10 employees, includes sweet preparation establishment with aid of LPG also. Clear? Right. Now, any other entity you want to apply, you can apply, provided how many months notice you have to give? 1 month notice you have to give. Clear? And your intention of provision to apply the provisions for them, you have to give 1 month notice. Not randomly you can apply. What is the wage limit? Maximum. So if it is more than 21,000, we fix it to 21,000. Less than 21,000, actual wages. So can I say actual or 21,000, whichever is lower? Clear? But one more thing. Beginning of the employment date only, that is from the date of appointment only, if it is 21, then okay. If it is more than 21, as on the date of appointment, then not applicable. Initial is 15, 16, 17, 18, 19, 20, 21, 22. Then applicable. 21 only. Clear? First day only 21,000. Applicable. First day 21,000. More than 21,000. 22, 23, 24. Not applicable. Be very careful. After the beginning, no problem. But from day one only, if it is more than 21, then for them it is not applicable. Once applicable, I said always applicable. This is for EPF, ESI, gratuity, bonus, everywhere. For employee benefit, whatever is there, once applicable, always applicable. Clear? For government, same as usual. Railway, major port, mine, oil field, CG cases. In all these cases, who? CG. In all other cases, SG. Who is dependent? Dependent, if you remember in the notes. Remember? Labor law notes. Widow, legitimate or adopted son who is less than or equal to 25 years. Unmarried, legitimate or adopted daughter, widowed mother, wholly dependent on earnings of insured person at the time of death. All these lists are called as what? Dependent. Clear? Just go through it once. There's no concept as such here. Okay. Now, sir, it is applicable for all except seasonal. We have told factory 10%. Shop, establishment, cinema, road, transport, everywhere more than or equal to 10, and where CG appropriate government says for them 20 or more. How much wage limit? As usual, 21,000. What is the contribution? Employee contribution is there. Employer contribution is there. How much employer will pay? 3.25% of the wages. Remember, employer will always pay higher. Clear? Employee should pay lesser. In EPF, employee will pay how much? 12. Employer 12. 8.33. 0.25%. Clear? Whereas in case of ESI, employee 0.75, employer 3.25. What mistake you will do is you will write 3.75 here and 0.25 here. Clear? Be very careful here. 0.25 is not ESI contribution. 0.25% is administrative contribution from employer's side in VPF, not in ESI. Okay. Now, who is the employee, sir? Employed by principal employer or immediate employer minus apprentice, then armed forces or anyone whose wages is greater than 21 when? From starting time only. Okay. Now, wages means what? All remuneration paid or payable excluding any contribution to pension fund or PF fund or anything. Traveling allowance is not included. Reimbursement is not included. Gratuity is not included. Clear? Now, if it is, when should we deposit this contribution, sir? Within the due date. Now, here is where people get confused. Okay. Due date is always payment of ESI contribution is within 15th of next month. But you can still contribute to your ESI after 42 days. It cannot be deposited. Clear? Up to 42 days you can deposit, but due date is always next month 15th. Clear? Okay. If salary is paid which is less than or equal to 176 rupees, ESI contribution will be paid by government. But whose contribution? Employee contribution government pays, not employer's contribution. Employer's contribution is how much? 3.25, which he has to pay. Employer is not getting salary, he is paying salary. Whereas employee, he is getting salary. So if it is less than 176 rupees per day, government will pay the ESI contribution for the month. Okay. Then how do you have to pay? Via ESIC portal. Contribution is equal to amount paid to ESIC. Who is this insured person? Employee who paid the contribution. We saw appropriate government definition. Who is appropriate government? In case of CG establishment, railway, port, mine, oil field. CG. Any other case? ESG. Dependent we have seen. Now, disablement, sir. There are two types of disablement. Permanent partial disablement. Permanent total disablement. Permanent partial disablement means what? Reduces earning capacity. They never said you'll never earn. For example, one eye is gone. Permanent partial disablement. You can see, but you can't see properly. Clear? That is permanent partial disablement. Clear? Permanent total disablement means what? Both eyes are gone. What he will work? Here earning capacity is totally out. Clear? That is called permanent total disability. Now, who are the seasonal factory for which ESIC is not applicable? Cotton ginning, cotton or jute processing, or that is pressing. Decortication. Some people will call this as decoration. Decortication. Decortication means what? Peeling of groundnuts. Clear? Peeling of groundnuts is called as what? Decortication. Clear? Of groundnuts. Manufacture of indigo, lac, rubber, sugar, tea, and any connected process to these three. Clear? Factory operating maximum for 7 months also will be called a seasonal factory, whether that is blending, packaging, or repacking of tea or coffee. CG prescribed process. Correct? Huh? Now, three authorities will be having in ESIC. One is corporation, one is standing committee, and third one is medical benefit council. Under corporation, who will be there, sir? Consists of chairman, vice chairman, other members representing employer, employee, SG, UT. What is UT? And medical profession. Clear? Then we'll have 3 MPs. Out of the 2 from Lok Sabha, 1 from then Director General. Clear? He is ex officio. He is ex officio. He is Director General of ESIC. So since he is Director General of ESIC, he will come and sit in the corporation. Understood? That's why I have written here, see, ex officio. Clear? Huh? Now all orders of this corporation is signed by whom? MCQ. Yes, we had seen it in ESIC website. So if he is appointed there, he will automatically be an officer here. Yes, he is superior person. Next, standing committee. In standing committee, who will be there? Chairman, 3 members from ESIC, 3 members from ESIC representing 3 state government, 8 members. In that, 3 representing employer, 3 employee, 1 medical, 1 elected by parliament. Then obviously, as usual, DG of ESIC, who is an ex officio, will be appointed here. What are their terms? 2 years. Power same as corporation. Clear? If committee commits any default in their duty, CG will supersede. What do I mean by supersede? CG will take it over. Okay? And all members shall vacate. Now once everyone will be removed, CG will appoint further new members. Clear? Now new standing committee will be formed after that. Third we have is medical benefit council. In medical benefit council, what do we have? DG of, who will be there? DG of ESI, that is Director General of ESI, DG of Health Services, Medical Commissioner of Corporation. All these are not appointed separately. Ex officios. Simply one word we say, ex officio. Clear? One member representing each state and UT. That doesn't mean only one member is there. From every state, one member. From every UT, one member. Then 3 representing employers, employees, 3 of employers, 3 of employees, 3 from medical profession. In that 3, 1 shall be women. Composition very, very important. Clear? Right. Now, what does these people do, sir? Whether it is corporation, standing committee, medical benefit council, what will they do? Sir, if they want to resign, they can resign. They have to give notice to whom? CG. Cessation, meaning they cease to become the member. Then, if he cease to become the member, when, sir? 3 consecutive meetings if he fails to attend. 3 meetings if you are not attending. Consecutive means what? Continuous. Sir, imagine 6 meetings are there in a year. He attends number 1, 3, 5. Is he disqualified? He attends 1, 3, and 6. Is he disqualified? Huh? Is he disqualified? Think and tell me no. How many meetings? But it should be. I told you 6 meetings are there. He attended 1, 3, now 5. Did he attend 3? Yes. Did he skip 3? Yes. Was it skipped continuously? No. Clear? Sir, what if 2, 3, 4 attended? Skipped 1, 5, 6. Not disqualified. He can be in the committee. Okay. 1, 2, 3, 4, 5, 6. Okay. Attended 1, 2, 3. 4, 5, 6 he skipped. Then disqualified. 3 consecutive meetings. What is consecutive means? Continuously he has to attend. Nada? Yeah, it's not disqualified. Here it is disqualified. See, meeting number 1, 2, 3, 4, 5, 6. Okay. Attended. Disqualified. Disqualified.
3 consecutive.
If he fails to attend 3 consecutive meetings, he stops to become a member. He ceases to become a member. 3 consecutive means what? Continuously, if he misses 3 meetings. Where has he missed continuously here? Is it continuous? 1 he attended, 2 he missed. 3 attended, 4 he missed. 5 attended, 6 he missed. It's not continuous. Clear? 1, 2, 3. Did not. Now disqualified because 3 consecutive meetings. Correct or no? What if? Not disqualified. 3 continuously he has to attend. Not attend. 3 continuously if he fails to attend, then he will be disqualified. Disqualified means what? He has to leave now. Clear? Right. Understood now? Got it. You have to remember he should be failing to attend 3 continuous. If I say, if you do not come to my classes 3 continuous days, then I'll remove you. Monday you came, Tuesday did not come. Wednesday you came, Thursday did not come. Friday you came, Saturday did not come. I should remove you from class.
No.
I should remove you from class. No. What did I say? 3 continuous days I told, not 3 days. 3 continuously if you miss, then I will remove you. Here you came, you missed 3 days, but not continuously. Are you getting my point? Understood? You are forgetting consecutive. You are just focusing on 3. Clear? It's not just because 3 he skipped. 3 he should have skipped 3 continuously. Only then he'll stop. Only then he can be disqualified. Clear? Now, Medical Benefit Council also, all these people, what are the disqualification they have? If you are unsound mind person, you cannot be there. Undischarged insolvent, you cannot be there. Convicted of moral turpitude, cannot be there. Interested party in a contract with the corporation, cannot be there. Except as medical practitioner, you can be medical practitioner in the corporation and still be in the committee, no problem for you. Clear? Or as a shareholder, but not as a director shareholder, because director shareholder is who decides the future, what actions to take. Director. Clear? What to take, what decisions, who will take, director will take. So as a director shareholder, if you are there, not there. Okay. Now every employee should register himself, his family and his family details should be given, family photo should be given. It's a one-time activity, and what will generate? IP number. IP is what? Insured person number. Clear? And this is a permanent number that you have. Okay. Now, sir, in this case, how do we appoint the employer, sir? Because in immediate employer you told no. Now, principal employer appoints immediate employer. He has his own employees. These employees can work where? For the principal employer. Either they work in the premise or they work for principal employer. ESI I have to pay. But how will I pay? I will pay to the department. Clear? With respect to 2 types of employees. Mine immediate employers. So my amount, I don't have to reimburse it to myself. Anna, but if I have paid because of immediate employer relationship, I have paid his employee contribution, then he is supposed to reimburse it to me. Clear? So I will pay my employer contribution, your employer contribution, but you have to reimburse your employer's contribution to me. If you don't reimburse, no problem. Whatever contract amount I am supposed to pay you, from that I will reduce and pay. Understood? Clear? Okay, sir. Right. That is with respect to your ESIC. Clear? Okay. Anything else? Did we skip an ESIC revision? No. Seasonally done. Wages done. Standing committee term. Suppression. Purpose. No problem. Contribution also is done. Principal employer recovery. Recovery, how do we do, sir? If any establishment, they have not paid the money, what do we do? How do we recover? Just like land revenue. Clear? The land revenue means what? District collector will help us. Clear? So, authorized officer may issue certificate to recovery officer. They can attach your immovable property, whose employer's immovable property can be attached. Clear? They can arrest the employer and his detention in prison. Approve a receiver for the management of the movable or immovable properties. So it's a very serious offense if you don't pay ESIC contribution. You have reduced from the employees, but you have not paid. Clear? Okay. Benefits we have already covered there. Clear? Funeral benefits also is given. If a person dies, his funeral expenses also will be taken care, because in the current generation, if you see, there are two types of, in Hindu only there are two types. One, you burn it normally with the wooden logs, and one is through electrical, right? Obviously, they'll charge for that. Correct? Now, it could be even for burial, they could charge for that, right? So, anything and everything we will pay, don't worry about it. Clear? Funeral expenses we will pay, right? Okay. Medical benefits, medical treatment in either in-house, that is, you can get admitted to the hospital and get the treatment, or even outpatient. Clear? Emergency also is included. Not just getting inside the hospital, get admitted, only then will be give you the benefits. As a funeral expenses, you claim. Now, to store the body, would have spent money on ice box. Clear? No problem. Claim it. Clear? Department sometimes may give, sometimes may not give. That depends on the case-to-case basis. Understood? Clear? Right, sir. Benefits not to be combined. Meaning what? Take one benefit at a time. Sickness and maternity are combining. No. Clear? Three benefits are there. What? Sickness benefit is there, maternity is there, and then disablement is there. You either take one. Understood? You either take sickness, or take maternity, or you take disablement. Clear? Do not combine more than one benefit. Okay? Sir, if you receive improper benefit, you are supposed to refund it back to the department, clear, or the company for that matter. Now, just because you have to pay ESI, you should not reduce their wages. Clear? Employer not to dismiss or punish. Why are you punishing him? For what? Sir, during sickness, because of you, I am not able to generate revenue. Papa, don't dismiss, discharge, reduce, or otherwise punish him. Clear? Right. Because he is getting sickness benefit. No, you can't, you can't take care of it. Clear? So now you start, shouting at him, harassing him. These things and all you should not do. It's for their wellness we are doing it. So don't do anything of that sort. Clear? If you want, you can go where? ESIC court. Any appeal is there? File in ESIC court. Appeal shall lie to High Court from an order of ESIC court. So first you go to ESIC court. You are not happy with the order, where you do? Go to High Court. Clear? Penalty provisions, do it. No problem. Okay? Right? Okay, sir. Deals with provisions for adjudication of dispute and claims. They will not listen to you directly. How much you have to deposit? How much you have to deposit? 50% of security deposit should be made first. Clear? Only then they will hear you. Yeah, summa, otherwise, simply you can come and file a case. Time waste. Clear? Wasting the court's time, wasting the appellate tribunal's time. So you pay 50%. Clear? If the reasons are there and the judgment goes in your favor, that 50% will be given to you. Understood? Then obviously someone should win, no? that will be given to them. Let's say, for example, 1 lakh rupees is a dispute. Okay, 50,000 you have to deposit. Imagine you win, employee wins. 50,000 will be given to them, rest 50,000 you pay. Clear? Employer wins, 50,000 will be refunded. Clear? But in some special cases, they can waive or reduce this particular percentage. They can directly tell 50% do want, 10% you give. Clear? But only in special cases. Okay? Right. This is your employee state insurance corporation. Clear? Yes. Let's begin with payment of gratuity act. Clear? Now, gratuity. Again, let's talk about MCQ. The term gratuity has come from where? Latin word called gratuitous. It means what? Complimentary or voluntary. All because of you, Rakesh. All because of you. Gratuity is a payment made by whom? Employer to employee for the termination. Sir, not for the termination. At the time of termination, when he leaves, we give him. For what reason? You have worked for us a very long time. You have generated revenue for us. Clear? So, for that, as a token of gratitude out of love word, we give what? Gratuity. Clear? Now, how much to give, which season, and for which factory, how many days we have to see, all those calculations will be there. Not like randomly we'll open piggy bank, take some amount and give. Clear? So, some kind of calculation is there, but we have to give. Okay? Now, gratuity is, sir, it is called social security benefit. Sir, do we pay monthly? No, we pay lump sum. What do we pay? Lump sum, meaning one full amount. One short payment will be giving. We are not going to give installments. Clear? What is your object? When did it come into force? 16th September 1972. What is your objective? For the payment of gratuity to employees engaged in factory, mine, oil field, plantation, port, railway, etc. Where 10% or more are there. Once applicable, always applicable. What is the time employee limit here? ESI 10, 12. I did not ask astrology. 10, EPF 20. Clear? EPF 20, ESI 10, gratuity 10. Understood? Clear? Right. See, ESI is with respect to health. If you increase the number of employees there, many people will lose. So there you keep minimum. Clear? Gratuity again is for their benefit only. Clear? Now, applicability for which these things are factory, mine, oil field, plantation, port, railway, every shop and establishment and any other establishment. Sir, with the aid of power 10, without the aid of power 20. Understood? Okay. We are remembering this forms P. Remember? Definition appropriate government as usual. Now, employee, anyone other than apprentice, and also we are excluding people who hold post under CG or SG. Who is an employer? Anyone belonging to or under the control of CG or SG, a person or authority appointed by appropriate government for the supervision or control. Sir, no one is appointed, then head of the ministry. Basically, who is called as employer, sir? Anyone who is the person controlling it. Clear? No one is there. Head of the ministry. Right. Then, if it is a local authority, person who is under supervision and control, meaning person who supervises and controls. Sir, okay, sir, not appointed. Then CEO of the local authority. All this can be asked in MCQ. Be careful. In any other case, the person who has the ultimate control over the affairs of the establishment. Clear? If CG is there, then a person authorized or head of the ministry. Local authority, same. Who is this? Person who has control or CEO. Any other organization, ultimate control over the affairs. Clear? Now, family. For male employee, who is family? Himself, wife, children, dependent parents, dependent in-laws. Right? And widow and children of predeceased son. What is children of predeceased son means? Grandson. Clear? Son, predeceased, children of predeceased son. Okay. Female employees exactly the same, but gender is different. Okay. Includes lawfully adopted son by employee, but excludes someone else has adopted your child. Clear? The child of an employee adopted by another person if permitted by personal law of that other person. See, I told you in constitutionally we have seen courts cannot ignore personal law and court cannot change your custom until it is very mandatory and necessary to change it. Clear? Notice by the employee to employer. You have to give a notice form number D. How many copies? Triplicate means what? 3 copies. One for the employer, one for the employee, one for the controlling authority. One for whom? Employee, employer, CA, controlling authority. Clear? Then, if you want, you can withdraw the notice. Again, you have to give in form number E, that is under triplicate form. One for the employee, employer, controlling authority. Okay? Right, sir. Now, what is continuous service? Very, very important for us to understand what is continuous service. Now, just before we move ahead, please let's go through this one. Employer's responsibility. What is employer's responsibility? Notice to controlling authority have to give in form number A. In how many days? What you should give? In case of name and address change, you have to give form number in from where 30 days? Change. Intended closure. You want to close 60 days before closure. But here, not after closure, before closure. Clear? Display of name of authorized officer in bold letters you have to give. Okay? Payment of gratuity, eligibility. Who gets the gratuity, sir? Number 1. Whoever has rendered continuous services of minimum. Minimum how many? Not maximum. Minimum 5 years you have to work. Only then you are eligible for gratuity. Clear? But my question is, 5 years continuously means what? 365 into 5 years? When we say continuous service, let's try and understand what is continuous service. There are 2 types of continuous services. One is actual, one is deemed. Correct? Now, what is this actual service, a continuous service, and what is this deemed continuous service? Actual continuous service, uninterrupted service, not to be taken as interruption, meaning following, even if you take leave, you can take leave, no problem. 1, sickness. 2, accident. 3rd, paid leaves. 4th, layoff. Remember we said lapse. You are sick, so you go and sleep in your mother's lap. Clear? Lapse. L, layoff. A, accident. P, paid. S, sickness. So if you take leave here, even though you have taken leave, we will consider as working. Understood? Even though you have taken leave, we will consider as working. Right. Now, sir, deemed continuous service, meaning we assume that you have already worked for us if it is a non-seasonal establishment or seasonal establishment. How do we calculate for non-seasonal establishment? For a period of 1 year, what is the calculation? If the employment is working for less than 6 days a week, then
190 days.
Minimum 190 days you should have worked. If it is 6 days a week, minimum 240 days you should have worked. For 6 months. If it is less than 6 days a week, minimum 95 days. More than 6 days a week, again there also. But I told you this is not 95. This is what? 190, no, 120. Clear? I told you, divided by 2. Understood? It is 120 days. Understood? Da? Clear? Yes. Pakka? Then let me correct it here. Clear? 120 days. Right, sir. For seasonal establishment, what do we do? Days actually worked by employee more than 75% number of days of the establishment actually worked. Therefore, what is the formula? Who worked? The days work means whose days? Whose days? Total working days of see in that particular year how many days establishment was working into 75% you do directly. Clear? Easiest way to get the calculation done. Okay. Now Here also, when you have to consider days actually worked, you have to include sick leave, paid leave, maternity and lay. Correct? No, labs only. Same labs will be including here also. Sick leave, paid leave, accident and layoff. Actually, maternity also will be coming under paid only. Okay. Okay. How much we have to pay, sir? Amount of gratuity? Maximum 20 lakhs. Maximum what? Sir, this 20 lakhs lump sum or what, sir? Lump sum only. Gratuity is always paid in lump sum. Seasonal. If for a seasonal, how much we should pay? Average of 7 days wages for each season. Wages drawn into why 26? We assume that 4 days off is there, that is Sunday, and 26 days you have worked. Clear? So on an average, 7-day wages we have to take. That means wages last drawn into 7 by 26. Okay, into number of years you have to take. Okay, wages to be taken separately for each season. So this wages for each season different will be there. In the class we have taken the example, different season example we have taken. Season 1 he learned 50,000. Season 2 he learned 60,000. Then he learned 80,000. Then he'll come back to 30,000. Clear? So every season calculate separately. Are you getting it? Understood? Okay, sir. For non-season, depends. Are you a time rate based employee or piece rate based employee? If you're a time rate based employee, average of 15 days of last drawn wages. What does last drawn wages means? Wages drawn into 15 by 26 into number of years worked. Last drawn means recently when you left. Clear? What was the recent salary? But in that, what is the recent wages you have to take? That into 15 by 26 you do into years worked. Okay? Which means we are giving half the month as gratuity. Whatever wages you have earned, half the month we are giving it as gratuity for the number of years you have worked. Imagine you have worked for like 20 years. Okay, last drawn salary was 2.5 lakhs. Yeah, so 2.5 into 15 by 26 into 20 years. That is 1 lakh 25 into 20. Right? 1 lakh 25 is 1,250, 1,250 into 2, 25 lakhs. Clear? So should we give 25 lakhs?
No, max.
So calculators are here. How much did I say?
Sir,
2.5
into
lakhs into
15 by 26
15 by 26 into 20 years. 28 lakh 84,000. How much will you give? 20 lakhs. Understood? 20 lakhs will give us gratuity. Right, sir. Next. Piece rate employee. If you are a piece rate employee, we can't give piece rate wise. What we'll do? Average 3-month wages you take. Last month, divided by 3. First you take average. Then that particular wages into 15 by 26 into years of number of years worked. Okay. Forfeiture of gratuity. Sir, when can we forfeit, sir? We'll forfeit in 2 cases. What is that? Sir, employee terminated because of willful omission, negligence, causing the damage or loss to the property. Forfeiture is only to the extent of loss. But riotous or disorderly conduct or moral turpitude offense means entirely or partially you can forfeit. Whereas here, you cannot forfeit entirely until and unless the loss is bigger. Clear? What do you mean by forfeit? Cancel it. Clear? Right. Now, nomination, sir. Employee should give nomination to whom? Employer. Why we should give nomination in the first place? If something happens to the employee, that money should go to the nominee. Clear? So, within 30 days, you have to give form number F. To whom? To employer. Clear? In how many copies? 2 copies. One is for him, one is for you. Okay? He will verify and return the duplicate copy to you in 30 days. Okay. Now, who should give nomination? Every employee who completed 1 year, he should give nominee. Nominee can be a family, yeah? Yes. Sir, what if I don't have a family? I don't want family to have a nominee. You need not have a nominee. But the day you acquire family, you have to appoint nominee from the family itself. You don't have an option to choose that I do not want my family to be a nominee here. No. Sir, they will be appointed. You have to appoint them. Understood? Clear? Okay. Which form you have to file, sir?
Form G.
Form number G, which is nothing but a fresh nomination. If nominee dies before employee, then same procedure has to be followed. Appoint a new nominee.
Form.
Understood? Same. Yeah, form H. Clear? Yes. Right, sir. Now, what are the certain things that you have to cover here? Continuous service done. Yes. Payment of gratuity done. Forfeiture done. Amount, nomination. Now, come here to determination of amount of gratuity. The moment it becomes payable, the employer shall determine the amount of gratuity whether or not employee is asking. Meaning, without employee asking, what you should do? As an employer, you should get to know how much amount you are supposed to pay as a gratuity. Clear? Number one. Number two, employer shall give notice to the person to whom gratuity is payable, specifying the amount of. So employer should tell employee, this is the amount of gratuity you are eligible for. Okay. In form number what? L. I told you, remember L for love. Out of love, I am giving you the money. Clear? Then the employer shall arrange to pay the amount within how many days? 30 days from the date of it becomes payable. Okay. So step. Who will tell? Employer should first calculate and keep. Then he should tell employee in form number L. Clear? Sir, should I wait for employer to come and ask me? No. Clear? Right. So within 30 days I should make payment. Clear? Now, if it is not paid, what is the interest paid? 10% per annum. 10% per annum. If the delay in the payment is due to the fault of employee, no interest is payable. Money is ready. We have kept it. You have not come to collect it. Whose fault? Your fault. Therefore, interest is not payable. Clear? If a claim for gratuity is not found admissible, issue a notice in form number M specifying the reasons. Send one copy to controlling authority. Why we are not paying gratuity? He should know what is the issue. What if there is a dispute between you and me? Clear? So for that matter, I will not give. Okay. If there is a dispute, what to do? Deposit that amount with whom? CA, controlling authority. He will tell, okay, you guys are fighting. No, don't worry. You give that money to me. Okay, sir. Then the CA will determine the amount of gratuity. How much is the actual gratuity has to be paid. If there is any excess, he will tell the employer to pay the excess. If not, the money will go back to you. But gratuity has to be paid. Something has to be paid. The CA shall pay the amount of deposit to the applicant, where is the employee, or to his nominee or legal head. Understood? Clear? Right. Application within how many days I have to make? Form number I. To whom? Employer. But if you are retiring, you know when you are retiring, no? So 30 days before the retirement, you are supposed to tell. Okay? Sir, okay, sir, member is not there. Can nominee apply? Yes. Nominee can apply within 30 days. Form number J. Clear? Nominee was always jealous. That's why form number J. Okay? Employee. My money, I. Therefore, I am applying. Clear? Then, employer may obtain such other particulars. Legal heir. He has 1 year from the date of gratuity becomes payable. Understood? Sir, K. K for kind. Clear? Out of kindness. Out of kindness, legal heir can apply. 1 year will give him time. Others 30 days. Clear? Then, belated application for payment of gratuity filed after expiry of periods shall also be considered as by the employer, provided proper reasoning you have to give. Why did you make the delay? Okay. How do we give? Person service or RPAD. What is RPAD? Registered post acknowledgement due. Understood? Clear? Okay, sir. Now, notice for payment of gratuity. Within 15 days of receipt, the employer shall, if the claim is found admissible, issue a notice in form number L. Clear? Specifying amount of gratuity, and fixing a date not being later than 13th day after the date of receipt. So the moment you get the application, within the next 13 days, you are supposed to make the payment. Clear? If the claim for gratuity is not found admissible, issue a notice called form number M, specifying the reasons. M for mudiyad. Clear? Understood? If a claim is not admissible, I will not. Clear? Hindi. Manunga nahi. F. Form number M. Okay. Now, sir, If that is not the case, sir, next going forward, in case of gratuity is due, the date fixed in the notice you have to give in form number L shall be refixed by the employer. Maybe you didn't come on that day. Go and appeal. Tell you the proper reason. They can refix the day. On that day you come and collect it. Okay. Okay, sir. If they want, employer may can ask for such witness for legal error. Randomly you come and say I am legal error. How can I trust you? Clear? Randomly you come and tell I am the nominee. How can I trust you? Mode of payment: paid in cash, DD, bank, or direct money transfer also is possible. Okay. If nominee is a minor, then invest the gratuity amount in the name of minor, term deposit. After he becomes major, give it to him. Okay. Application, powers, recovery, appeal. Now recovery is as good as what? Same. Collector will recover. How much you have to pay interest? 9% you have to pay. Appeal: person aggrieved by an order can appeal within 60 days from the date of receipt of the order to appropriate government. Clear? Now what will appropriate government do? If it is satisfied appellant was prevented by sufficient cause from preferring the appeal, then he can extend the period for further 60 days. Primary 60 plus total 120. Understood? Clear? Yes. In Gratuity Act, more or less remember the calculation. Clear? And nomination. These two things are very, very important. Clear? Yes. With this, payment of gratuity also is done. Factories Act. Chapter number 4, Factories Act. Let's talk about Factories Act. Right? So, what is the main object of Factories Act? Three things as usual: safety, health and welfare. Safety, health, welfare. Applicability: whole of India including Jammu Kashmir. Clear? Now, who is a competent person? There are certain definitions that we have to talk about. Clear? Who is a competent person? Person or an institution for the purpose of carrying out test examinations and inspections. See, why Factories Act came is, if we are manufacturing something, we have to have a factory. Now in that factory, when you employ people for your work purpose or for your manufacturing purpose, you have to take care of them. Clear? Three things: health, safety and welfare. Health also you have to see, safety also you have to see, welfare also you have to see, because they work for you. So when they work for you, you have to ensure that they are getting the right amount. So what is the salary to be paid? Should I make them work for like 14-15 hours a day? Clear? And which people should I let them work like 14 years, 10 years, 12 years, 15 years? So all these things are taken care in this particular act. How the environment should be. Should it be AC? Should there be water cooler? Should there be toilets? If yes, where it should be, for male separate, female separate, everything will be discussed in Factories Act. So Factories Act basically talks about three things. It addresses three issues: health, safety and welfare of people. Clear? Now, competent person means what? The one for the purpose of carrying out test, examination and inspection in the factory. Something happens, we should get to know, no? Not randomly we'll take him to the hospital. We should get to know what the problem is. So for that, if we have a competent person, he'll help us in finding out this particular problem. Clear? Right. Now, hazardous process. What does hazardous process means? Poisonous, harmful. Clear? Like chemical. Right? Chemical manufacturing, rubber manufacturing, in all these cases, no. Harmful fume. Fume means what? Kind of gas, not exactly gas, but smell. Right? That smell can affect a lot of people. Correct? So these gas emission, smell emission, disposal of waste, all these things will be coming under hazardous process, provided it is very, very harmful. But how do we define that? Any process or activity specified in first schedule. Which schedule? First schedule, where unless special care is taken, raw materials used therein or in the intermediary, it will cause material impairment to the health. Not just impairment, material impairment. Impairment means what? Disability. But not small disability. We are talking about huge disability, material disability. Clear? Resulting in pollution in general environment also. Environment pollution happens. People's health is being targeted. Clear? And in that case, state government should take care of it. Who should take care of it? State government should take care of it. In Factories Act, who gives license? State government gives license. Clear? Example: petrochemical, explosive, paint, synthetic rubber, coal, ignite, coke, chemicals, etc. All these are hazardous process. Clear? What is manufacturing process? Any process for making, altering. Remember Maro? Yes? Maro? That is then WC. Then remember? Yes? Making, altering, repairing, ornamenting. Then FP. Finished product. That is finishing and packaging, then oiling and washing, then CBD, that is cleaning, breaking and demolishing, or otherwise treating or adopting any article or substance, right? Like pumping oil, water, sewage, generating and transforming and transmitting power, printing, ship and vessel, breaking the ship and vessel, clear, maintenance of it, clear, cold storage, right? Certain inclusions are there, that is laundry is included, carpet beating is included, conversion of latex into rubber. Remember I showed you a video, yes, how latex is collected and then it will become a rubber band video we had seen, yes, then conversion of seawater into salt, tobacco into cigarettes, breaking of boulders. Boulders means big monolithic rocks which is converted into stones, small pieces of stones. Everything is considered as manufacturing. Okay, very important definition. Okay, then 2L talks about what? Worker. Who is worker? Person, employer, meaning who is it? Individual. Clear? Directly or through any contractor, right? For what? In manufacturing process he is working, or in cleaning of any machinery, incidental or connected with, but does not include any member of armed forces. All people excluding armed forces. Clear? All people means what? For manufacturing process, not for your admin office. For which one? Manufacturing process. Clear? Then section 2M talks about what? Factory. Here we had seen factory includes presence also where manufacturing takes place. Right? Remember I told you garden? No, garden is not a manufacturing, not a factory. Clear? 10 or more workers are there in the last 12 months, not accounting year, not financial year. Last 12 months, if 10 or more workers are there, we call them what? Those factories has to be considered under Factories Act. Clear? With the aid of power, if it is without the aid of power, 20 or more. With the aid of power, 10 or more. Without the aid of power, 20 or more. This is called as what? Factory. If it is less than that, we will not call them as a factory, and Factories Act is not applicable for them. Clear? Does not include mine, mobile unit of the armed forces, then railway running shed, hotel, restaurant, eating place. These are not manufacturing entity, right? Or these are not factory, but kitchen is covered. Clear? Kitchen is a factory under the definition. Not the definition as such, but with the cases. Okay? Then, sir, how do we calculate number of workers? Sir, when you calculate number of workers, you have to consider all shifts put together. Shift 1, shift 2, shift 3, everyone put together you have to calculate. Clear? Then, sir, electronic data processing, EDP unit is not to be considered as factory because it's only software manufacturing. There's no other manufacturing. It's a software processing. Okay? Occupier, who is the occupier? Whoever has ultimate control over the affairs of the factory. If it is firm or association, then individual partners. If it is a company, director. If it is a factory owned by CG, then persons appointed to manage the affairs. And in case of ship, owner of the dock. And sir, in case of ship, owner of the dock, correct, but owner of the ship or his agent also to be considered. Any person who contracts to carry out the repairs and maintenance also deemed to be occupier. So this definition is very important. Firm, if it is firm, partners. If it is company, directors. If it is government entity, then person who authorized to manage it. If it is a ship, owner of the dock. Clear? Now, you need not be owner of the dock also. If there is a manager or anyone who is taking care of the ship. In original class, if you remember, we spoke about Bhaiya in the academy. Remember? Yes. So that will be considered as, who is this? Occupier. Clear? Who is this? Occupier. Then notice of occupier. Now onward section number starts. Okay. Now, an occupier shall 15 days before he begins to occupy, he has to give notice to whom? CI. Who is this? Yes. What should he give? Name, situation, address, nature and details. Now, not only that, whenever you appoint a new manager, you have to send a notice to chief inspector in writing within 7 days from the appointment. Clear? Then, duties as usual, health, safety and, well, yes. Inspector, SG may appoint such inspector. Power and all, no problem. Clear? Certified surgeon. Who is a certified surgeon? The SG may appoint qualified medical practitioners to be certifying surgeons. Clear? The duties, examination and certification of young persons, examination, medical supervision. For what? Cases of illness have occurred due to the nature of manufacturing process by reason of any change in the manufacturing process. Basically, in the factory, if due to the manufacturing process, if they get hurt, somebody should take care of them. Clear? And that is notified by whom? Certifying surgeons. Very important concept. He is appointed, qualified medical practitioners, not Legi Vikraman. Clear? Not roadside doctors and all. Who do we talk about here? Certified surgeons. Clear? Yes? Okay. Then, now, Three things we have to talk about: health, safety, and welfare. First, we'll talk about health. Clear? In health, what do we have to take care? Cleanliness, water, disposal of waste, ventilation, dust, artificial humidification, overcrowding, and lighting. Cleanliness, you have to keep the area clean and free from effluvia. What is effluvia? Bad odor. Clear? Drainage. See, for example, when you walk through this road, sometimes you see drainage water oozing out. Correct? It has a very bad smell, and that is what we call as effluvia, and because of that, infection can happen. Clear? Now, in those cases, for example, even for that matter, flood, when you walk in that flood, obviously it's mixed with drainage water, right? You will start getting a very bad odor on your feet and all. Now, those bad odor is what we call as what? Effluvia in factories. Okay? Now, from any drain, privy, or any other nuisance, removal of accumulated dirt, clear, effective disposal has to be done. Okay, cleaning of the floor every workroom once in every week with disinfectant or any other effective manner, meaning floor should be cleaned at least once in a week. Okay, then providing effective drainage for removing the water to the extent possible. What do you mean to the extent possible? How much ever is possible, we should be able to drain the water. Clear? Then interior walls and roofs should be cleaned. Whitewash or color wash once in every these are all MCQ important point. Clear? Once in every 14 months. Clear? Where surface has been painted or varnished, repair or revarnish once in every 5 years. If it is washable, every 6 months. Clear? Where they are painted or varnished, or where they have some smooth impervious surface, then clean once in 14 months. Time limit is very, very important. Clear? Here there is nothing to talk about as such conceptually. You just have to remember the time limit. Clear? Here memory is more important. Then all doors, windows, and other framework, if it is wooden or metallic, shall be painted or varnished once in every 5 years, and you have to maintain a register. This is with respect to cleanliness. Right? Next, disposal of waste, treatment of waste and effluent. Waste disposal, maybe wet waste converting into, what is that? What do we call that? Where we can put it for the plants and other things. We can convert that into biogas also, or even manure. Yes, you convert that into natural manure. Clear? Then ventilation and temperature. Every workroom should have adequate ventilation. Clear? That is nothing but circulation of fresh air. Otherwise, it will feel like suffocating. Okay. Then, in case of the work involves the production excessively, then you have to separate by separating their process which produces such high temperatures from the workroom. Keep it separately. Clear? Insulating the hot parts or by other effective means. Clear? Proper insulation should be given. All right. Then dust and fume. Now, what do you mean by dust and fume? Obviously, when you manufacture something, you'll see they'll wear different type of masks so that they will not inhale the fume. Okay. Now, every factory, if it is given off any dust or fume, you have to take effective measures to prevent the inhalation and accumulation in any workroom. Exhaust appliance shall be applied. Now, when you go to printing press, you will see experience a different kind of smell there. Yes, although you like it. Clear? But it is very dangerous if you keep smelling it on a consistently daily basis. If you keep inhaling that, it is very bad for your lungs. Clear? So printing press, previously we used to have screen printing. Clear? Where they use the paint. Clear? Very difficult if you are having such type of factory. Clear? You have to wear mask. Proper mask you have to wear. Okay. Artificial humidification. What does humidity means? Humidity means presence of water in the air. Clear? Now, in cooler areas and all, obviously, humidity is not there. So, they have to create an artificial environment of humidification. Clear? There, SG will take care of the rules and regulations. Overcrowding, very important. Between two people, what should be the distance? 14.2 cubic meters. That is important. They will say 14.2 feet. 4 options they'll give you. You just have to see 14.2 cubic meters. Understood? Okay. Then, sir, with respect to lighting, sufficient and suitable lighting, nature, artificial, or that both, meaning natural lighting or artificial or both. Windows, skylights. Skylights means what? Natural, for natural lighting, no, on the ceiling you will give skylighting feature. Clear? Where automatically sunlight will fall into the premise. In those cases, it has to be kept very clean. Okay. Prevention of glare. Glare means what? Now when you are driving the car, you will see too many people will come with different headlight. You won't be able to see properly. In factories also, if you are having such surfaces where you can't see properly while working, you have to be very, very careful with respect to that. Clear? Then drinking water at suitable points conveniently situated, supply of wholesome drinking water, more than 250 workers if they are there, you have to provide cool drinking water. Clear? Water point shall be away 6 meters from any washing place, urinal, latrine, spittoon, open drain. It should be far away, sir. Near the toilet you will keep water cooler. No, keep it little away. Clear? Latrines and urinals conveniently situated, accessible to workers at all point of time, separate for male and female. You should give adequately lighted and ventilated, clear and sanitary condition. Sweeper shall also be employed. If it is more than 250, then proper, that is Indian and Western bifurcation should be there. Clear? Latrines and urinals once in every 7 days at least. If you want every day you do it, but at least once in 7 days you have to clean it. Clear? Spittoons should be clean and kept clean and hygienic condition. What is spittoon means? A particular place where you can spit. Clear? Then safety. Safety what? Fencing, working near machinery, self-acting machine, casting of new machinery so that you will not get hurt. This is purely from safety point of view, not health point of view. Health point of view, we have covered it. Now, we are talking about what? Safety point of it. Clear? That is your revolving machinery. Of all these things are there, you have to take care of it. Clear? Explosive, precaution in case of fire, maintenance of buildings, appointment of safety officers, protection of eyes, that is your glasses, helmet, safety shoes. These are all coming under safety measures. Clear? Then hazardous process, very, very important. Who should approve the premise? State government should approve this thing, but they have to appoint what? Site appraisal committee. They should appoint what? Site appraisal committee. ST directly they will not come. They will appoint a committee. This committee will come and check. Once they check, they will make a recommendation to SG within 90 days. If they want, they can call for any extra information, and if they are satisfied with the report, they will give the permission for you to go ahead. What is the responsibility of the occupier? Detailed policy you have to lay down. Disclose all the information regarding dangers. On-site emergency plan and disaster control measures. Measures for handling usage, transportation, storage of hazardous substance inside the factory. For example, chemical reaction can happen, right? So if you don't keep it properly, say, store it properly. For example, kerosene, LPG, clear, right? Any such gas items you keep, you have to be very careful with respect to that. Clear? Next. Welfare. Now, welfare means what here? Not health, not safety, but your well-being. You should work in a cool environment. Clear? I should not force you to work. So in this case, what they're telling is washing facility for storing and drying clothing, facilities for sitting, first aid appliance, canteen, all these things we'll be talking about. Washing facilities should be given where? Sir, adequate and suitable facilities should be given separately for male and female. Sir, if you are giving washing facility, don't you think drying facility also you should give? Clear? So to drying clothing also we will be giving you. Sitting, suitable arrangement for sitting. All workers obliged to work in a standing position. Sir, entire day they'll be standing and working. Give them some sitting arrangement there. Let them go and sit. Take some rest. No problem. Clear? First aid appliances very important. For every 150 workers, one first aid box should be there. Then separate reasonable person should be there. A certificate in the first aid treatment, meaning he should know how to treat, which cream to apply. Imagine you got hurt. This fellow does not know what to do. Instead of putting that antiseptic powder, he put salt on the wound. Clear? What will happen? Obviously, septic, infection, so many things can happen. So basically, he should be certified. Certified, at least he should know how to treat it. Then, if more than 500 workers are there, you have to have an ambulance facility as well. Canteens, more than 250 workers if there is there, you have to provide canteen. Item of expenditure, you can't put it on them. Clear? It should be borne by whom? Employer. This is important MCQ. Canteen expenses always employers. Clear? Next, shelter, restroom and lunchroom. If more than 150 workers are there, shelters or restrooms, suitable lunchrooms with provision of drinking water, proper lighting and ventilation should be there. Okay? Creches. What do you mean by creches? What is creches? Basically for people who have kids, infants, like babysitting area. Here, if more than 30 women workers are employed, a particular place should be provided, maintained and suitable room for use of children under the age of 6 years. Clear? It should be adequately ventilated, clear and sanitary condition. Okay. Welfare officers must be employed if there are 500 or more workers. Clear? These numbers are extremely important from your exam point of view. Clear? Now, working hours for adults. What is the maximum number of working hour? 9. But one slot we can give 5, but after 5 hours we have to get at least half an hour of break. Okay. Now, maximum how much? 48 hours in a week. Weekly holidays. Sir, you give any holidays, weekly holiday, no problem. Generally, they say Sunday. Generally, they say what? Sunday. First day of the week. That is nothing but Sunday. But if Sunday I am not able to give, 3 days before Sunday, 3 days after Sunday, one of the slot you have to give one holiday. Clear? Then, sir, manager has or the factory has before the set day or substituted the day, whichever is earlier, delivered a notice to require the worker to work on the set day. Meaning, if I have to make you work on Sunday, I can't suddenly give you a surprise. Clear? I have to tell you work today. I have to give you notice. Without notice, I cannot make you work on a Sunday. Clear? Then, compensatory holiday, meaning on your weekly off, you have worked. You are not supposed to work, but still you have worked on a weekly off. Now I am supposed to compensate that particular holiday on some other day. Clear? But what's the time limit? What is the time limit? Within that month only. But not possible, sir. Then within 2 months immediately following that month, compensatory holidays of equal number of holidays so lost. If I work for 2 days in this month, 2 days comp off I can take. Either this month or by next 2 months. Understood? Clear? Shift duty extends beyond midnight is what we call a shift duty. Clear? Now for them, how do we give a holiday? For them not Sunday, Monday, Tuesday, no. For them 24 hours. Clear? People who work in shift, let's say for example, 9 to 4. Night 9 o'clock, let's say 2, let's say 5 o'clock. Now you are working on previously also, today also, no? Clear? So for them what they are telling, no problem, 24 hours you take off. That's as good as 1 day. Okay? Now, overtime if you are working, simple, 2x of the normal wage. Okay? How much you have to pay? Twice of normal wage. Okay. Sir, if where the workers are paid on piece rate basis, the time rate shall be deemed to be equivalent to the daily average of their full-time earnings. So if they are paid on piece rate basis, daily average of their full-time earnings you take, that into 2 you do. Clear? How much they have earned in a day. That is what called daily average of their full-time earnings for the day which they have worked. So how many days they have worked? Take that divided by number of days. You will get the average into 2. That is the overtime wages. Clear? Double employment. Can I work in 2 employment in one shot? No. At a time? No. I cannot work. Clear? Register you have to maintain. Okay. Employment of women. For them, 6 a.m. to 7 p.m. I can ask them to work. No, sir. No, sir or yes, sir?
Yes.
Can I ask them to work from morning 6 to evening 7? Then? Evening 6 to morning 7, huh? No, sir. See here. No woman shall be required to or allowed to work except between the hours of 6 a.m. and 7 p.m. Between 6 to 7, any number of hours. Not 6 to 7. I am not asking you to work from 6 to 7. Between 6 to morning 6 to evening 7, any number of hours I can ask you to work. But SG may authorize the employment of any woman between 10 p.m. and 5 a.m. That means generally 10 p.m. and 5 a.m. you cannot work. 7 p.m. to next day morning also you cannot work. Clear? There shall be no change of shift except after a weekly holiday. Meaning daily you can't change the shift. Weekly if you want you change the shift. Right? Employment of young persons. Now, no child who has not completed his 14th year, you cannot employ him. This is a child labor. Clear? Then, can I appoint adolescent? Yes. 15 to 18. After 18, major, obviously. Clear? But before I appoint him, certificate of fitness should be granted. Clear? Certificate of fitness, who should give? Certifying surgeon. On the application of any young person accompanied by a document signed by the manager of the factory, he should give a certificate. Clear? Understood? Okay, sir. Now, sorry? Is there no? See, certifying surgeon, correct. Now, chief inspector for what? Certifying surgeon is going and telling this fellow is fit to work health wise. That inspector is different. Inspector is for what? Premises. Clear? This one is for what? Fitness. I want to go to the doctor only, no? Clear? Then, certificate is valid for how many months? 12 months. After 12 months, again you have to renew it. Okay? If you want, you can revoke. Revoke means what? Withdraw at any point of time. Clear? But when you are withdrawing, you are supposed to give reasons. Okay? Occupier is to pay the fees. You cannot recover it from the young person, his parents or guardian. That certificate has to be paid. Obviously, that certifying surgeon might charge something. Clear? That charge who should pay? Employer should pay. Clear? Can I take it from the employee? No. Employee's mother? No. Employee's father? No. Employee's guardian? No. Solely and solely whose expense? Employer's expense. Working hour for children, nothing divided by 2. There it is 9. Here it is 4.5 in a day or during night. So more than 5 hours you cannot have. Okay. So 9 hours is max. Okay. Now female children, you cannot work from 8 a.m. to 7 p.m. you can work. Apart from 8 a.m. to 7 p.m. you cannot work. Then you have to maintain a register of child workers where name, nature, group and shifts are involved. Annual leave. How many days you can take leave? How many days? If you worked for minimum 240 days, minimum 240 days, 1 day for every 20 days if you are an adult. If you are a kid, 1 day for every 15 days. Meaning, if 1 day for 20 days, for 240 days, how much I will get? 12 days I get. Clear? 12 days I get. Okay. Then for a kid, 1 for every 15. Then for 240, how much he will get? Clear? That you calculate. Alright. And that much is called as he is allowed to take that leave. Clear? The following shall be deemed to be days. That is he's worked. Meaning even though you take a leave here, you will assume that you have worked. Which are those? Layoff, maternity. Clear? Leave earned in the prior period. Last period you have earned the leave, but you have not taken it. Now you are going to enjoy it. No problem. Enjoy it. We'll consider it as worked only. Okay. Now, if when you calculate the leave, fraction of leave of a half a day shall be treated as 1 full day and fraction less than half a day shall be omitted. For example, I told you 1 for every 15 days. For 240 days, you'll be coming at 15.9. Now it is more than 1 half. I have to round it off. That is 16. If it is 15.3, 15. Clear? Carry forward of leave, you can carry forward, but you shall not exceed 30 days for adult, 40 days for kid. A worker who has applied for leave with wages shall be entitled to carry forward the leave if it is refused. Without any limit, you can carry forward. Generally 40 and 30. 30 and 40. 30 for whom? Adults, 40 for whom? Children. Now, if you went and asked for leave with wages, employer refused. Then you can carry forward whatever leave you have for infinite number of days. Clear? There is no limit for it. Clear? Then availing of leave, minimum 15 days before you are supposed to send a notice to them so that they can get the leave. Clear? If he is employed in a public utility services, minimum 30 days before the leave you have to tell. Clear? Wages during the leave period, same wages what you were earning, that we will be giving you. Nothing more, nothing less. Clear? Exclusive of any overtime. We will not give overtime. Last month you worked overtime. This month you are on leave. Why we have to give overtime? Normal wages will be giving. Right there. Normal wages. Normal wages. Clear? So last month how much you have worked, that we will take, that average will take, clear, into number of days here, what you are working. Okay. But when we calculate that last month wages minus OT plus DA. Wages minus OT last month, imagine now we are in the month of May. Clear? Now, let's say for example, April month, whatever you have worked, whatever is the salary minus overtime if any plus dearness allowance, that is our total wages divided by number of days of work, yes, into number of days of leave. Clear? That will be your leave with wages. Okay. Sir, if you have not worked on any calendar month, no problem. Sir, wherever you have worked before that day, let's say for example April month also you have not worked, March would have worked. Take that day. March also not worked. February, any one month you should have worked, no? Yes, that month wages you take for calculation purpose. Okay. Then advance payment. If you are taking leave, you are allowed to take leave, no problem. But if it is not less than 4 days, meaning more than 4 days if you are taking in case of adult, and more than 5 days if children are taking, you have to pay their wages in advance. Before they go on leave only, pay their wages in advance. 1-2 days, no problem. But if you are going for more than 4 days, then we have to pay in advance. Encashment of leave. Sir, I don't want to take leave. No problem. You can take cash instead of leave. That is called leave encashment. Clear? Right? So this is your Factories Act. Okay. Here there is nothing called as too much of concept. Here it's only memorization technique which has to be used. If possible, make a short note. Just a table. Clear? Table, serial number, facility, number of employees, remarks. 4-column you write and keep on writing the tables. Understood? Clear? This is your Factories Act. Now we are left with only code on wages. Last chapter on labor law, code on wages. Okay, woman, focus. Code on wages 2019. Okay, now here 4 acts has been converted into one code. What are the 4 acts? Payment of wages, minimum wages, payment of bonus, equal remuneration. Okay. Now, why do we do this? Why did they bring code on wages? To bring basically uniformity and ease a burden of documentation. In different acts, so many definitions are given. Everything has been removed. Clear? Under one thing only they have told what is the definition. Clear? Here, floor wage concept was introduced, whereas in old acts, floor wage concept was not introduced. Only minimum wage was there. Now, floor wage is there, minimum wage is there. Then they have actual wages. Clear? Now, here 2 definitions are very important. One is called wages definition. One more is employee definition. Employee is nothing but very easy. Whoever is employed on wages. Clear? Now, employee and worker, very, very important. What is the difference? Only one. What is highlighted in blue color? Managerial and administrative. Employee includes, worker will not have managerial and administrative. Clear? Also, workmen will include journalists, also sales promotion employee, but Air Force, police service, supervisory capacity, whoever is getting more than 15,000, and managerial administrative employees are not covered in the definition of workmen. But employee definition, they are covered. Workman is basically working in factory and manufacturing thing. Admin people are working in the office. Okay, right. Now, let's talk about definition of wages. For equal remuneration, what is wages? Do you remember? Wages is equal to travel allowance, overtime, house rent allowance, award, settlement also will be included. Clear? This is for what? Equal remuneration, meaning basic pay is there. Yes, DA and RA generally. But for equal remuneration or payment of wages, what is wages? Basic is there. Clear? DA is there. RA is anyway there. And bonus are. No. You have written it wrong. Wait, I'll give you clarity on this. You are talking about where is it? Code on wages. See, all remuneration, salary, allowance or otherwise expressed in terms of money or capable of being expressed in money. Now, this is nothing but in kind. It is called wages and includes basic pay, DA and RA. Correct? But does not include what? Bonus payable. But which bonus payable? If it is under any law, exclude. Terms of employment, include. It will be included in the salary or wages. Okay. Then value of any house accommodation, any house accommodation, if it is given, the value of that should be taken care under the definition of wages. Contribution paid by the employer to any pension or provident fund. Very important is employer, not employee. Conveyance allowance, house rent allowance, award or settlement, OT, commission, gratuity, retrenchment. Meaning, sir, these four things, whatever we have put, it should be included for wages definition only in case of what? Equal remuneration or payment. Which are those? Travel allowance, overtime, HRA, award or settlement. Apart from basic plus DA plus RA plus TA, OT, HRA, award and settlement. These four should be included for what? Only two things. Equal remuneration and payment of wages. Clear? For minimum wages and bonus, it is different. For minimum wages and bonus, these things will not be included. Basic TA and RA and bonus. Which bonus? Only? Which is only under the terms of employment. Can I say agreed bonus? Can I say agreed bonus? Yes. Clear? Okay. Now, sir, one more provision which you have to talk about. To reduce this, what employers will do, basic, they will keep it very simple. Clear? Basic plus DA, they will keep very simple. These allowances, they will give more. So that when we pay bonus, bonus is paid on what? Basic plus DA plus RA. That they will keep very less. Allowance will give more. Now for an employee, I am getting whatever I am getting, I am okay with it. As long as I am getting money, I am okay with it. Clear? So what they will do is, basic DA, RA they will keep less, allowances they will keep more. So what government has told is, you give any number of allowances. You give how much ever you want to give, but cap is what? 50%. Cap is what? 50% of your total remuneration. So whatever allowance you give, it should be 50% of total your remuneration, which is nothing but wages should be 50% and allowances should be 50%. Clear? If exclusions, that is more than 50%, then excess has to be added. Let's say for example, basic DA RA. Okay, total remuneration is 1 lakh. How much should be your basic DA RA? Minimum 50. Minimum how much? 50. Now, your allowances should be how much out of 1 lakh? Maximum 50%. Allowance should be maximum 50. Basic should be minimum 50. Understood? Clear? Okay. Now, sir, what if they have given something in kind?
15%.
Maximum how much you should add or how much is allowed? 15%. Any excess is there? Add to wages. Clear? See here. Let's say remuneration 1 lakh, TA 20, HRA 10, OT 50. What is actual wages? 1 lakh, that is remuneration minus TA minus HRA minus OT, that is 20. Allowances, total allowance is how much? 80. What is the total remuneration? 1 lakh. Maximum allowed is how much? 50%. So 1 lakh into 50% is how much? 50,000. In 50,000, how much is your remuneration? Your allowance? 80. You are paid 80, allowed only 50. So that remaining 30 should be added to basic DA plus RA. Clear? Now your wages will be 50. So bonus will be not paid on 20, it will be paid on 15. Okay? Right, sir. Next, if they have given any kind, again, if it is not exceeding 15%, no problem. But if it is exceeding 15%, anything excess, you have to add it to the wages. Okay? Right. Now, equal remuneration, sir, should not be discriminating between people, gender, caste, creed, because our constitution only prohibits us, if you remember. Clear? Then, no employer shall reduce the rate of wages, make any discrimination on the ground of sex while recruiting any employee for the same work or similar work, meaning between male and female, similar work, no discrimination. Clear? Except where in some of the employment women are prohibited. For example, hard labor, sir. Clear? Very hard labor where you require masculine strength. In those cases, obviously, women should not be allowed. Clear? Now, mines. Clear? When you are working in the mines, you are going deep inside the earth, right? Now they will tell, no, here women should not be allowed. In those cases, no problem. You can't apply equality everywhere. Clear? Some places you should understand the situation. Okay. Then components of minimum wages. How much we have to give, sir? Appropriate government will fix it. How? Basic rate plus allowance. Clear? Basic plus allowance. Now that allowance could be in the form of DA, whatever you call. Basic plus allowance they have to give. Now, not only that, basic rate of wages with or without allowance and the cash value of concession given also should be included in the definition of what? Or component of what? Minimum wage. So minimum wage means what? Basic, DA, cash value of concession given. What is concession means? Perquisites. Perquisites given, cash value of that should be taken into consideration. Okay. Then procedure for fixing wages. Who will fix, sir? Two types of method: committee method, notification method. Clear? Committee method means what? AG will appoint a committee. This committee will recommend some suggestions or recommend some measures. Clear? You have to implement that. In this committee, who will be there? Employer representative, employee representative, which is equal to employer. Independent persons, not more than 1/3. After considering the recommendation, the AG will fix or revise the wages. Clear? And it shall come into the force on the expiry of 3 months from the date of issue. Notification method also very same. What does notification method say? AG will publish it in the appropriate manner. Proposal shall have a date not less than 2 months. Once all the people give their objections and everything, they will fix or revise, and therefore what is the time limit? Same, shall come into the force after expiry of or on the expiry of 3 months from the date of its issue. Whether committee method or notification method, both are same. Clear? Right? Okay, sir. Now fixation of minimum wage. Two types: time weight, piece rate. Where the employees are employed on piece rate basis, you shall fix a minimum wage rate which is equal to time rate only. Remember, we discussed one example here. Time rate is how much? 200 per hour. Pieces per hour manufactured how much? 2. Actually in that factory piece rate is how much? 50. But technically time rate is how much? 200. So in 1 hour you might manufacture 2 pieces. 50 into 2, how much you'll get? 100 you'll get. Piece rate if you see 100 you'll get. Time rate if you see 200. Sir, same person, if he works for 1 hour, he'll get 200 per hour. But if I give based on piece rate, he'll earn only 100. What employers will do? What will employers do? Best no piecework if we do. We'll save some salary. Law says, boss, for piece rate worker also, basis should be time rate. What is the time rate here? 200 divided by number of pieces worked. How much? 200. That is your piece rate. So this 50 is waste. Clear? This piece rate of 50 is waste. Clear? Now, where the employees are employed on piece rate, same wage rate only. Therefore, 1 hour is equal to 200 divided by 2 pieces. Therefore, 100 per piece. Clear? In case of time, hour, day or month, you have to take into account skill and geographical area. Okay? Difficulty and temperature. Clear? Minimum wage will vary from place to place. Now, there is something called as floor wages. Who will fix it? MCQ. CG will fix it. Central government will fix the floor wage. Now, what will happen, sir? You keep it, no problem. Fixation of floor wage is CG's department. Fixation of minimum wage is appropriate government. It could be state government also. It could be central government also. Clear? So, what they will do? CG will fix the floor rate. Imagine SG fixes minimum rate. So, minimum rate should be more than floor. Minimum should be more than floor and actual should be more than minimum. I repeat, minimum should be more than floor and actual should be more than minimum. Are you getting my point? Clear? Okay, sir. Sir, what if an employee has worked for less number of hours? We will consider, if it is a fraction, we will consider he has worked for the entire day. Clear? If you have worked for less number of hours, we will assume that you have worked for a normal working day only. Okay? Sir, wages for 2 or more class of work. One person is doing two types of work. What do we do? For separate class of work, you give separate wage. Don't combine. Clear? Yes. Right, sir. Fixing of hours of work, sir. We have already seen in Factories Act also. Clear? What is happening here? Fix the number of hours of work shall constitute a normal working day, including intervals. They are saying rest for every person once in 7 days. Clear? Shall be allowed to all employees if you are working overtime 2 times the normal rate. Okay. Now, sir, certain things you have to give little lenience. Like what? Employees engaged in emergency, for them fix separately. Don't put it in their normal category. Now for you will tell 7 days and all. Now emergency people are there. How will they work? If emergency is there, only then they'll work. No. See, now for example, commandos are there. Of course, not applicable here. Just giving you an idea. Commandos will work every day or what? Work in the sense they are alert. But do they go and fight every day? No. Only in case of war, emergency, they will come into the picture. Correct? Huh? Now reserve police is there. Do they work every day? Work means what? Do they go and do bandobast every day? No. Clear? So there are some employees where on emergency basis only they will come. For them, separate policy you have to fix. Then there are some workers whose work nature is what? Preparatory or complementary. What does preparatory means? Before the actual manufacturing starts, they have to prepare it. Clear? And after manufacturing ends, they have to complement it. For example, now ArivuPro, before we come to the class, don't you think class should be ready? A person who keeps the classes ready, preparatory work. After class gets over, they'll come and clean, complementary work. Clear? Okay, sir. Then essentially intermittent. What do you mean by intermittent? They don't work here regularly. Clear? They'll just say once in 3 hours, just come and see. Their work only is that. Clear? Then employees engaged in any work for technical reasons has to be completed before the duty is over, and engaged in a work which could not be carried on except at the times dependent on the irregular action of the natural forces. Only during natural cause they'll come and work. For these people, keep the policy separate. Clear? For these people, keep the policy separate. Overtime, as usual, twice into second time we are seeing here only 2 times of normal wage rate. Correct? Huh? Next, we are talking about payment of wages. Right? Payment of wages. Next. Okay. Now, payment of wages, how do we make? Mode of payment. Good morning, sir. Currency coin, currency notes, check, or by creating into the bank account directly. Clear? Appropriate government may specify the method. Clear? And employer shall be paying in the same manner. Sir, you can pay daily, weekly, fortnightly, or monthly. No wage period of any employee shall be more than a month. Once in 2 months and all, you cannot pay. Maximum once in a month. If it is daily basis, end of the shift. Weekly basis, before the weekly holiday. Fortnightly, before 17th day. And if it is monthly basis, before the 7th day. Okay. Where an employee has been removed or dismissed, retrenched, resigned, then within the next 2 days you are supposed to make his payment. Okay. Then deductions which may be made from wages. Sir, deductions, I am not going to do the entire list here. Okay. Just try to understand certain things is very important. These 3 things are not deductions. What are those? Withholding of increment. I am not giving you increment. That doesn't mean I am withholding your salary. Clear? I am not reducing your salary. I am not just giving you promotion. Number 2. Reduction to a lower post, meaning you are demoted. Here, you are not promoted. There is a difference. Third, suspension shall not be deemed to be a reduction. Withholding, reduction, and what? Suspension cannot be considered as what? Reductions in the salary. Clear? Matabadi yella fines, deductions, damage, house accommodation supplied, everything we can reduce. Just go through the list in your book once. Clear? Now, before that, whatever total deductions you are making, maximum it should be how much? Maximum 50%. Okay. If it is more than 50, the excess may be recovered in such a manner as may be prescribed. Okay. Now that means you should not pay the entire salary only. Abde, if you see deduction means you should not pay salary only. Maximum deduction allowed is how much? 50%. Something you should give them, no? Clear? Sir, what if my salary is 10,000, deduction is 7,000? Maximum 5,000 deductions. The 2,000 is there, no? Somehow I will recover. I will make you work more. Clear? Or maybe next month I will try to recover. Okay. Then fine, I can apply fine. Opportunity of being heard should be given. How much maximum I can take fine? Shall not exceed an amount equal to 3% of wages. No fine shall be imposed on an employee which is under 15 years and shall be recovered. You cannot recover fine in installments. Clear? Or after the expiry of 90 days. A register shall be kept. Deductions from absence of duty. Sir, if you are absent from duty, I can reduce your salary. But certain things we cannot be considered as absent. Right? Amount of such deduction shall in no case bear a larger proportion than the period for which he was absent. Basically, simply right here, deduction shall be what? Proportionate. Okay? Then, if 10 or more employed persons acting in concert, what is concert? Together, if they are being absent from the factory or from the establishment and without reasonable cause, sir, you can reduce the wages for how many days? 8 days straight away, very important. Okay, right? Then, now we'll talk about bonus. In your payment of wages, nothing is there. Alright, now let's talk about what? Bonus. Okay. In case of bonus, I have already numbered it. What you have to see first. 10 things are there in bonus for us to check. Okay. Number 1. Applicability and non-applicability. Clear? It is non-applicable for whom? LIC, seamen, employee registered under dock workers, CGR, SG. Clear? Red Cross, university, institution, etc. But applicable for whom, sir? Any establishment in which 20 or more persons are employed or were employed or any day during an accounting year. If you have 20 people in your establishment, bonus is applicable. Bonus and PF 20. ESI, factories and gratuity 10. ESI and gratuity 10. Factories depending on the power. Clear? With the aid of power, without 10, without the aid of power 20. Clear? There both are there. Okay. Whereas bonus 20. Bonus and EPF 20. They have their act. So we will not be taking care of it. Okay. Now, if a public sector is competing with the private sector, then for them what is the criteria? Profits earned by sale of goods and services. If it is less than 20%, no bonus. More than 20% or equal to 20%, you have to pay bonus. Okay. Now, this is done 1. Now come for eligibility. Sir, who should be able to get bonus, sir? Any employee who has put in at least 30 days of work in an accounting year. What does an accounting year means? April to March. Minimum 30 days you should have worked. Clear? Then, what is the rate of bonus? Minimum how much? 8.33% of the wages. Maximum how much? Maximum 20%. Maximum minimum 8.33% of his wages or 100, whichever is higher. Maximum how much? 20%. We can't give more than that. Clear? Okay, sir. That we have seen entitlement of bonus. Next, sir, all bonus put together should be 20%. Remember, Deepavali bonus, Pongal bonus, any bonus you give, all bonus put together should be 20%. Understood? Maximum 20%. If your salary is 25,000, clear? Maximum how much I can give? 5,000. Clear? So throughout the year you give any number of bonus, but it should not exceed 5,000 rupees. Clear? 5,000 rupees for, in my example, don't consider that as a fixed amount. Okay? Then, proportionately I can reduce, sir, in case if you have done anything wrong. In case if you have done anything wrong, I can reduce. If you have not worked for all the working days, obviously I can reduce your wages. Obviously proportionate. Clear? Proportionate reduction shall be allowed. Okay? Then computation of number of working days. Sir, in the following situations, even though you have not worked, we will assume that you have worked. Which are those days? Laid off, salary or wages, absent due to temporary disablement, maternity leave with salary or wages. Clear? In this case, we'll assume that you have worked. Okay. That's why we don't disturb him. You understand? Okay. Disqualification. If you are a fraud or righteous violent behavior, you have theft. Clear? Conviction for sexual harassment. In these cases, you can be disqualified for bonus. Clear? You will not be getting any bonus. Okay. If the employee is removed on the above grounds and is employed again in the same organization, entitled for bonus again. Imagine an employee who did all these things, who did fraud, clear, who did the righteous violent behavior, clear, who was convicted for sexual harassment, clear, theft and all he did. Now we removed him or he is there. After that again if we appoint him, then next time when we appoint him we have to pay him bonus. Understood? Clear? Yes. Okay. Now next, sir, from where do we pay the bonus? From where do we pay the bonus? Allocable surplus. From where do we pay? Allocable. Now to get the allocable surplus, we need to understand available surplus. You remember? Yes. What should we have? Available surplus. How do we calculate available surplus? Gross profit less depreciation under income tax less development allowance less direct tax payable. Now direct tax payable you have to calculate as per the income tax. Clear? That year's taxation only we have to take. Okay. Any other sum we reduce. Then we add tax saving on bonus paid in previous financial year. I already explained the logic. Last year when you declared bonus, it was considered as an expense. Clear? Because of which, last year you had paid a bonus on the profit. Now we already paid tax on that particular profit. This year we will consider that as a benefit. Clear? So tax saving on bonus paid in previous financial year. So how do you calculate? Your module has given one method where they have told calculate the tax without bonus, without reducing bonus, then calculate the tax with reducing bonus. Whatever the difference is there, no, you add here. Clear? How do you calculate? Tax calculation without reducing bonus, tax calculation after reducing bonus. Whatever is the difference, you have to add here. Okay. This is called available surplus. From that, we will come to allocable surplus. What is allocable surplus? If you're a banking company, 60%, other establishment, 67% of the surplus. If allocable surplus is not available, then minimum bonus should be paid. How much? 8.33 of wages or whichever is. What if allocable surplus is available? Then maximum 20% or allocable surplus whichever is low. Clear? If it is there, 8.33 or 100 whichever is higher. If it is surplus is there, enough surplus is there, 20% of wages or allocable surplus whichever is lower. Clear? Right. Simple chart. Allocable surplus is there, not there. If it is there, is it more than minimum bonus? If the answer is yes, maximum you can give only 20%. If it is no, you have to give minimum bonus. Sir, allocable surplus is not there only, you have to give minimum bonus. How much? 8.33% of wages or rupees 100, whichever is higher. Understood? Clear? Okay, sir. Now, 20% of wages, calculated maximum bonus is less than allocable surplus. Sir, whatever bonus I calculated is less than allocable surplus. If the answer is yes, pay your calculated bonus. Otherwise, pay allocable surplus. Imagine allocable surplus is 10 lakhs. The bonus I calculated is 8 lakhs. How much should I pay now? Bonus I calculated is 8 lakhs. Allocable surplus is 10 lakhs. Put here, 8 lakhs is less than 10 lakhs. The answer is yes, pay 8 lakhs. Clear? Let's say calculated bonus is 10 lakh, allocable is 8 lakhs. Then I'll have to pay allocable surplus. How much it is? 8 lakhs. Clear? You just have to put the amount in the formula, in the chart. You'll automatically get the answer. Okay. Now, excess bonus paid excess bonus paid, aggregate bonus including minimum bonus should be less than or equal to 20%. Remember I told you puja bonus, Diwali bonus, everything put together 20%. Bonus should be proportionate on the days of work. Deductions allowed, interim, customary, bonus paid before due date, misconduct, anything, deductions are allowed. Understood? Clear? Right, sir. Now this is our important bonus allocable and available surplus. Quickly tell me available surplus, what is the calculation? Gross profit, add depreciation, add tax payable, clear, add one more allowance is development allowance, and one more any other sum. Reduce tax saving on bonus paid in the previous financial year. What we get is available surplus. From available surplus, what do we do? Allocable surplus we'll get. How much is allocable surplus? If you're a banking company, 60, other companies 67%. Clear? Now, if allocable surplus is there, then I can pay maximum 20%. If allocable surplus is not there, minimum 8.33% or allocable surplus, whichever is higher. Correct? Understood? Yes, sir. Minimum to minimum, I have to pay 8.33%. Clear? Okay, sir. Now, last is your set on and set off. Yes or no? No. What is set on and set off? Very simple. Very simple. Sir, every year you are supposed to pay bonus. Bonus is mandatory. But for the first 5 years, you need not pay bonus. Clear? You have to pay bonus only in the first 5 years. Whenever you make profits, only then you have to pay. Clear? 6th year, 7th year onwards, set on set off is available, but with some adjustments. But normal set on and set off means what, sir? Let's say this year you are supposed to pay one fixed bonus of 4 lakhs. Okay? This year you are supposed to pay how much? 4 lakhs. Let's say your allocable surplus is 2 lakhs. Allocable surplus is 2 lakhs. What is your bonus payment now? 2 lakhs. Shortfall? 2 lakhs. Now, whenever we have a shortfall, what do we call that as? Set off or set on? Huh? Set off or set on? Set off or set on? Here, read. No available surplus or allocable surplus, and there is no amount or sufficient amount carried forward and set on, then such minimum amount or the deficiency shall be carried forward and for being set off in the succeeding year and so on up to the including of 4th accounting year. That means this we have to set off. How many years? 4 years. Now next year, let's say our allocable surplus is, bonus will still remain the same. We solved this entire table once. Clear? Now, how much we have to pay bonus? This is our bonus. This is our surplus. This is our payment. This is shortfall or excess. Okay? Now, how much excess we have? 2 lakhs. This is set on for 4 years. Everything will be going for 4 years. Okay? Right? Now, I think here only I have put one table. It's here only, no? No, I'm talking about the, oh, it's then that book. Correct. You have the book with you, no? The table is there. Give it to me. It's another iPad. Take the same amount. Huh? That I'll take it over. Right? Okay. I'll take the same class example. Okay. Now, surplus, bonus, payment, shortfall or excess. Now, what is the surplus first case? 5 lakhs. What is the bonus we are paying? 4 lakhs. What is the payment we have to make now? 4 lakhs only. Yes. Shortfall is minus, not minus 1 lakh. Oh, shortfall, excess, no. Surplus. Okay. Action is set on. For how many years? 4 years. This was 2021. 2022. 3 lakh we have surplus. Bonus is how much? Payment is how much? We'll make 4 lakh only. You know why? 4 lakh only. But how we'll pay 4 lakh? 3 lakh 2022. 1 lakh from 2021. Therefore, we don't have anything. Clear? Although we have shortfall of 1 lakh, but it will be set off. Clear? Even if I write here minus 1 lakh, it should be set off. Clear? Next, 2023. 6 lakh is a surplus. 4 lakh. Payment how much? 4 lakh plus 2 lakh. Set on for 4 years. 2024. 2 lakh 50,000. 4 lakh. Now here we have to pay 4 lakh. So what we'll do? 250 we'll pay from current year. Okay. Then last year we have 2 lakhs. 150 we'll pay from last year. Therefore we'll have shortfall how much? 50,000. Yes or no? This 50,000 will be set off. So like that, basically what is the set off and set on concept is nothing but only one. Whenever we make lean profits, we don't have strong profits. That time, whenever we had strong profits, we have to separate and keep it. Clear? Don't use it for anything else. You know why? Bonus is a mandatory payment. Clear? Whenever we have made very good profits, we'll save and keep for future purpose. Whenever we don't make enough profits, from this reserve only we'll take the money and pay the bonus. Clear? Napa? What doubt? Ask. Last year? Correct. Correct.
So we have access.
Yes. Okay, correct. Oh, sorry. Set on. Positive na set on, negative na set off. Loss is always set off. Profit always set on. Okay. I thought some big doubt you have. The way he looked at the board. Okay. Done na? So what is the logic here? Logic is I told you. Whenever we make good profits, we have to save and keep. Where we can use that whenever we have lean profits or when you don't have profits at all. Because bonus, minimum bonus we have to pay. Clear? To meet that criteria, we have to keep set on and set off concept. If this was not there, no, all the years wherever we make enough profits, we will be saving or no, we will be expending it. So whenever we don't have profits, obviously we will be paying now penalty on it because bonus is a mandatory and those will file a case on us, workers. Clear? So for them, every year we have to calculate at least how much we are supposed to pay. We'll keep that aside. Understood? Clear? Pakka? Okay? Right, sir. This is with respect to your set on and set off. Time limit. Within when should you pay? Within 8 months from the closure of accounting year. If you want, you can extend the period, but not exceeding 2 years. If it is a dispute, then obviously 1 month from the award. What do you mean by award? Order. 1 month from the order date. Okay. If there is a dispute at the higher rate, you have to minimum pay 8.33, and for the rest of the thing, you can go for the case. Clear? Imagine they are telling 15% have to pay. Okay. Now I am telling why 15% you have to pay 10%. There is a dispute. 8.33 you have to deposit. Clear? Deposit means what? You have to make the payment within 8 months to them. To whom? To the workers. Within 8 months you make the minimum payment. Only for the balance there is a dispute. Understood? Now, if they say 6%, you can't pay 6%. Minimum you have to pay 8.33. That much you have to pay. No matter what you do, 8.33 has to be paid. Clear? Understood? Right. Okay. Now, this is with respect to your payment of bonus. With that, code on wages is done. Clear?